ಕಂಪ್ಲೇ ಆಗಿದೆ ಮೇಡಮ್. ಕಂಪ್ಲೇ
Lord, one submission. Lord, so yesterday serial number 45 parted matter, we had made a mention to have it today at the top of the list. Lord, by inadvertence, my Lord, 44 had come up on top of the list, and the matter which was supposed to be come up as 40, top of the list has come as serial number 65. My Lordship,
What we can do now?
my Lordship may have it at 231st matter, my Lord, parted.
My
Page-wise
lord.
adjournment.
Memos to the court officer.
Page-wise adjournments. Page number 8, cell number 17, 18. Page number 9, cell number 19.
My lords, page number 6, I had mentioned to the court officer requesting an adjournment for serial number 10, my lords. The counsel on record is ill, therefore he is not able to make it up today. Page number 6, serial number 10, my lords.
Have you informed the other side?
They haven't appeared yet, my lords. I requested the court officer for an
They'll be waiting for you
adjournment.
in the court that you will make a mention. It is submitted, the counsel for the petition is unwell.
The respondent number 7, my lords.
Respondent number 7 is unwell. List this matter on 17th.
It's obliged.
Serial number 19,
Yes.
my lords, have approved the petitioner. The entire loan has been cleared. Am I audible, my lords?
Yes.
Serial number
Yes,
19, the entire loan is cleared. I'll file memo. Lordship gave me 2 days time. I'll file memo along with the document, my lords. I've informed the other side also.
List it on Thursday.
Grateful.
No, my clients are outstation. Lordship may have it on Monday, my lords.
No, you said 2 days.
No, because my clients are coming day after tomorrow. This way.
It's a matter on Monday.
Monday, before that, I'll file a memo along with the document. I will
The
close the
entire
loan.
loan is clear
Yes, ma'am.
and they'll come up with an appropriate application list on
Page
Monday.
number 10, cell number 20 to 23.
Much obliged.
Page number 11, 24 to 27. Page number 12, cell number 28 to 30. Page number 13, cell number 31 to 34. Page number 14, cell number 35 to 38. Page number 15, 39 to 45. Page number 16, 46 to 51. Page number 17, 52 to 56. Page number 18, cell number 57 to 62. All other parted.
All the rest.
List number 1, for parted matter, cell number 1.
Yesterday, it appears that serial number 44, they made a mention. Lordship directed the matter to be listed on the top of the list. Because when I was here at serial number 44, 230.
Where it gets listed is immaterial. Don't understand this.
I'll argue the matter, my lords. Because
Because it's very unfair that many times they have been waiting for this. Now it is listed, you can argue, what's the difficulty?
I'll argue the matter.
Yes, please argue. There are 5 writ petitions.
Lords, I will be arguing, my lords, firstly in WP number 7071 of 2025. But then I take your lordships to the other writ petitions.
Yes.
Lords, the challenge is to the orders, to the sale notice dated 11/12/2024.
Yes.
Lords, and the orders passed in the SA. Lords, principally there are 3 grounds which are raised. Firstly, my lords, the sale notice indicates that the total due is 3 crores 25 lakhs. Even according to the sale notice, the valuation of the property is 23 crores 50 lakhs. The first contention is that it would not be permissible for them to sell a property in excess of the property which is required for the debt to be recovered.
What was the loan that is taken?
3 crores.
But you have mortgaged the property of that.
Lords, what happens when I am mortgaging the property? This was under one single deed that I had purchased large extent of property. So that entire property I have given for a OD facility and I have taken the loan. But when it comes to the sale of the property, it would not be permissible for the bank to say that I will sell your entire extent of property as a secured asset. It should be sold only to the extent of property which is sufficient for the purpose of recovery of the debt. Lords, what happens is this: if your lords were to recollect, Lords, under the scheme of the Code of Civil Procedure, though there is a mandate, there is a similar provision even under the provisions of the SURFACE Act. Under Order 21 Rule 64, there are a series of judgments which came about which said that if this exercise is not undertaken, then the sale is rendered a nullity in the eye of law. Mahakal Automobiles case, it started, and thereafter there are 3 other judgments. Now, adopting the same principle, qua the secured assets, the Supreme Court has taken a view, Lords, that it would not be permissible to sell the entire extent. But the exception is, if this exercise is undertaken and it is not practical or it has failed, then it is permissible for them to undertake this exercise as one of the views taken. There are multiple judgments on the point which I will be citing before your lordships. This is the first ground on which we are challenging this.
Yes.
Second, my lords, valuation of this property, my lords, is abysmally low. This is a property which is, even according to the registration value which we have cited, is about 38 crores. They have valued it as 23.5 crores.
No, at the time when you have taken the loan, as per the valuation, what was the valuation that point of
That
time?
was in 2012 minutes. It's about 12, 13 years back. So that instruction, I will get it by the time, because that instruction, probably that's an information which the bank will be in a position to provide it.
The second ground.
This is the second ground. The third and important ground, my lord, says the sale notice is already spent itself. Because though the sale took place, only 25% of the amount was paid. The sale took place, my lords, on 8/1, on 7/1/2025.
The respondent is directed not to issue the sale certificate.
That is all. Up to the
Why will he pay the money without having the sale certificate?
my lords, it is simple as this. The stages under Rule 9495 is up to the stage of the sale certificate. After the entire money is paid, then the situation of issuance of sale certificate arises.
No, in view of the pending litigation and an interim order from this court, that can't be
The
a valid
Supreme Court
ground.
says, my lords, that this is mandatory. The period does not stop. There is no stopping of the clock. My lords, a coordinate bench is also dealt with this matter, where the coordinate bench says, if an auction purchaser is really interested in undertaking this exercise, he cannot keep 75% and say that I want the property. The course is to deposit 75% and say that please ensure that this is done. This is the view taken, my lords, by a coordinate bench. And it is referring, my lord, there are 2 judgments. One is the Supreme Court judgment in Senmugvelu's case. Other one, my lords, is Gurmurthy's case, which is by the division bench of this.
Probably those are the judgments which are coming when the auction purchaser is before the court and say, by paying 25% he is keeping quiet.
Lords-
Not in a case where the borrower is before the court and obtains a stay.
Lord,
In
stay
the-
is not there. That's the reason why I said.
No. on,
Lords,
on
no,
the 11th,
only issuance of sale certificate. I take your lordships to Rule 94 and 95. Lords, when the requirement is under the interim orders not to issue the sale certificate, essentially means that things up to the situation of sale certificate is required to be complied with.
Yes.
Lords, interim order, my lords, which has been granted, should not be read beyond what the interim order itself says.
Yes. These are the 3 grounds. Yes.
Get some water. Lords, this is the third ground. One more ground, my lords, I'll just point out. Lords, the other ground is single bidder. Malaise and single bidder is the other ground, my lords. The purchaser, auction purchaser, is owner of a building in which this bank is situated. He has let out one of the portions of his building for this bank, and this is one of the contentions which we have raised, that it's a single bidder without there being anything in the auction.
Push in the sale notice, by that time you're aware of who the single bidder and all.
We will not be aware.
That's what I'm saying.
We
When the
will not be
petition
aware.
is filed, that was not the ground.
No. Lords, we will not be aware, my lords, of any of these things.
No, that was not the ground for filing the writ petition.
Lords, that is now which we are, because this will come about only after they filed the statement of objection saying that it was a single bid we accepted. Otherwise, this is an information, as your lordship knows, my lord, this is borrowers will not be aware of the
No, that's why
proceedings.
I'm asking.
Yes,
No,
Lordship's
when you're
right.
saying a ground, I thought it must have not been in your knowledge to raise a ground on that.
And the other ground, my lord, says that Lordships passed an order and we have paid the entire amount. About 3.25 crores was what was required to be paid. 4 crores we have deposited before the bank. Bank is now issued an NOC saying that we have appropriated the entire 3 crore 25 lakhs. Another 75 crore lakhs also they have appropriated towards cost, charges and other expenses.
When was that order passed?
Not the same order, my lords, which your Lordships now read.
The respondent is, for the first order, no condition. Second order,
Give me the order.
38 crores and distress market value of the property.
18/3/2025.
23.5 crores.
Not the court order.
They are ready and willing to pay 4 crores to the bank. Handed over and is accepted by the bank. Outstanding is 3 crores.
325,
And what you paid is 4 crores.
4 crores.
Yes. Now you are relying on some judgments with regard to that the entire property cannot be sold.
That there are judgments to that effect. Just one point, my lords, can I just take your Lordships, my lords, to just 2 dates.
Yes.
Lords, the auction notice contemplates the auction sale to take place on 7/1/20 7/1/2025.
Yes.
Lords, then the confirmation of sale according to the statement of objections is on, when is it? Is on 8/1/2025. That's what has been stated.
Yes.
Just kindly permit. My apologies. 18/3/2025 is the date of the order. It's under which this honorable court said permitted to deposit this 4 crores.
Before that, 10/3/2025 is the date where sale certificate was directed not to issue the sale certificate.
Yes, my lords. 10/3/2025.
Yes.
10/3, na? Date of order is 18/3, yeah? Just check. Give me
This
the
date
order.
of order is 18/3.
18/3, my lords.
First order was on 10/3.
No, 10/3
where
there
the
is
sale
no-
certificate was directed not to be issued. Then 18/3 was a conditional order.
Lords, 10/3, yes, 10/3 not directed not to issue sale certificate and thereafterwards. Now, if your
18/3
lordships
order.
were to see section rule 9(5), my lords.
Surface.
Yes.
Yes.
Rule 9(4) and 9(5).
Yes.
The balance amount of purchaser payable shall be paid by the purchaser to the authorized officer on or before 15th day of confirmation of sale of the immobile property or such extended period as may be agreed upon in writing between the purchaser and the secured creditor, in any case not exceeding 3 months. Lords, I have gone through the statement of objections. 15 days lapsed.
In all these reality matters, if we have to look at these rules in the manner in which we are proceeding with, and I think not even one matter can be entertained.
Lords, these provisions.
Provisions like where the bank is following, where it is applied in its strict sense. Bank in one case, bank will remember 8 or this 9(5). In some other case, they will cancel the auction and give it to the auction purchaser. So it's like, it's
Lords,
all,
but
now
there-
it is all upon what the bank thinks.
That's true,
Whatever
my
is
lords. It
the-
should not, that is the reason. The first of the judgment is Matthew Varghese, which said, Madia Chemicals itself said, these are all the statutory safeguards and the bank has to act as a trustee. Matthew Varghese said that these procedures are meant for the purpose of safeguarding the interest of the borrowers, interpreted in the favor of the
Now,
borrowers.
when the property, when the order is passed under 14 and this property was taken fiscal portion, what follows is the auction.
Let's,
When was that
physical
section
possession-
14 order?
No, they have not taken any physical possession in this matter.
No order under section 14.
No order under section 14. At least that's not what is under challenge.
Yes, this is one ground, that they have not deposited, the auction purchaser has not deposited the money.
Within 15 days.
15 days as per rule 9.
Because if 90 days is only where there is an agreement in writing between them for extension of this period. Interim order comes about only on 10/3. 7/1 to 23/1, 15 days expires. So therefore, my lords, my respectful submission is that even before the interim order having been granted prior to this date, issuance of sale certificate, the period prescribed had already expired and there is no agreement for extension. That's the statement of objections filed because this is a ground which you have raised. This is number 1. Now 9(5), my lords.
Yes.
In default of payment, this is essentially what is required to be done by the bank now. In default of payment within the period mentioned in sub-rule 4,
Yes.
deposit shall be forfeited to the secured creditor and the property shall be resold and the defaulting purchaser shall forfeit all claims to the property or to any part of the sum which it may subsequently be sold. Then on confirmation of sale of the secured creditor in terms of the payment have been complied with, authorized officer exercising powers shall issue sale certificate. Notes, the reason why I am referring to sub-rule 6 is that 9(4) is second milestone. 9(3) is the first milestone. 9(4) is the second milestone. After 9(4) is complied with, then comes the question about issuance of the sale certificate.
So as per this 9(5), the bank has a power to extend it by 3 months.
Yes,
Still, for the outer limit of 3 months.
outer limit of 3 months.
So the auction confirmed on 8/1. The 3 months will complete by 9/3,
Yes,
2025. And 10/3/2025.
9(4) minutes, it will be 4.
9/4. So the interim order is on 10/3.
Lord's interim order is in terms of rule 9(6). It did not prevent what's to be done between 9(3) and 9(4).
But practically what happens is, court gives an order, we see cases and cases where for years together, on a stay, why should the auction purchaser pay the money and just keep waiting for the
Lords, now
court cases to be
I understand this,
decided?
Lords. In the event, if for any reason, if 15 days was lapsing, even before an interim order is granted, there is an obligation that there is a period which is to be extended upon an agreement, which should be in writing. If this embargo is not crossed, the question of saying that there is an interim order would not arise. I understand, my lords, your lords would say there is a practicality, but the legality, my lords, of the manner in which the transaction has to take place in terms of 9(3), 9(4), 9(5),
No,
9(6).
that is after you file the writ petition. Now we are on the grounds which made you to come before the court and the judgments in support of your case that they cannot sell this property, that you can submit.
Lords, the reason why I am submitting this is auction purchaser is out. Auction purchaser's money is already deemed to have been forfeited. Shanmugh Velu's case on the division bench says that it is deemed to have been forfeited. Lords, if the interim order is only for issuance of not to issue the sale certificate, that is the step which is required to be taken in terms of rule 9(6). What is required in terms of rule 9(5) is not, Lords, usually your lordships is aware, Lords. There can be 2 types of orders. One, after the auction takes place, there can be a direction to not to confirm the sale, in which event there is no necessity for depositing the balance amount, because it is only upon confirmation of the sale that the balance amount is required to be paid. If confirmation of sale itself is not stayed, then the next step, will be that they will have to pay the money and then they will have to ask for the dismissal of this writ petition.
No, I understand your contention. What I am saying is, that would be your alternative argument. The first is,
Yes.
you have come to the court. So,
Yes, my lords.
So what are the grounds? First of all, you have to maintain your writ petition. Then we'll go to the legality of the sale.
Lords, this legality of the sale, the reason why I made this submission is,
We will go into that. first submission is with regard to why the auction sale notice is bad, you have
Hey,
said so.
just refer to
About
this
that,
judge.
that we will
Give
see.
me the judge, please, confirmation. Ramkrishnan, please. Captain. Mark this. Yeah. 72. Page number 72 minutes.
Yes.
Can I just read the provision before I take your lordships to the judgment? That's section 13(4).
Yes. 34 or
13(4) minutes of the surface.
13(4), yes.
13(4).
Yes.
In case the borrower fails to discharge this liability in full within the period specified in subsection 2, secured creditor may take recourse to one or following of the measures to recover the debt due. Take possession of the secured assets of the borrower, including the right to transfer by of lease assignment, take over the management, appoint a person to secure the assets, require at any time notice who has acquired any secured assets from the borrower, so and so, any payment made, so and so. Not then, if your lordships were to take turn to Rule 8(5).
Yes.
Before effecting sale.
Yes. Yes.
Before effecting sale of the immovable property referred to in sub-rule 1 of Rule 9, authorized officer shall obtain valuation of the property from an approved valuer and in consultation with the secured creditor, fix the reserve price of the property and, lordships may kindly mark the next phrase, may sell the whole or any part of such immovable asset, secured asset by any of the following methods. That's 1, 2, 3, 4, 5.
Yes. By obtaining the quotation.
So statutorily, there is a requirement, Milords, that they will have to assess whether it is required to sell the whole or part of such immovable property, which is the secured asset. This is contained in the code itself. That is in the comprehensively whatever the code provides for bringing the property to auction. Then the bank is required to find out whether this is done, which could be done or not. If it is not done, what happens is what I am required to answer, Milords. Lordships may kindly take page number 72.
Yes.
Notes para 13 deals with recovery of public dues. Para 13 and onwards. Then para 18 to 22 deals with valuation and the reserve price, how it is fixed. This I will be referring to, Milords, for the second ground. Valuation is not proper. Then 3, decision to sell whole or part of the secured assets. In Ambati Narsaya M. Subrao, this court dealt with a case wherein execution.
I will read 23 and 24. Whichever paragraph you want me to read, I'll read it so that you will get rest to your throat.
I'm so grateful, Milords. Para 23 and 24.
Yes, I'll read. Yes.
And para 33. Para 31, 30, 33.
31 also.
No, 33 minutes. No, I will have to.
Yes. Yes. Then,
What's then? Page 86 minutes is the judgment rendered with reference to the sales other than the court sales. Essentially, the revenue sales, etc. The Supreme Court says that it is not necessary to demonstrate the prejudice. If the statutory provisions are provided for and it is violated, that itself is sufficient because these statutory provisions are designed in a manner that this itself constitutes a safeguard. If there is any breach, it is not necessary for me to come and show prejudice as though it is required under Order 21, Rule 90 in respect of court sales.
paragraph.
What's in this? In this paragraph number 61, paragraph 51 and 61. And if your lordships were to see, my lords, on the facts of this case, similar to what transpired here is what is contained in para 87.
Then the after 61, which paragraph?
87, my lords. You got 11 paras. It's mandatory.
Yes. Then,
Lords, these are the two judgments, my lords, which is being relied upon so far as the first contention is concerned. That if there is any breach of the statutory rule, Lords, now I just wanted to elaborate a little bit on this. Lords, a person gets into distress. This is what was decided, my lords, in Deshbandhu Gupta's case. By means of, it is not that we have not paid the interest. We borrowed the money in 2012, OD facility. We have been servicing this 2021. Everybody got into trouble because of the pandemic. So we committed default. We have paid the interest and serviced the interest. It is not that I am a fly-by-night person. We have serviced the interest. And they have given me this, not the only loan. There were other loans which were given, I have discharged. So not somebody who is like, I am running away from anything. Lords, I am now in distress. There is only one property which I am having. I have mortgaged this property to the bank. Now, if a person is in distress, the requirement is you should ensure that I am not put into further distress than what is required to be undertaken by me legally. Lords, these kind of actions by the bank, if it is to be upheld, my lords, because the property is sold at distress value, everybody knows it's a common knowledge. It is never sold at the market price. The valuation report itself will say that valuation is 30 crores. 30 crores. We have the registration value is 19 crores, 20 crores. Distress value of sale is 23 crores. That will be the reserve price. And this essentially means that property will never be sold on the market value. Not see if this is the scenario with which we are placed, the bank should then act as a trustee. That is when Matthew Varghese case comes into picture. There is an obligation. The first of the judgments which was rendered in Madia Chemical said that bank should act as a trustee of my property. They should treat this as though it is their own property. If let us assume bank is in distress and they want to offload 3.5 crores, 4 crore rupees, will the bank offload the entire property of 40 crores into 23 crores? I can understand. My property of 5 crores, they are selling it at 3.5 crores, I can understand. My property of 50 crores, they want to offload it at 23.5 crores. This is the solemn duty which is cast on the bank. The bank cannot act like a property dealer. That's what the Supreme Court says. This is essentially what the bank is doing in respect of the SARFAESI proceedings. Let's see if there is any due, because I understand the law is there. The moment I default for 90 days, my account gets into NPA. Once it gets into NPA, the procedure under the SARFAESI Act steps in. If this is what has been my conduct for all these years, and bank otherwise legally obliged to be a trustee, cannot undertake an exercise of this kind. You have produced Deshbandhu. Lords, can I just refer to Matthew Varghese case and Subramaniam's case? Madia is extracted in this. First judgment, my lords, in page number 1.
Yes. Paragraph.
Paragraph number 29.
Yes.
29.3. Sorry, minutes. Only on the proposition he is a trustee, minutes. If such a power, drastic power is so vested in the banks, the authorized officers, it doesn't have any adjudicatory mechanisms of any kind whatsoever. And Supreme Court felt that these are the kind of cases, it is more a substitute trust. They are the deemed trustees of my property when they take it over. And if it is their own property, if it is their own trust property, will they deal with my property in this fashion? Milords, is essentially the question. My respectful submission is, this is where Wednesbury reasonableness or the proportionality comes in, where any authority exercises power under a statute. It has to pass through the muster of either Wednesbury reasonableness, that no reasonable person would have done this kind of things in the reasonable circumstances, or the doctrine of proportionality, that there cannot be a disproportionate action for a proportionate default. So either of the ways, Milords, my respectful submission is that this is an exercise which they ought not to have entertained, is my first submission. Second contention is regarding the sale notice. Not sale notice is fixing the sale on 7/1. Statement of objection says that on 8/1 they have confirmed the sale. There is nothing in the pleadings to indicate that there was any agreement in writing between the borrower and between the auction purchaser and the secured creditor.
Point is clear, that I understood.
Yes. For that, Milords, I just want to refer to two judgments.
Yeah.
42 is Rajiv Subramaniam's case. Milords, para 13. It's in
Para 13.
13:13.
Yes.
And para 15 is important. Para 13 is regarding the right, being a right to property under Article 300A. Matthew Varghese also examined 8 and 9. On a detailed analysis of 8 and 9(1), it has been held that sale effected without complying with the same would be unconstitutional and therefore null and void. at any step whatsoever. Rule 8 and 9 put together. Then Vasu P. Shetty, my lords, at page 52.
Which paragraph in that?
Lords, para 23. At page 69. Para 23, 24 and 25.
Yes.
It's particularly the question is that even if a person is in default at page 70 placitum A, likewise after the second auction when the bank requested the borrower to accept the bid of 2.25 crores, giving its reasons and the borrower instead of doing so took initiative resulting in OTS, but defaulted therein, it would merely indicate that the borrower was at fault in not adhering to OTS. By no logic can it be deduced therefrom that the bank was relieved of its obligation not to follow the mandatory procedure contained in the rules while taking fresh steps for disposal of the property. The moot question is even if there were delay tactics adopted by the borrower. Notes this is where it says, and then it reiterates the principle in para 25 of Matthew Verghese. Because an argument was advanced saying that if you are a defaulter, you cannot come and say that there is an aberration of the statutory mandate. That was not accepted by the court, Supreme Court.
Yes.
This was a sale was set aside under Article 226.
Yes.
Yes. What is that? You produced it. Huh? There's one more judgment, Lords. Leelama Matthew, civil appeal number 7128 of 2022. Lords, of course, it is not as directly on the point as Ramkishan's case, which I referred to in the first instance. But this para 5.4 of this judgment says that what is contained in terms of Rule 8.5.
Where is the judgment?
Lords, I'm just passing. That's not a part of that. I'll give a copy. Take it later and then.
Yes. Which para?
Para 5.4. The sale was set aside for not adhering to Rule 5.4. That's.
Yes.
Not then on the principle regarding Rule 9.4 and 9.5. Lords, I'm relying on the judgment of the Supreme Court in Shanmugh Velu's case, page 137 of the compilation.
Which paragraph?
I'll just point out notes. Shanmugh Velu's case, what's the paragraph? Not marked it in this 134. Notes paragraph number. I have to get the paragraph numbers here. I'll just point out the paragraph numbers. Notes. If your lordships were to take page 136.
Yes.
High Court in its impugned order resorted to page 136, starting from this line.
Yes. 136 head notes.
Yes, my lords. I'll just mark the relevant paragraphs and give it.
You're relying on this judgment for what purpose?
Lords, I am just unable to place my hands readily, my lords, on the relevant paragraphs. I'll just give it. 9.5 cannot be read down. 9.5 is mandatory. That's essentially on the point that rule 9.5 of the rules is mandatory. Forfeiture is automatic. There is no necessity of even passing an order by the bank. Once that 15 days period expires, and if there is no extension, there is no necessity for the bank to pass any further orders. The Supreme Court says it's a deeming provision. It is deemed to have been forfeited. There is no necessity that the
time has come that the Reserve Bank should look into all this, how what the banks are doing.
Yes. Lords, there are instances where the banks are taking money even after 90 days and doing this. But statute does not permit.
Where the banks are taking money from the principal borrower, money from the auction purchaser.
Both of them. Lords, now what happens?
And if they want to, cancel the auction, they will cancel the auction. If they do not want to cancel the auction, then they will come up with the redemption of mortgage not permissible. Why are you taking the money?
I think this is an issue which was answered. Of course, Cellular LLP is already referred before Lordships in many cases. This issue was answered in Cellular LLP. The distinction which the Supreme Court has drawn is, if money is paid by the auction purchaser and then he seeks for sale certificate, then 13.8 is not applicable. The right to seek for the redemption is lost. Though it is from the date on which the paper publication comes about. This is one other issue
the sale notice itself.
Sale notice itself lapses because, something like this. Supreme Court also dealt with this issue. Of course, I'll just digress on that, and I'll just give that judgment also. Cellular LLP was a case where the auction purchaser deposited the money. At that stage, the bank accepted the money from the borrower and said that we don't want to pursue, and they wanted to refund the money. Auction purchaser went before the court. So the court said the moment the sale is concluded by depositing of the entire money, it would not be permissible for the bank to undertake this exercise. The only exception which the court found was wherever the sale is either set at naught or the auction notice itself becomes redundant because of either non-payment of money or whatever reason, then we go back to the stage of 13.8. Because 13.8 says, on the date when the paper publication comes about, the right to redemption is lost. Now let us assume a situation that paper publication is made. I will not have a right to redemption. That is what sale does not take place. Then they have to re-notify for the sale. Again, they have to go for a paper publication. In between this period, if I tender the entire amount, that's what Cellular LLP said. If the sale notice is itself, then it is still permissible to undertake this exercise. I come within the second criteria because 7.1, 15 days expired on 23rd, even excluding 7th. 23rd, the 23.1, 15 days expired. Statement of objections doesn't indicate that this is what they have done or this is their understanding why they have not paid the money. I can understand if they have said it. The moment that happens, that sale notice vanishes. Then my right of redemption revives. 13.8 again revives. And in such circumstance, the money has already been paid. I have completely cleared the dues. As against 3.25 millions, I have already paid 4 crores. That the bank, of course, is to give the accounts how they have adjusted this 4 crores. And they have given me an endorsement saying that we have adjusted entire 4 crores towards your dues, charges, interest, etc.
Then what happened to the 23 crores?
No, it's not deposited. Only 25% is deposited.
We'll ask. Yes.
So,
in reply, you can cite the judgment. Yes.
Just one more judgment, minutes of a coordinate bench. I wanted to point out it is page 229.
Yes. Yes.
It's paragraph number 2.
Yes.
Page 231.
Mm.
Para 2 is the facts of that case, and then para 4, my lords, the court extracts
Mm.
the rules, and para 5. These rules stroke terms require the auction purchaser to deposit 25% of the sale price offered on the same day. If the rule requires the remaining amount subject to agreement in writing in the secured creditor to be paid within 15 days, but not later than 3 months from the date of auction, the aforesaid terms contemplate not only 15 days. Apex Court in the case of Natarajan, while holding the rules are validly made in the statute as a point that is in the matter of course interfering the secured creditors to forfeit the incomplete price offered. Then para 6, this court must opine the petitioner cannot succeed in this petition because petitioner having participated in the auction, being aware of the consequences and being put on notice thereof, should have offered the entire sale price. If there was any default by the first respondent in delivering possession or otherwise in complying with the terms of the sale requirement, this is clause B.
Yes,
Petitioner should have
I've seen
availed the remedies in law to operate after tendering the full value.
I've seen this. I've seen
So that's,
Yes.
then one more judgment minutes of the division bench on the same lines is the previous judgment
Mm.
at page number 208.
Yes.
Para 5.5 minutes at page 222. Para 5.3 and 5.5.
Yes.
Then ultimately, minutes, it has taken the view that 9.5 is mandatory and the process of forfeiture is an automatic process. It's a deemed process. Para 6.1 is the conclusion. This is what I just read it, minutes. In the light of law laid down by the Supreme Court in Shanmugh Velu, there is no escape from the position of the law that 9.5 of the rules providing for forfeiture of the earnest money is mandatory application 1. Once the auction purchase is unable to pay the balance amount sale consideration within the statutory time limit contemplated for the purpose. 9.5 has the compulsory consequence of forfeiture of the earnest money in the event of commission of default by the auction purchaser. So their amount has to be forfeited mandatorily is what the Supreme Court says, but I'm relying upon this only to show, my lords, that the sale notice goes because of this.
Yes.
Yavudidu? One more judgment, my lords, of a coordinate bench. No, it's a Delhi High Court judgment, my lords. I just cite this. Court officer.
Yes.
Copy ಕೊಡು ನಾನು. ಇದೆ ನೋಡಿ. ಇನ್ನೊಂದು ಕೊಡ್ಬೇಕು ಆಯ್ತು. ಆಯ್ತು. That's paragraph number 19.
Yes.
Para 17 minutes, and that's what, of course, the essentially elaboration of what is the duty of a trustee. Para 18, these days the attempt is to ensure that business entity is not pushed into liquidation to this intent, so on. So then para 19, when the collaterals and securities are provided by the borrowers,
Yes.
so. Because the division bench view is again not referring to the division bench, but another coordinate bench, referring to the judgment in Shanmugh Velu's case and Natarajan's case, which I have already referred before, Lordships. Again says that this is a mandatory procedure and the forfeiture is automatic.
I think for the same proposition, these many
I'll
judgments
not,
are not.
I'm sorry, Minutes,
Yes.
it's not.
I think we'll hear the senior counsel. Yes.
Lords. Just prepared on convenience compilation, the lots of documents, I'll just refer. They have it's all part of the writs, my lords. Oh, my lords, the sale was on 8/1/2025.
7 months.
It's a confirmation.
Confirmation. Oh, please come to page. The DRT order, just to show, my lords, that there was always an order of temporary order.
Page
The lordship kindly come to page 30 in that. my lords.
An order before DRT.
Yes.
In their essay. That's an order dated 9/1/2025.
20?
Lords, running page 30. my lords. It's a chart, kind of a chart, sorry.
You can see.
It's an order dated 9th of January 2025, passed
It
by,
is an essay number.
in the current essay number,
16 of 25. Sir.
16 of 25. That's the essay which they had filed,
And it is under challenge.
They have filed questioning
questioning the sale notice. Questioning the sale notice. That's the order which is currently under challenge before my lords. The essay order, instead of going to DRAT, they have straight away come here. In that on 9th, 8th was the confirmation. 9th, my lords, please see the last para. In the meanwhile, it is hoped that the respondent bank will not take steps for issuance of sale certificate till filing of objections by the respondent bank or till next date of hearing.
This was passed on 9th.
9th of January. So that continues. And then ultimately
When was the final order passed?
the final order, my lords,
Next page it was
28.
discontinued. The interim order was not extended.
I did not interfere.
Yes,
28/2.
28/2. Let's see that order once,
Yes.
the 28/2 order.
Patient page 46.
28, the impugned order, my lords. The lordship should get us page.
46. Sorry. sir.
Annexure F at page 46. ನೀನು ಅವಸರ ಮಾಡಿದ್ರೆ ನನ್ಗೆ ಇಲ್ಲಿ ಇದಾಗುತ್ತೆ. Page 46 in the writ petition.
Yes.
Essentially, the grounds taken there was the valuation is not correct. Guidelines value and the sale value is not correct.
What was the
And-
finding?
Towards the findings, your lordship should get issue starts from page 50 onwards. Issue frame. And the answer starts from 57, para 7 at page 50. Where they say when it was classified as an NPA and declaration of NPA, there is no error is at page 51, para 8. Then the other one was on exorbitant rate of interest being claimed by the bank. That contention is answered at para 10 at page 51. Then, my lords, at para 12, one of the grounds taken was that they have been approaching the bank for regularization and bank was not doing anything. That is also answered. Now, please come to para 14 at page 53
Yes.
about restructuring and alleged payment of 58 lakhs, which they claimed that they had paid the bank. The DRT says not even a single document is produced by them.
Yes.
Now, valuation, my lords, para 16 at page 55. They are also
Let's read this paragraph.
16, my lord. Yes. According to the applicants, the authorized officer of the defendant bank issued annexure A2 sale notice dated 1/7/2024 fixing the sale of the scheduled property on 22/7/2024 and issued A6 sale notice dated 12/9/2024 fixing the reserve price of the scheduled property at 20 crores when the guideline value of SRO itself is 38 crores 40 lakhs 35,380, proposing the sale of the same on 30/9/2024 for recovery of sum of 3 crores 41 lakhs 15,400, whereas the actual market value of the same is more than 60 crores. It may be noted that except contending on the reserve price fixed by the defendant bank in the aforesaid sale notices, applicants have not produced any proof before this tribunal to prove that the market value of the scheduled property would come to a sum of rupees 60 crores. It may also be noted that the guidelines value fixed by the revenue department of a government is for the purpose of registration of the sale deed of an immovable property, and it has nothing to do when a sale is with a sale conducted in operation of law. Also, the contention of low reserve price is not a sufficient reason to set aside a sale took place in accordance with law unless and until some material irregularity is conducted in conducting such sale is proved before this tribunal. It is also contention of appellants that the defendant bank issued a sale notice dated 11/12/2024 fixing the reserve price at 23.50 lakhs, and though the same was published in the newspaper on 13/12/2024 as per Annexure A11, same also was not served upon them and also not affixed in accordance with law. But according to defendant bank, as they failed to discharge the debt due, that the authorized officer of defendant bank issued Annexure B7 possession notice dated 22/2/2024 under section 13(4) of the Act, taking symbolic possession of this scheduled immovable property, and thereafter he issued the sale notices Annexures B15 to 17 respectively dated 24/4/24, 17/24 and 12/9/24 for sale of the immovable property which was not fructified for want of bidders. It is a case of the defendant that in the meantime applicants filed Annexure B18 affidavit dated, please mark this, my lords, affidavit dated 28/12/10/24 before the Honorable High Court of Karnataka, undertaking to close the account within 1 month, failing which permitting it to proceed with for the sale of the scheduled immovable property in accordance with law, and as they did not honor their words, its authorized officer issued Annexure B19 sale notice dated 11/12/24 proposing the sale of immovable property on 7/1/25, and thus scheduled property was sold on 7/1/2025 for a sale consideration of 2,351 lakhs as against the reserve price of 2,350 lakhs. Then the sale notices, my lords, are mentioned, the copies. Now, my lords, regarding the divisibility at para
I
19,
have seen that, I have seen.
it is considered.
So what is your submission on that aspect? When the outstanding loan is 3.5.
My lords, it is for the bank, that is considered by DRT and says, bank considers it cannot be divided. Now, whatever judgments my learned friend is referring to is in relation to revenue sales, my lords, not particularly, my lords, those are all auction sales or sales which take place under CPC. Here, this is a sale which has taken place not once.
Even the rule is also clear. You have.
Yes, my lords, I will only submit this. Now, my lords, can your lordship kindly come to the undertaking affidavit which they had filed? Please come to in my compilation, my lords, at page 25.
Just now you passed on.
Yes, my lords, convenience compilation.
Yes. Page number?
Running page 25, my lords. This was in the, those writs are there now. These are writs which are still pending, connected matters, my lords. This is the undertaking affidavit filed by the petitioner. Please see, when the, lords, this is a third attempt made to sell the property. Whenever a sale notice is issued, writ is filed, saying that I will deposit the money. And then please see the undertaking, para 3 and para 4. I submit, I undertake to close the loan within 1 month as my loan process will be completed in a month. I submit if the amount as undertaking
This is given in WP.
Lord, WP, there are all connected 27762 of 2024 and connected matters.
These many petitions are pending now.
Every time Lord, sale notice is issued, one writ. And that writ is connected. It's connected today, it's listed before my lords.
Which one?
This particular writ 27762.
Is there?
Yes.
Oh, all are there.
All are
five
there.
Yes.
So he gives an undertaking that if I don't deposit, I will not object for possession being taken. I will not object for sale being taken. Now, my lords, every time this is when, my lord, the sale takes place. And was this contention even raised before the DRT? Now, my lord, DRT considers and says divisibility is an issue. Yes, bank felt it appropriate to sell the property because they don't find it is divisible. The property cannot be divided is the bank's opinion. Now, my lords, what happens
Before coming to such conclusion, what was the exercise done by the bank?
The bank has to answer.
Anything is there on record to say that such exercise is done by the bank?
There exists in house property also, my lord.
Huh?
Building is also there, my lord.
It is a building.
Building is also there, my lord. Hence it cannot be divided.
3 survey numbers.
What is the scheduled property? Let us see.
My
Where
lord,
is
sir.
the auction notice?
The auction notice your lordship should get.
Our valuation, Akira.
Valuation I'll take. My learned friend wants to show on the valuation, I'll answer that and take. Lord's auction notice, your lordship may kindly come to page 22.
22.
Running page 22 is this.
Complete.
At 23, your lordship should get the description.
Parcel of residential converted land property,
Yes.
3.725 acres, 10 guntas. A house is there in the part of the land.
60-40. Out of 3 acres, 29 kuntas.
No, my lords, the valuation report of the bank is placed on record already because one of the contentions taken here, though he does not produce any valuation report before the DRT, he comes here and the my lords contends that the property is worth 60 crores and he mentions about the valuation report. Now I'll take your lordships to the valuation report which he has filed first and the bank's valuation report. The petitioner's valuation report, your lordships would get at page 27, annexure D in the writ petition. This is their valuation report. My lords, this is dated 25th of January 2024. Now, my lords, all other aspects, it's a vacant land converted for residential use is shown. Now, please come to the valuation at running page number 33, my lords, that's
Guideline value for the land,
Yes, my lords.
38 crores.
prevailing market value and guideline value. And please see what the valuer says is 25,300 per square meter or 2,350 per square feet for converted sites in KEB layout. And he says note guideline value is only for stamp duty calculation. It is not related with the fair market value. Then he gives, based on the same notification, guideline value for land, how he calculates fair market value and the thing. Now, my lords, this he refers to a notification of the government, valuation notification. Now, my lords, we have produced the valuation report obtained by the bank. There are two things under the government's valuation. One is, my lords, converted, non-developed.
Yes.
The other aspect is converted and developed. What his valuer does is, he treats it as if sites are formed in the land. Whereas the bank's valuation, my lords, your lordships, I kindly see a memo was filed on 8/4/25 with the valuation. Is it with the, anyway, it's in the compilation, my lords. I'm sorry, it's in the compilation, convenience compilation.
Page number.
My lords, the valuation report, your lordships would get at page 3, my lords.
Yes.
This is a bank's valuation.
Yes. It says how much?
Please come to, my lords, page 9, running page 9, value of land. Your lordships would get A on top, guideline rate, sub-register rate. Your lordships have that. Please see, 257 lakhs per acre for agricultural land, add 65% for residential conversion, rupees 424.05 lakhs per acre or rupees 973.49 per square feet. Yalanka SRO, that's a guidelines value he takes. Value of the land as per guidelines rate, sub-register rate, 1,62,261 per square feet at rupees 973.49 per square feet, which will equal to 15 crores. Present realizable market value for the land as per the rate under C, 22 crores 63 lakhs 54,995 rupees. The subject property is a larger extent of land. It is irregular in shape and it is undeveloped, residentially converted vacant land. Land value depends on location, level of the ground, shape of land, extent of ground abut.
It is undeveloped, converted land.
Converted land. He takes it as converted land. Now, my lords, the difference we have made out, if your lordship kindly come to page 28. Guideline value, my lords, we have, for the purpose of convenience, what they say and what bank's valuer takes is set out here, my lords. Please see, as per valuation, as per the guidelines valuation itself, what the bank has done is the correct valuation. Please see the valuation as per bank. We have given the articles also. Under the notification also we have enclosed so that there is no dispute because all the valuers are relying on the same notification. It comes to residential undeveloped land value. Now to say petitioner's valuation goes into 70, not naturally they will value it at 70 crores. 70 crores they will value, but they had a chance 3 occasions. They come before the court every occasion and say, we will pay, we'll pay, we'll pay. It is not paid. My learned friend's other argument was that I did not deposit 75%. I showed your lordships the DRT order, which said, don't do anything. Thereafter, my lords, what is missed out is...
At the order, according, as per his submission, it is both this court and the DRT was saying about the sale certificate.
Sale certificate, all right, I'll admit.
Whatever is a sale certificate, this, the payment of the.
I should have done it is his contention. Now, my lords, another thing is, bank could have anyway, if I had gone to the bank, bank could have had the power to extend it for 90 days, which expires in April 2025. Please see the order dated 18/3/2025 passed by this honorable court, interim order. No, in
4
that,
lakhs, 4 crores amount was.
yes, but before that, please see what happens in that very same order, my lords. That's an offer he makes. The court does not direct him to deposit 4 crores. I'm sorry, the interim order, my lords, 18/3. Just above that, learned senior counsel at this juncture submits they are ready and willing to pay 4 crores. Above that, in terms of the figure quoted herein above, I deem it appropriate to stall all further proceedings pursuant to auction. So even before 90 days is over, the auction proceedings itself have been stayed by this honorable court. Only on what ground? Please see the ground which is recorded and above. That's only on the valuation. Today, my learned friend is bringing all, that's these facts, whether valuation is correct or not, DRT considers. Now, the other issue, his right of redemption, my lords, right or wrong, is till the date of issuance of sale notice. PHR invents seller, my lords.
But for any reason, the auction sale itself is set aside by the.
Then, my lords, he had a chance.
The question of
Then
redemption will come. But now, in all this, whatever submitted by you and the senior counsel, the issue that which the court wants to know from the bank is about the divisibility of this property.
My lords, I would.
That was done or not? Why you have not done? For an amount of 4 crores or 3 crores and odd, why should you put a property worth 23 crores according to you to sale?
Lords, before the bank assessed can, there were 2 prior sale notices, my lords. That is, my lords, the first sale notice came about on 7/7/2024.
Whether the bank really follows the rules as laid down in the
securitization
consultation to the secured with the secured creditor, do you fix the market value?
Yes, ma'am.
Was it done?
Yes, ma'am, it was done, ma'am. And the most.
Where are your objections?
My lord, I filed.
When did you file your objection?
Filed my synopsis, my lord, at on 22/4/2025. 22/4/2025, my lord.
Lords, only one, may I just answer that only.
Yes.
1/7/24 was the first sale notice. The second notice, sale notice was on 12th of September 2024. Then the third sale notice is the current sale notice. In all these sale notices, property remained the same. The borrower, my lords, came before this court in a batch of writ petitions which are connected.
No, ultimately, for all this litigation and all, what he has to bear, that's a different aspect. Now, coming to the legality, can the banks be permitted to act in this manner?
Yes,
No,
the
it is
DRT
like
says.
5 times, 10 times the property, like more than the the property worth.
Well,
And it's a land, it's a vacant land, definitely it is divisible. Can be
Lords,
divided.
Even that, my lords, the valuation report says
That
approach road. My lords, somebody has to have the approach road also.
For that, there should be
They,
something
they,
from
they
the
will
bank
answer, probably they'll answer.
to do it. And to say, but it can't be, divided. For
Divided.
that reason, we are selling it. A
The
bank should
DRT
be fair to
answers
the-
that. DRT
Yes.
answers that.
But DRT assumes, as far as that aspect is, it just assumes that is not, burden is not on them, burden is on the bank.
Bank. My lords, I will only say this, even against the DRT order, there is an appeal provided. Otherwise, my lords, we are bypassing the appeal route itself.
What is happening is in all these matters, Interim orders.
No,
are
I'll
granted.
only-
No, not on that. Interim order is granted. The matter will be pending here for 2 years, 3 years. Then at this point of time, if the court says you have an alternate remedy.
Lords,
then we
that's
will-
why I'm not pressing too hard on the alternate remedy.
2 years, the
Lords,
delays that are
Lords,
happening.
that's why
before
I'm
the
not
court.
pressing on the alternate remedy. I'm only saying he raised an issue on valuation. Valuation was answered.
I am convinced on the aspect with regard to this, the auction purchaser depositing the amount and all, that's not an issue. Now, the only issue that needs to be clarified is with regard to this. Why did you put the property of 23 crores according to you for a realization of an outstanding of 3.5 crores? What was the exercise done by the bank? And whatever is the exercise that has to be placed on record? You can't just like that say in your, what do you call, in your objection saying that as it is not feasible. How is this not feasible? What was the exercise done by you?
My lord, my
If,
submission is
if an approach is required, you can as well as the secured creditor that because for the approach I require this also will be taken or something like that.
my lord, my submission is that, my lord, there exists a building, my lord, 2 floors are there.
Yes.
And apart from that, my lord, there should be
Entire extent of land is 4 acres or 5 acres?
3 acres, my lord.
3 acres land.
3 acres.
3 acres, entire 3 acres, 2 floors building will not be there. Probably it may be there in 2000
Apart
square
from
yards
that,
or
my lord,
so.
there should be, see, this property is having one single kata, my lord.
One single.
One single kata.
Uh,
So without having the bifurcated kata, it cannot be sold, my lord.
uh,
That is my submission, my lord.
uh.
So hence it has been, full property has been taken into consideration. And on top of it, my lord,
It is not the oral submissions, Mr. Counsel. I want to know what was done by the bank. Because the banks cannot be
my
permitted
lord, in the
to
valuation report,
work
it
in
has been
this
taken
manner.
into consideration. Valuation report, it has been shown, my lord. Valuation report, it has been shown, my lord. It has been taken into consideration and the sale notice also, it has been mentioned, my lord. About the building, it has been taken into consideration and it has been mentioned, my lord. May I just pass on this, my additional documents, my lord.
Why should you lose the entire property for a small amount of 3 crores,
My
4
lord, it
crores?
cannot be divided, my lord. If it has to be divided, there should be a bifurcated kata, my lord. Otherwise, I cannot sell the property, which is mandatory in the present rules of the registration rules, my lord,
let's
for the
see.
purpose of sale.
Yes, we can understand like all are the difficulties. Where are they? Where are they recorded? Where have you stated? What was the exercise done by the bank?
My lord, I'll just demonstrate. My lord.
Yes.
My lord, the first document is a sale deed, my lord, which the petitioner has purchased, my lord. Page 11, 50 lakhs is the amount, my lord. He has purchased it on 2005. And the scheduled property is the same property, my lord. It's at page 14.
Hmm.
And at page 16, my lord, this is the valuation report. Earlier valuation report, it has been taken at the time of last renewal, my lord. Last renewal happens to be on 33/2023, my lord.
2023.
23.
What was the valuation then?
The first valuation report is on 1/8/2022.
Hmm.
The valuation is shown at page 20, my lord.
Hmm.
The market value is shown as 16 crore 22 lakhs.
Hmm.
And the for sale value just below that, my lord, 12 crores 17 lakhs is the for sale value. And the second valuation is at page 26, my lord. 11/1/2023. And the valuation is shown at, my lord, page 32.
Hmm.
17 crore 3 lakh is the market value.
Hmm.
And further at 33, 13 crore 62 lakhs.
Hmm.
This is a valuation report which has been taken prior to last renewal, my lord.
No, let's
Renewal
forget
sanction-
about that valuation of the property. I'm only on this point, nothing else.
My lord, the sanction order is at 24/1/2020, that's page 43, my lord.
Hmm.
44 last line, my lord. Below that collateral column.
Hmm.
Continuing security of already held equitable mortgage of residentially converted landed portion and portion of building constructed in the land situated at survey number so and so in Harohalli village, Elanco Hubli, Bangalore, totally measuring 149 guntas, along with
No,
existing.
At any point of time, have you made any representation to the bank with regard to this?
But we had taken this contention only before the DRT, saying that you cannot bring the entire property to sale. You have to bring only the portion of the property. That contention, my lords, my learned senior.
When was the first sale notice taken place? When was the first sale notice?
First sale notice.
1724.
17?
1st of July.
Please, my lords.
DRT, they have come, went before the DRT.
12/9/2024 is the second sale notice.
Before that, you have never approached the bank. You never asked that this whole property cannot.
Lords, I have approached the bank saying that I want to clear the loans.
No, that you have said so in so many writ petitions.
Lords, that's true. Lords, the reason why I read the judgment in Vasupi Shetty is similar facts emanated in those matters. If I default in the earlier instances, would not give a go by to the following of the mandatory provisions as held, my lords, in Vasupi Shetty versus Vandana Palace's
Same time,
case.
it is not open, first of all, filing these many writ petitions and going, when an order of DRT, why you have questioned it without bypassing the remedy under DRAT, why did you come to this court?
Lords,
Everything is silent on that.
Lords, the matter was pending before this honorable court. The earlier matters, this petition was filed
Because
on the
unnamed
solitary
matters
ground.
itself were not,
Lords,
you
even-
can't maintain a writ petition before this court.
Lords, so far as maintainability is concerned, my lords, we have stated that the order of the DRT, my lords, which is now passed, is an ipsit dixit order.
But why were you giving undertakings before the court?
Lords,
on so many
undertaking what I have
occasions?
given, Lords, undertaking will be indicative of the fact that intention is to clear the loan. Lords, I will not come and give an undertaking, my lords. We gave an undertaking that we want to clear the loan. Lords, then lords, may kindly see, my lords, page number 40. Along
No,
with
you
my
tell the
petition.
court, now according to them, only part of it can be sold. Please tell the court how the part of the property can be sold
Lords,
with one
kindly-
khata number.
Kindly have a look at, there is no one single khata number. Kindly have a look at the valuation document produced. Lords, the valuation of the property by the bank.
You have also filed, let us look at your
Lords,
document.
I'll just, Lords, may kindly see page 48 of the valuation report filed by them.
Yes,
Yes,
48
yes.
of your papers
Lords,
or their
of the
compilation?
compilation, which is, no, of the statement of objections or list of documents filed by the bank. This is filed on 22/4/2025.
Yes, page number
Lords, page number 48.
48.
Yes.
Yes.
Lords will kindly see at the bottom,
Hmm.
there are three distinct properties.
Hmm.
27/1, 10 guntas, 20/2, 2 acres, 20 guntas, and 20/4, 39 guntas. I'll also show from their records, Lords, this entire property is exposed to the road. The whole property, there is more than about 200 meters which is
Oh,
exposed
this
to the
is
road.
one document.
This,
one
I just,
khata.
Lord, this is, no, these are three khatas. The moment survey number is different, there will be different khata, there will be a different RTC.
Where from you get that?
Lord, it's a survey number itself shows me, Lord. If survey number is different under the Land Revenue Act, Lord, there will be a different RTC for different survey numbers. There will be no common RTC, Lord. Then your lords may kindly see, Lords, the location of the property which has now been given by them as additional documents. The additional documents which was now given, if your lords were to see page 24 of the additional documents now handed over. Lords, at page 24, your lords will find that black mark property is the property. At page 24.
No, the convenience compilation.
No, my lords, this is the additional documents which was now handed over, my lords, by the counsel for the bank. This is their valuation report which they are now submitting.
Page number 20?
24.
Yes.
Lords will find that the rectangular property, subject property, the whole property is exposed to the road. And now if your lords were to see, my lords,
Yes.
now this, as a matter of fact, what has happened, my lords, now is that this is coming immediately next to the business corridor which is now proposed. The plan and all is already sanctioned. Now, whatever valuation I've given is abysmally low because this is exposed now to the PRR or what is now called as the business. That is what is there in page 23, but it is not clear, my lords. The location clearly indicates what is the potential of this property. This is in Yelahanka.
You are submitting that it is one kata. It is only one kata number. Then the senior counsel says that
Page 27, can I just request your lordships may kindly take page 27, my lords?
yes.
Page 27. No, the artists are there, I can produce. Kindly have a look at, my lords.
Produce it. Produce
Page
that.
26, your lordships may kindly take.
No, in this only the bank.
Unquoted land, my lord. Only single kata will be issued by the BBMP. my lord.
Lords,
So
kindly,
when it is a single kata, it's not, you cannot divide the
Just under
property.
single sale deed, my lord.
my lords, bifurcation of
Entire
kata is
extent
no,
is purchased under
lords, I
single
just
sale
want
deed,
to say this.
Which I have produced.
Lords, even in respect of a larger extent of one single survey number, it is permissible to sell portion of the survey number. If it is a larger extent, there is no different yardstick, my lords, so far as kata or the survey number is concerned. Let us assume, my lords, my property is 10 acres. It is worth 10 crores. I am required to pay only 50 lakhs to the bank. Can they sell the property of 10 crores when it is permissible for them to sell only a portion of the property?
No, that I'm not able to understand the land rules or
Lords,
laws, what is prevailing in Karnataka.
Lords,
That's
that's
why
the
I'm not
reason,
able to
Lords,
understand what both of you are submitting.
Lords, now page 26 in that additional documents, my lords, which is their submission, which is their report.
Yes.
Lords, in that clause C,
Yes.
because I can understand if there is something in the report itself. B, belongs to details of the property, brief description of the property, residential land, building situated at Harwalli, complete address is given, survey numbers is so and so, then door number is given 27/1, 20/2 and 20/4. Then extent of land is distinctly shown, 10 guntas in 27/1, 2 acres 20 guntas in survey number 20/2 and 20/4 it is 39 guntas as per conversion order, and then boundaries as per the sale deed. Distinct boundaries are there for at least two extents of the property. 20/2 and 20/3, there is one single piece. 27/7, there is a different piece of property.
Oh, let.
And now kindly have a look at page 27 of my statement of my read petition.
No. What we do is, no, I mean.
Can I make this request?
No,
my lords?
I'll adjourn this matter. On that day, no more arguments. I want an affidavit or a memo to be filed by the bank and also by you about the divisibility of the land. Based
Very
on
well.
that, I'll pass further orders.
Very well.
Heard the councils, on behalf of the petitioner, as well on behalf of the auction purchaser. It is stated that a property, when the outstanding loan is about 3 crores and odd, the property worth rupees 23 crores, as per the valuation made by the bank, is
What
put
is this?
to auction. According to the land council appearing for the bank, it is not acceptable. According to the land senior counsel, for the petitioner, the same can be divided, and as per the whatever is outstanding, the bank ought to have put the said property to auction. In this regard, what is the exercise that is done by the bank? Why the property cannot be divided and sold? The bank shall file a affidavit oblique memo in this regard. The counsel for the petitioner, the petitioner shall also place before this court the material to show that the property can be divided and so.
For DRT.
Heard the counsel.
Petitioner also should file an affidavit to that effect. ma'am.
Huh?
Petitioner also should file an
I will
affidavit.
file an affidavit.
Petitioner also should
Yes.
file an affidavit.
I will file an affidavit. Milords, can I
Because
just
recorded
say
only
one
in bank.
statement, Milords?
No, yes,
Milords, one sentence I just wanted to say. In the objections filed before the DRT, which I'll place before this honorable court, bank never took a stand that they have undertaken this exercise.
and you also know I have never done except taking interim orders from the.
Lords, that's the reason why I said, Milords, loan of 2012, Milords, this is not a property which is, I can understand, Milords, if my property value is more than the assets, more than the debt which is
No,
due.
we are in fact.
Milords, I fully understand.
In fact, court is looking at equity, but it appears that the petition was, invoking the jurisdiction of this court from
Milords,
from.
during the pendency of these
2024,
proceedings.
filing several writ petitions.
Milords,
But one more
50
thing, I'm making it clear, once when I pass a final order, this conduct also will be taken into consideration by the court from how the intention is. By giving undertaking, it is not the intention that you want to. It is your intention to,
Close the
No,
loan account.
No,
Well,
not
not
at all.
close
Do
the loan account.
litigate on
So
this
long.
for further time. Yes,
Let's-
come up
Any
with that.
prudent businessman will
Businessman-
hold on to his capital money.
Cell number,
Let's, I will pass
Just-
But
on.
unfortunately, the banks are not being fair.
That's
Their
their-
attitude, nowadays now it should be that nobody should buy any property in the bank auction because they do not do any exercise. One that whereas we sell and let
We have reached,
both of
we
you
have
fight.
reached a stage where, my lords, earlier BDA, my lords, that's Bangalore Development Authority, if it sells, without any due diligence, people would buy the property because it's ultimately BDA, and bank would also give. Today, we have reached a stage when BDA is also, we have to see, because there will be some litigation on.
Yes,
That's
because
what
they're not doing any minimum exercise.
Lords, there are three
Lords,
judgments.
the-
One is seller
Like,
and
as the Supreme Court observed, they're behaving like now the bank is a big litigant and
with a memo, I'll
Lords,
pass
can
on
I,
three.
there is one more memo which I am filing, my lords, your lordships may kindly take this on record. The bank has given a letter saying that how they have adjusted the money which I have paid 4 crores. You just pass it on, my lords.
have you given a copy to them?
Artists.
A memo is filed with the petition. The same is taken on record. And I'll list this matter on 18th. On that day, just I'll take the memos, no further argument on this.
Lords, we'll just pass on the,
Request for some other day, my
Huh?
lord. Some personal inconvenience.
When?
On 18th, some other day, my lord.
19th, it can be taken up. my lords.
24th.
I'll
Very
just
well,
pass
Lords.
on the judgments, three judgments. One is Sanjay Sharma, latest judgment of the Supreme Court, which says, unless there is fraud in the auction, do not interfere, especially, my lords, in this. I'll just hand it over to the court officer with the
Yes, yes.
paragraphs marked.
Yes.
I'll just counter that there are about 3 judgments of the Supreme Court, my lords, where the Supreme Court says that valuation has nothing to do with the fraud. If the property is undervalued, grossly undervalued, my lords, just one indulgence, my lords, because I'll not be arguing this matter on the other day when it is listed. Can I just persuade your lordships to kindly have a look at one document, page number 44 of my writ petition, just one document, my lords. Reason why I'm referring to this. Lords, for this very property, we approached the State Bank of India for a loan. Lords, we were hopeful that there will be some takeover and that did not happen. Page 27. Lordship gets it, my lords.
Yes.
Lords, kindly see the next line. As per the instructions of the State Bank of India, Warangal branch, we had approached the bank, my lords, for the purpose of loan for this.
44.
Page 27, my lords, of my writ petition.
Mm.
7071.
Mm. Mm.
This is the valuation report by a valuer of the State Bank of India to State Bank of India.
Mm.
Lords, now, if your lordships were to see at page 28,
Yes.
the purpose of valuation and date of inspection. 1A, B and C.
Mm.
Now, if your lordships were to see plot survey number at page 29, serial number 9. This is very important, my lords, these two aspects. Description of adjoining property, converted layouts and apartments.
Yes.
3 acres, 29 guntas within BBMP limits. Then plot survey number is 27/1, 20/2 and 20/4. Harohalli village. After that, my lords, serial number 37 and 38.
Yes.
BBMP limits. That's only to indicate, my lords, that within the BBMP limits. Now valuation, my lords, in this your lords may kindly turn to at page number 833.
That's what I read.
Page 32, 9(4).
Yes.
Comparable sale prices in the locality is taken into account. Page 33, 13B, prevailing market prices taken.
Hmm.
Then guideline value is taken into account. Summary of valuation. Guideline value of the land is 38 crores. Market value is 70 crores. Realizable value of 85% is 59 crores. Forced distressed value is 56 crores. Lords, then if your lords were to see the next page,
Yes.
at page 36 and onwards, they have indicated, my lords, the inspection having been conducted. Just one line I wanted to point out, my lords, I just marked it. Because this is meant only for the purpose of the State Bank of India is what is stated in a certification which is given at page 41. At page 41.
Yes.
Lords, to assess the for State Bank of India. Lords, I just wanted to only bring to your lordship's notice that,
File your written arguments also, so
no,
that whatever you
I'll be
missed,
filing my written arguments,
yes,
but,
by the next date of hearing, all the parties shall file their
and one more,
written
I'm sorry,
arguments
my
along
lords,
with the
just
memos.
one more clause, I'm sorry, my apologies, my lords. One more clause which I want to read, because with reference to that 25% deposit, because I'll just, clause 9 of the auction notification.
Yes,
The successful bidder shall deposit 25% of the bid amount immediately on the sale being knocked down in his favor, failing which bank will forfeit. Balance 75% of the bid amount shall be paid within 15 days from the date of the sale by RTGS NEFT, pay order
that is
EMD of
how
unsuccessful.
the rule says,
Lords.
that would be there.
No, the reason why I am referring to this is, I read the judgment of the coordinate bench, my lords, is Justice, Lordship Justice Shyam Prasad's judgment. Says that even the terms as also Noon 5 requires, terms, my lords, rule 9 and
As I
11.
said, in that judgment, all the auction purchaser is before this court.
Exactly.
This is not a case, though.
Lords,
Lords,
Does
this was a
the-
ground
I-
available for
I-
him in DRT.
My lords, I just wanted to ask, answer this in this way, my lords. Whether the auction purchaser comes or the borrower comes, an interpretation of
definitely.
the provision will remain the same.
No, interpretation will change.
That I will leave it
Yes.
at that, my lords. My
Yes, we will.
understanding is that the
Please.
provision will,
Yes,
para 9, clause 9 and clause 11.
that will come, because you already relied on and I've noted down, please make your written submissions
No,
also. Place
clause
the written
11 also
submissions.
says, my lords, that it will be forfeited if it is not deposited within 15 days.
Lords, his object is that my money should be forfeited.
No.
That, my lords.
No,
is a
I'm not, my lords, this is 75%. Just one more contention, my lords, which I wanted to raise. Just keep this.
Lords, all this has to be first before the DRT. Now we are my lords, making this as a civil court to raise fundamental questions before the.
No, in all the DRT matters, High Court is a civil court for all practical purposes. And that's what we are doing in the DRT matters.
I want to see it out of my mind.
Yes, file your, yes, next.
For dismissal matter, sale number 2. Rajendra
Grateful for the
MA.
hearing, my lords.
Yes,
Rajendra MA for petitioner.
yes.
I'm returning from this case, because there was no instruction I received from my petitioner. I'm returning from, just to inform the petitioner he was present here in the court in some other matter.
You made arrangements for engaging another advocate, what we can do.
No, I'm
I'll record your-
returning.
No, I'll record your submissions
Yes.
and I'll proceed with the matter.
Yes, my lord.
Yes, argue.
I'm undertaken to file a call on the R6 matter. Connected matter, I am filed a petition.
There is one more connected matter. my lord.
Connected matter.
13695.
Is
This
ordered-
writ petition has been filed, my lord, leaning on the two other writ petitions which has been disposed of by this court, my lord.
The learned counsel for the petitioner submits that. He has given a wakalat in this matter. And the party is also present in the court. The party is also present in the court. It is for the party. You should have engaged an advocate, giving an opportunity. This is matter on 17th. Yes, under the same caption. Yes.
Can I make one submission, my lord?
Hmm.
There is another tagged matter along with this writ petition.
2.1.
13695, yes, my lord. 2.1. Where this writ petition has been filed, leaning on that other two writ petitions, my lord. The other two writ petitions, my lord. In one writ petition, the writ petition number 794.
What is your name? You are appearing for the Canara Bank.
No, madam, R6 mal, that is the, in the connected matter, we have filed.
No, for Canara Bank, who appears?
Canara Bank, nobody has been.
Yes, where is Mr. Vig? Take notice, Mr. Vignesh City takes notice on behalf of the respondent Canara Bank. What about next two? Authorized officer, again in 2.1 also,
I'm appearing for the second respondent.
R2,
Two and a half.
concrete products, yes. Get instructions, we'll hear it on the day. Take a copy from him, because the petitioner, he has given up wakalat. Who appears in second matter?
Mr. Ashok.
Ashok.
My lord, sir, I am appearing, my lord, on behalf of Ashok Pandit, my lord. This matter has ordered to be listed on 17/11, my lord.
No, are you appearing for the petitioner?
Petitioner.
You are giving an impression as if you are appearing for the respondent.
My lord,
When he is asking in his matter, when he is asking for time, how are you concerned with that?
no, my lord, I'm just, in the connected matter, your lordship has asked who is appearing, that's the reason.
I was under the impression that you appear for somebody, some respondent in In two.
My lords, in the first matter, my lord, in matter.
Give papers to them,
R6.
give papers to them, it will come on 17th. Yes, list on 17th.
Cell number 3,
Oblige.
Dhananjay Kumar, Dinesh Shetty.
Why you were not present when the matter is called? This court has repeatedly adjourned this matter for filing the affidavit. If the affidavit is not filed by tomorrow, that is on 11/11/2025, without going into the merits of the matter. Have you filed the affidavit? Please come. Please, do. Now, yesterday your colleague has come. I remember. This farce is going on from 28/10. 1, 2, 3, 4. This is the fifth time. Yes, this writ petition is filed, seeking the following prayer. Huh? Yes. That's why court has asked you to file an affidavit. Yes, sale has not taken place. I will dismiss it on that ground then. The present writ petition is filed, seeking the following relief. The land council appearing for the bank submits that the auction, why it could not be conducted?
For want of bidders.
The auction could not be conducted for want of bidders, and the writ petition has become infructuous. Considering the submission of the land council, as the writ petition is filed, questioning the auction notice dated so and so, 13/8/2024, and the action was not conducted. The writ petition is dismissed as infructuous.
Cell number
Yes,
4,
next.
Syed Jafar Moinuddin.
For respondent bank.
Hmm.
On last date also, there was not
Yes.
present for filing an affidavit. As on date, 1 crore 22 lakhs is it.
The writ petition is filed, seeking the
The position of
following prayer. Extract the prayer. On 31/10/2025, it is submitted before the court that the petitioners are ready to pay the entire amount in 4 equal installments in a span of 6 months. And in that regard, they'll file an affidavit before this court. Hence, the matter was directed to be listed on 5/11/2025. And by 3/11/2025, the court has directed that the affidavit shall be served on the respondent bank. Then when the matter came up on 5/11/2025, there was no representation on behalf of the petition. And so matter was directed to be listed on 6/11/2025 under the caption for dismissal. On 6/11/2025, the counsel appearing for the respondent submits that the respondent has not come up with any proposal for OTS, and the outstanding amount is an amount of rupees 1 crore and odd.
1 crore 22.
Accordingly, the matter was directed to be listed on 10/11/2025 under the same caption, and it is made it clear that no further adjournments will be granted. On 10/11/2025, it is stated that the bank is going to come up with a one-time settlement. And the learned counsel appearing for the respondent submits that there is no such proposal from the bank. Then this court has directed the matter to be listed today, and on the merits, the order will be passed. Today, when the matter came up, there is no representation on behalf of the petitioner. Next para. It is stated that the petitioner had taken the loan of a sum of rupees 1 crore 1 lakh on 28/2/2017. When the petitioner has failed to pay the loan, the account has become NPA. They have declared, They have classified the account as NPA, and a demand notice was issued on 19/4/2025 under section 13(2) of the Act. It is stated that in spite of the petitioner's request, they have issued notice under section 13(4) of the Act. It is stated that the respondent has not intimated the petitioner before taking action under section 13(4) of the Surface Act. And on 10/10/2025, issued a final vacate notice to take a physical possession of the property without even giving petitioners chance to make arrangements for alternative accommodation. And it is stated that the petition is ready to pay the amount. It is stated that the impugn notice is bad in law and the same is required to be rejected. And the respondents have acted contrary to the banking law. Next para. The petitioner, he has questioned the possession notice dated 22/7/2025 and 10/10/2025. When the bank has issued the possession notice, the remedy available to the petitioner is to go before the DRT under section 17 of the Surface Act. He has come before this court, and how it is an exceptional case that this writ petition has to be entertained. Nothing has been stated. And from the beginning, what is submitted before the court that there is a one-time settlement, there is a OTS scheme, and the bank is going to come forward. The learned counsel appearing for the bank submits that there is no such scheme from the, there is no OTS proposal from the side of the bank. In these circumstances, this court do not find any reasons to interfere.
But, sorry, we received instructions from the petitioner. But he wishes to withdraw the case because the settlement OTS order is still not been given by the bank. It will take some more time, hence he instructed us to withdraw the petition.
Delete all that. File a memo. A memo is fine. Seeking to withdraw the writ petition. Dismissed as withdrawn. Yes, fine.
5 for orders matter. PP Headback for petitioner. Francis Xavier.
Lord, the matter has been settled, my lord, mediation.
Matter has been settled in the mediation. It's a bank surface, under surface. The memorandum settlement.
Report.
Copy. Please.
Report. KMC report.
Mediation report is filed. Balance payment. Total amount agreed is 28 lakhs.
1 minute.
15 is already paid. Page number 2.
Page number
2. 1. As against the total sum of so and so, sum of rupees 28 lakhs to be paid. Next mode of payment, 15 lakhs is already paid before the deposited before the Honorable High Court. And the balance amount next B.
15 lakhs is already deposited.
Yes.
Which is entitled to withdraw.
Yes, please.
He has withdrawn or subject to the.
Not yet.
Yes. Then
Please. And the balance amount of 30 lakhs is paid by way of DD through demand draft as mentioned in clause B.
you already given him.
It's being handed over today. As mentioned in page number 3, bottom B. That's for both the cases, the two cases, both can be settled.
The WP 19340 of 2022 and WP 15905 of 2022. Both these matters were referred for mediation by an order dated 5/8/2025. And before the mediation center, parties have entered into a settlement. As per the settlement, it was agreed that the petitioner will pay an amount of rupees 28 lakhs in full and final settlement. And the mode of payment is already the petitioner has deposited 15 lakh rupees.
15 lakh 28,188.
There is an order on 25/7/2025.
15 lakh,
28 crore.
but order as per this, it takes only 15. It refers to 15.
Lord, there is a order.
It's in fact, what's mentioned, that's true, my lords, but I have no objection, 15 lakhs,
28.
28,188.
earlier.
This all
The
court's order,
petitioner has already deposited 15 lakhs 28,000.
188.
188. However, in the order, in the mediation, in the settlement, it reflects that an amount of rupees 15 lakhs is deposited. The learned counsel appearing for the petitioner, learned senior counsel on instructions, as the client is present before the court, submits that he has no objection for the respondent bank to withdraw the said amount. Then the remaining amount of rupees 13 lakhs. A DD was a demand draft dated 16/9/2025 is handed over to the bank today,
Yes, my.
bearing number 651211 on the Union Bank of India, Answadi branch, Bangalore. In the light, the respond, in the light of the settlement, both the writ petitions are disposed of. The respondent bank is at liberty to withdraw the amount.
The registry may be directed to.
Registry is directed to the amount to the bank.
Okay, so only thing is, the clauses mentioned in that they have to return the documents.
We will return it, my lord.
Give
Original
the
title deeds.
mediation report. As per the mediation
Page
report,
number 4, clause number 2.
the mediation report, as per the settlement, where is that?
That's page number 4, clause number 2.
Hmm.
After actual realization, the entire amount of so and so, respondent will arrange for discharge of the memorandum of deposit of title deeds.
The bank immediately after realizing that is a DD.
That is
And this amount is with the bank.
Yes, my lord.
Hmm.
That is the process, my lord. Obviously, the bank has to discharge, we will discharge it.
Once the amount is withdrawn from the High Court,
Yes.
within 10 days from thereon, thereon,
Yes.
the respondent, the bank shall discharge the memorandum of deposit or title deeds in favor of the petitioners and the relevant petitioners and what is this relevant person?
And return the original documents.
Relevant persons, what is this?
No relevant to the borrower petitioner.
To the borrower,
Or-
to the petitioner borrower and hand over the original documents which are given by the petitioners.
As
along with
indicated in the MOTD, my lord.
And relevant, what is that?
MOTD, yeah. The documents as
Memorandum of,
indicated in the MOTD.
As indicated in this
Memorandum of deposit of
memorandum
title deeds.
settlement.
Please.
Yes.
Memorandum, not memorandum of settlement, my lord, memorandum of deposit of title.
MOTD, memorandum of deposit title.
Yes.
Much.
Whatever the documents
Yes,
as per the memorandum of,
Title,
yes.
deposit of title deeds.
Yes,
Great.
yes,
Number 6.
yes.
No, but.
Yes,
Commissioner,
Your Honor,
Case query.
after the stay order, I paid 23 lakhs, Your Honor. Complied the
Where is the order? Let us see.
2022, Your Honor.
When is the order? Where is the order?
23/12/2022.
23/12. What is outstanding?
Outstanding as on today, it's more than 80 lakhs.
No, Your Honor. In
70,
this
77 lakhs.
58 lakhs,
How much was paid as of now?
23 lakhs. are
As
paid.
of now, my lord, since 2022, as per this order, this 15 lakhs was paid.
Here afterwards, I paid around 31/12/2022, 5 lakhs I paid, 29/12/2023, 4 lakhs, 9/2/2022.
So total how much you have paid as of now?
23 lakhs I paid, Your Honor.
So 23 lakhs you have paid.
Yes, and-
Outstanding as on 2022
Is
is
58
77 lakh.
Yes, 57 lakhs. Your Honor,
57 or 77?
in this,
Now it is 77 as on today. Monthly EMIs are not serviced, only
this, Your Honor, we want to go for one-time settlement and close the matter.
So yeah, what are we doing from 2022 year?
Your Honor, we have approached to the bank, but there is
And
no
if
proper.
they are not coming up with the OTS, we can't compel them to, court cannot compel them to go
We
for
are,
a
we are
OTS.
interested and we want to close the matter, Your Honor, because he's staying in the same property. So we want to go for a one-time settlement, we'll close it, Your Honor.
There's no proposal of one-time settlement in our bank. It's
Your
been
Honor,
declined to him
we'll
very long
approach the
back.
bank and we'll settle.
And
We
which one-
approached them, but there was no proper.
Can you, no,
Let him go to.
one
let
minute.
them go
No,
to DRT.
this is pending from 2022.
Yes.
Now, I'll adjourn this matter till 25th of November.
No, Your Honor.
25th of November, something happens.
First week of December, because I have got
Yes,
some.
please. We will take up this matter on 2nd of December.
Let there not be extension of interim order, or let the service cut, let them
them-
continue paying EMIs, that also they are not paying.
No,
Since
Your Honor.
22, no EMIs.
First week of December.
Unfortunately, bank 2022 interim order is
I
there.
filed my vacating of interim, I filed IA for early hearing.
That's what.
Everything is there.
Now, we will, anyhow, that is 2nd December. I will not adjourn the matter at any cost.
25th it will be, let it be on 25th.
No,
of-
no, Your Honor, I have some personal problem.
24th.
First week,
It is
first week of
submitted by the
December.
land council for the respondent bank that as on, from the date of order, they are not regularly paying the EMIs. And there is a stay, and he has filed the vacate petition and also an application to expedite the hearing. It is submitted that by the land council, the petitioner, that they'll approach the bank and they want to settle it. And but bank is not coming forward with the OTS. Land council appearing with the bank submits that the bank has no such proposal, as such no scheme for the same. The writ petition is pending before this court from 2022, and the petitioner is enjoying the interim order by giving a reasonable opportunity till this deems it appropriate to list this matter on 2nd. By that time, if the petitioner is ready to pay the amount, an affidavit shall be filed before this court.
We'll go for the OTS and we will.
If there is no scheme, how will you go for the OTS? Bank should have a scheme. If they don't have, how will you compel them?
We'll request
So
them
by
one.
that time, by 2nd of December, if an affidavit is filed before the court, when they are going to pay the remaining amount, on that the matter will be disposed of, or else this court has to pass orders on the merits, and it is made very clear that on whatsoever reason, the matter will not be adjourned on 2nd December.
Published.
And this should reflect in the call list. Yes.
Cell number 7, Nagaraj Naidu for petitioner.
Yes.
Chattakant Patil.
In DRT matters, appearing on this side is always very difficult. But in any event, Lord, the first matter we're withdrawing.
Memo is filed?
We are filing a memo, Madam. We are withdrawing the first
A memo
matter.
is filed seeking to withdraw the petition.
That's become infructuous.
Has withdrawn?
Yes. Now, the second matter, Lord, we have a very small issue.
Yes.
After the interim order was passed protecting the house property, the bank, my lord, has sold various of our properties. According to us, after sale of all those properties, there's no outstanding today. All I'm asking the bank, my lord, and I've been going to the bank, is to give me a statement of what they've recovered. All I want is a statement of recovery, because then I would like to pay with the money if there's any
How
outstanding
many
clause.
sales were conducted?
That I don't know, my lord, because he was in hospital.
Lords, according to us, only one property in Delhi which is sold is the one which they withdrew.
And then how can a writ
And if there is a sale, my
for
lord,
this court for a property for a 13-4
That-
order
Yes.
that is passed by the courts at Delhi?
that is what they withdrew,
How
my
can
lord.
the writ petition be filed before this court?
That's the petition they withdrawn, my lord. Anyway, there was there was some interim protection subject to payment that was not done. Therefore, the property was then sold.
Oh, it's good that you don't have to argue
Don't have to.
arguments on that writ petition.
None of the other properties are sold. It's not sold.
Some movables
Only
have been
one
sold. I think
Only one that which they withdrew.
my learned friend can give us a statement, my lord. Your lords may have it.
Let's see, what is this writ petition?
My lord, in this, we have
7.1.
challenged the possession notice.
13.2 and 13.
13.4 and 13.2. The possession
ground?
note. I beg your pardon, my lord?
On the ground?
My lord, the main ground is we had actually given them, my lord, deposited 10% in favor in respect of an OTS, 5% in respect of an OTS which we had given to them, and it was under consideration, and that you also will find in the interim order as well. On 1/7/22, my lord. My lord, if my lord kindly takes page 204.
Where is interim order? Where?
Yes.
Dated 6/2/2023.
Yes, ma'am. In this case, interim order, in this case. Interim order is there in order of court. Which one are you referring? Which one? No, 2796. My lord has 2796. ma'am.
Yes, I'm
Yes,
looking at that.
2796. Interim order is in 2796 is not there in
The bank has filed its objections.
It's filed, my lords. We have also stated.
Where's the bank?
Where are the objections of the bank?
We don't have a copy of the.
It's been filed, my lords. I'm told this has been filed.
Illa, we've not got a copy of the objection statement. There's some office objection
Lords,
based on that.
according, I have the copy which is filed in 2023.
It's 16 to
I think
2023.
there's some office objection that it is not served.
I don't know.
I also haven't seen the objection
I have the
statement.
copy. That's why I don't know whether it's been served or not. I don't know. He has to say, but it's been filed in 23 itself.
Illa, otherwise file a rejoinder at least to the objections. I don't have a copy.
Otherwise, I'll ensure it is served
Yes,
today
it is
itself.
submitted by the senior counsel appearing with the petitioner that the bank's objections are not served on the counsel. The respondent bank shall serve the copy of the objections, and if rejoinder, if any, shall be filed by 20th of November by serving the advance copy on the counsel for the respondent bank list the matter on 24th.
24. Interim orders may be continued.
Interim order earlier
I-
granted
my lord,
is
one
extended.
request, one more request is if they can give us a statement of how much is recovered and how much is outstanding now.
That
We'll-
can be
my
given,
lords,
bank shall furnish a
I
statement
will
with
do.
regard to what is the outstanding, how much amount is recovered.
And
Yes, we'll do that.
complete.
Cell number 8. Cell number 8.
But I beg to appear on behalf of Lord Respondent.
Lords, they have served the copy of the objections in the morning. Just go through it and make my submissions tomorrow or day after. Maybe next week, my lords.
Sale notice and there are two petitions, my lord. One is, my lord, sale notice SLB full on the court. The second one is, my lord, section 14, my lord, order SLB full on the court. In fact, this honorable court, my lord, in fact, the matter is very same matter, my lord, earlier various rounds of litigation. My lord, I just draw my lord's attention, one order passed by this honorable court.
Lords, they have filed the statement of objections today morning. I'll go through it and make my submission.
I am not
If
filed.
that,
I
if
can
that,
remember to. I have filed. I am the answering respondent. I filed way back, my
so
lord.
I'll go through
Who
it and
is
make.
he? He's the auction purchaser.
Yes,
No, let's not hear him. We will only hear the bank. Yes, give it.
Lords, I,
When did you enter appearance? When did you file your wakalat?
Yes, we have filed the application, including offense. It has been allowed in last date of hearing.
Yes, let's see. What is the writ petition about?
8696 of 2024.
Yes, yes.
past 4 months. Lords, I thought that I'll argue this matter on some other day, Lords. I'll go through because I did not go through the, I was a little
This is
busy with
matter
other
on
matter.
Monday.
Monday.
This honorable court directed me to produce, my lord, the sale deed. My lord, I may, my lord, where, my lord, my borrower, my lord, title. I mean, my lord, permitted. to-
Yes,
And I don't copy it.
the memo, the bank has filed the document, the title document
Sale
by
deed
way
and, my
of,
lord, valuation report which I, my lord, I had taken at the time.
by way of a memo. Memo is taken on record. It is already served on it is submitted. The same is served on the counsel for the petition.
My objection may be taken on record. I have served the copy to the,
Anyone now file it in the section.
please.
The auction purchaser has also filed his objections, and counsel, senior counsel appearing with the petition submits that they'll come up with their objections. This is matter on Monday,
Interim order.
on 17th. Interim order earlier granted is extended.
Yes. 8 and cell number 9.
Yes,
Cell number 9.
no representation for dismissal on Monday.
Cell number 10.
And which bank,
adjourned.
let us see which bank in 9.
Lord, I am appearing for the respondent number 6. We have not received the petition copy.
Lordship.
Lord, if petition
Yeah,
copy
yeah,
is
I-
served, we'll look into it and we'll make
Yes.
My lordship,
Hmm.
I am for the petitioner.
Hmm.
I'll take this notice for 4, 8, 9 and 11, my lordship. Notice. And I will serve the copy because,
Respondent 6.
I will serve the copy, petition copy to.
Interim order is there. Interim order is there.
Yes,
Interim order is there in your
Yes, yes,
favor?
yes. I may, that's what I'm coming, my lordship. It may be extended, my lordship.
What are you doing from 24 without service of notice of the
My
respondent?
lordship, actually in this, respondent number 8 is not coming before this honorable court.
Morning.
No,
10
no,
was
actually,
adjourned.
they are not informed me, my lordship. That's what I am before here. Actually, I was seated. They are not prior intimation.
Generally, this court insists that it should be informed, but she said that the counsel is hospitalized and you are not for, she has not seen you. That's what is her submission.
No, yes.
The interim order in 10 is extended till the next date of hearing.
17.
The petitioner shall take steps for service of notice to R4, R8, R9 and R11.
11.
The learned counsel appearing for respondent?
6, madam.
6. The petitioner shall have the copy of the writ petition on the counsel.
Yes,
Yes.
much obliged.
11. Cell number 11. Avaraj. Allard.
Yes. In this case, your worship, I can see.
This. Appealing for
If the matter is set down for taking of steps, because throughout the proceedings, my lord, that she filed a suit for maintenance, wherein also he placed ex parte, and thereafter RA has been filed, wherein also he placed ex parte. His whereabouts is not known. Then now your lordship, the question of taking steps to that respondent 2 does not arise. Because here bank is involved.
Respondent number 2. Who is
2.
respondent number 2?
2 is the husband of the petitioner. I think it is a collusion.
Not collusive, it is a borrower. He is the borrower and is the wife. What has happened is he obtains the loan, deserts the wife and the child. Now the one question is, as far as there is a maintenance order against the husband, it's not been paid. This one aspect of the matter, that proceeding is going on. Now the second aspect is they now try to invoke the proceedings after more than 1.5 decades, which is impermissible law against the this property where the wife is residing. Husband appears that he is not available for enforcement, the maintenance proceedings also.
Whatever is a secured
Please.
property, that they will do it. Why it
They
is
will
not
they will
in
proceed.
Both
They
have
to proceed.
obtained the loan. Husband and wife is also are the parties to the
Whatever
loan.
is mortgage, or whatever is the asset.
Please.
It will be, that they have every right to
Now,
invoke
please.
it. invoke
Now the question
providence
is,
of surface.
the question is within
Because of
which,
that reason only, even RA, my lord, the bank has filed an appeal. Trial court has declared, wherein the modification is bad. Bank can take action against the mortgage property. Then they have not preferred any RFA, RSA. Really, sir, not bad.
Now, whatever are the senior
No.
counsel, whatever are the disputes between the wife and the husband,
please.
whether both of them are applicants, one is the applicant, whatever it is, ultimately a particular property is mortgaged to the bank.
Yes.
Once there is any default on the part of the borrower, whether it is husband, wife, or interstate disputes between them, the bank has every right to proceed under the Surface Act.
As far as the right to proceed under the Surface Act, we have no dispute. As far as the right is concerned, we cannot dispute. But kindly see when it can be proceeded, within which time, once they issue the possession notice, etc., and within which time it has to be initiated is the
Possession
question.
notice
Kindly see, I may directly take the kind consideration of the Honorable Court to page number 67.
Yes.
The initial notice is 7/2/2007, page 67. I am reading that extract from the present notice, which is an admitted fact, page 67, subject withdrawal of the demand notice under section 13(2) of the Securities and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, dated 7/2/2007. Kindly see this date, 7/2/2007.
Then after that, what happened?
They don't do anything. Now 2024, they say we'll again initiate proceedings.
How can I-
2007.
Your lordship, I can say there is an order of injunction against me.
No, 1 minute, let me submit. My lordship friend is not allowing me to submit. This was the case with the husband also. Husband never allowed the wife and
That's why
children
you
to
please
speak.
narrate the facts. After 13(2) notice is issued.
Please.
7/2/2017, what are the other legal proceedings that are pending, which made the bank not to move further?
Please. Now I will submit on that. Kindly see one by one. I may submit the aspects. As far as the proceedings are concerned, kindly see the initial proceedings, page number 13.
Yes.
Where this was number 2756 of
There will
2005.
be, you must have, the synopsis must be there to understand what has happened.
Yes.
Please come. to the
I
synopsis.
beg to take the honorable court synopsis. first date 4/8/2009.
Hmm.
This is the judgment and decree in OS number 2756 of 2005.
Hmm.
Bangalore granting maintenance of rupees 3,000 to the petition number 1 and 1,000 petition number 2 and permanent injunction respect of alienated civil property granted against respondent number 1.
Permanent
bank-
injunction, so.
Please.
In respect to the mortgage property, you have taken an injunction.
Yes, that is 2009.
Hmm.
2009, there is an injunction order, and
Yes.
this injunction order is set aside.
2009.
Then the bank has
2005.
appealed against that.
Yes, 2015 bank has appealed against that.
Decree as far as this injunction is
that-
concerned is set aside.
That set aside in 2015.
Yes.
Now, at best, what they can plead is, at best, what they can plead is that this time limit from 2009, when the judgment of injunction was granted, from there onwards, still it is set aside 2015. We are saved, they can say, at best. Now, what they now do is, they issue the notice in 2025. Judgment was set aside in 2015.
28/1/2025 is the possession notice.
Yes, now 25 is the possession, no, original possession notice is 2007.
Yes, to 13/2 only, at that time 13/2
Please.
happened. Other steps were not taken place. Okay, 13/2 notice was
Please,
issued.
no, once, yes, please.
So now after that, they've issued the possession notice on, under section 14, on 28/1/2025.
25.
22/11/2024.
What is the date?
22/11/24.
Demand notice.
Demand notice.
Again, fresh demand notice is issued on.
Yes.
13/2 is a demand notice dated.
22/11/2024 demand notice.
Hmm.
Then thereafter,
1 minute. When the demand notice is issued under 13/2, was it served and was it any reply was given?
no reply, I think.
Huh?
No, original notice 2007 was served.
No reply.
2007 demand notice was also there. No, I best.
Lordship,
let me submit
may
one
I give
canvas.
the dates, my
Let me submit.
May I
Let me
give the
canvas a
date?
legal point.
7/2/2007 notice was issued.
Yes.
Then thereafter, your Lordship, even prior to that, the suit is filed the year 2005. That, your Lordship, is the 29/11/2005 filing of the suit.
1 minute, 29?
11/2005 suit is filed. 31/1/2006, a temporary injunction order is taken.
31?
31/1/2006.
Injunction.
Then bank was implemented on 16/7/2007.
Hmm.
Then the judgment was in, that the suit is on 4/8/2009.
Yes.
Granted an injunction. Then the bank has preferred an appeal.
8/10/2015.
Yes.
Yes.
On 9/7/2010. Modification order was passed on 8/10/2015.
Hmm.
Then thereafter, your Lordship, they demand notice and thereafter
13/2 is
Page.
22/11. Then this 14 is on?
14 is on 28/1/2025.
So now your submission is, though the bank, it is outstanding right from the year 2007, it is not open for them to initiate the surface proceedings?
They could, my lord, once they issue the demand notice, and thereafter kindly see there is no payment, etc. at any point of time. Now, as far as the limitation for recovery proceedings is concerned, they issue the demand notice, the account has become NPA. Time should be counted from that date when it fell in NPA. Of course, they can request for the postponement or the waiver of the period within which.
Provision on the Surface Act says that once there is a limitation, once the NPA, account becomes a NPA.
Please.
After like a suit.
Please.
After 3 years, within 3 years only, you have to initiate the surface proceedings. After that, you cannot.
Please, there's
Provision
one,
says-
which is the provision the honorable court is posing question to me.
And under the Surface
As far as
Act.
the provision is concerned. With great respect, my lord, provision in the residuary provision in Article 137 of the Limitation Act is applicable. This, of course, I beg to submit on the point
With regard to the suits.
with the, for the suits. And
it
what
is
is,
always, 3
what
years.
is constituted by the honorable Supreme Court is, as far as the word suit is used, that is the provision. But whereas the word application, that is the period is 3 years. So honorable Supreme Court has constituted this provision, stated that this amounts to filing an application before the concerned authority, DRT or the other authorities.
Any judgment.
There is a
relying on-
judgment on in Babulal Varadaraj Gurjar. I beg to,
Pass on.
please, I feel this decision was passed on to the kind consideration.
It is there.
Babulal, file alli nodi. Last time it was heard before the honorable coordinate bench earlier.
Yes.
If it's not there, I will pass on the
It
hard
is there.
copy.
It is there. Which paragraph in this?
Please, I beg to take kind consideration to Babulal. Babulal, please. Please, kindly see. I may start from para 30. This, of course.
Yes.
Please. Para 30. Para 30, please. A few days after the decision in Vasudevo or Bojwani, a 3-judge bench of this court had another occasion to apply and explain the ratio in BK Education Services. That was in Gaurav Hargovind Bhai Dave, decided on 18/9/2019. Therein, the financial creditor had stated in the 11th column of former 1. Sorry, this is page number 47. Please. There in the fourth line, the financial creditor has stated in the relevant column in form number 1 of the application in section 7 of the code, the date of default to be the date of NPA 21/7/2011. Application section 7 was filed on 3/10/2017. Adjudicating authority applied Article 62 of the Limitation Act, reached the conclusion that since the limitation period was 12 years from the date on which the money sued has become due, the claim was within limitation. Hence, admitted the application. The interplay between section Article 62. Now, para 6 extracted portion, may I read, please? Having heard the learned counsel for that, what is apparent is that Article 62 is out of the way on the ground that it would apply only to suits. The present case being an application filed under section 7 would fall under the residuary Article 137. Then the extracted portion, para 7. That being the case, we fail to see how this para would possibly help the case the respondent. Further, not for us to interpret commercially or otherwise articles of the Limitation Act when it's clear that a particular article gets attracted. It's well settled. There is no equity about limitation. Then para 31. So Article 37 is applicable. 137 is applicable. Residuary provision is applicable. Para 31 extracted portion may beg to
Let
take.
us see what are the facts of the case.
Please, facts of the
first fact.
before the Honorable Supreme Court. Yes. Please. This is actually about the IBC code, a relevant the interplay between the IBC code and the Limitation Act. May beg to take the kind consideration to the. It starts at page number 10.
Yes.
The appeal under section 62 of the IBC is directed against the judgment and order dated 14/5/2019 passed by NCLAT, New Delhi, in so and so, whereby the appellate tribunal has rejected the contents of the application made by respondent number 2 under section 7, seeking initiation of the corporate.
Any judgment that is dealing with the surface proceedings?
With great respect, there are judgments of the other high courts. The Supreme Court, I beg to submit directly.
In high courts also.
I will place all of them in a compilation, my lords. The only thing is the interplay between these two. I do consider the Honorable Court's question to me, I understand as it is, that this is under the IBC, directly under the surface. This principle is applicable, it has been applied. I will have produced I have its soft copies, hard copies I will produce with copy to my learned friend on this point. I feel this law is, this is followed, my lord, now. As on today, it's applied to surface also. The principles in Babulal.
Why the bank is keeping quiet from 2015?
Your Lordship, that is the problem. Your Lordship,
that could not be explained earlier also because the coordinate benches.
Article 62, Your Lordship can say 12 years. Article 62 says to enforce payment of money secured by a mortgagee or otherwise charged with 12 years.
12 years is from
when the money sued for becomes due.
2015 to 2027.
Yes.
If they want to count from 2015, they can't count from 2015. Earlier it started when it fell NPA. With great respect, first.
If it is, but the interregnum period where you had the injunction and the matters are pending before, you had an injunction in 29/1/2005. 29/1/2005, you filed the suit.
Bank was not a party.
No.
They initiated the proceedings.
No. At least let's say 16/7/2007. There was a bank was impleaded and an injunction against the bank.
I do understand this question. The
16,
question would be,
2007.
your Honorable Court is, I have to go down to this proposition. When exactly is the starting point of limitation is when it fell NPA.
No.
That date, they are not,
No. They have issued the NPA, the 13-2 notice on 7/2/2007. So let's forget about when is the NPA. The proceedings were initiated on 7/2/2007. By 7/2/2007, on 6/7/2007 itself, you have the bank was completed and you have an injunction against them. So the period from 2007 till 2015 is in the litigation.
Correct.
So your limitation starts from 15.
15.
Their limitation starts from 15.
15.
They've issued in 20, as you just know submitted,
It's
12
three.
years limitation.
No, 3 years. What said is in this
3 years
decision.
in respect of.
No. That suit is not applicable. Supreme Court says it's applicable to suits. These are not the suits for recovery, that they initiate securitization proceedings. That's exactly the para. May take the kind consideration of the exact para.
It's all
It's
public-
out of the way.
It's all public money. We will try to understand.
No. That's why Supreme Court said there is no equity about limitation, and the exact words used by the Honorable Supreme Court is Article 137 is applicable. 62 is out of the way. Kindly see. I will read the exact para, page number 47.
We will take up this matter.
Please.
On 10th November. I mean, not 10th, this is the 17th November. That day, please.
Please, we will assist you
enlighten
on.
the court on this.
I now understand that the Honorable Court may have to decide, is it to be construed as Article 62 or 137?
That's it.
Please. If it is,
So if it's a debt, now
62.
even under the Limitation Act also, the debts belonging to a private individual, debts belonging to the government, there is a distinction. What is the limitation
no,
value?
this point is now settled. As far as the government banks, the debt is concerned, they have no equity. They should flow as per Limitation Act. It's what exact word used by Supreme Court is. You make public money, you know have equity. You don't have equity on that count.
Now
They should be, in fact, more cautious. They sleep for the rights after way back after 10 years and say, now we will proceed.
So now they keep quiet and public money should go.
Public should not also suffer. That's the balancing the equities.
No. Now it is not about public suffering. No, this way also public will suffer. It is public money.
It's
Somebody happily taking it and keeping
They are in
quiet.
finance.
Here, your lordship, you can see 137 when the right to accrue.
So the limitation.
Here,
Act
your
is-
lordship, you can see only right to accrue.
That's what the Supreme Court said. We will not legislate. We will not amend the law. As the law stands, it applies to banks also.
We will see, we will pass orders on 17. Yes, on 17.
17. Interim order may be extended.
Interim order all granted is extended till then.
Please,
Cell
I'm
number
grateful.
12, Rajendra M.A. A
Or
petition
in bank, my lord.
King Chandra.
Yes.
Lord, on the same relief has been sought in the earlier writ petition also, my lord, which is at page 143, 140.
What is the relief in this? I'll give you.
They are sought to quash the section 14 petition and
No, let me look at the prayer first.
please, my lord. It's at page
To quash and set aside the impugned order passed by the DRT.
DRT.
Then?
Second one, my lord.
Criminal miscellaneous, that's 14
Yes.
order to be set aside.
Yes.
Where is the earlier writ petition?
Earlier it is at page 143, my lord.
140.
Fourth para, my lord. May I read, my lord? The petitioner was a borrower. He committed a default. Hence, the Karnataka Bank initiated proceedings under section 14 in criminal misnomer so and so on the file of first additional senior civil judge Dharwad. The trial court wide order dated 3/10/2023 allowed the petition.
Same essay which he is questioning
Yes,
now.
ma'am. As against said order, the petitioners filed essay number 385/2024 before the Debt Recovery Tribunal under section 17 of Surface Act. The tribunal dismissed the appeal on 29/11/2024, which was already taken into consideration by this honorable court. Madam. And in that petition also, earlier interim order has not been complied.
You have
Madam.
not even sought the leave of the court.
Your Lordship, there are two aspects is involved here. One, I have challenged the order passed by the magistrate under section 14 before DRT under section 17 of the Act. That is one aspect. Wherein there was a delay of 260 days to condone the delay because in magistrate court order, we are not the parties in magistrate court order. It is executive proceedings. From obtaining the court order, when we approach the DRT said 260 days delay.
No.
It has not considered on merits.
Notice was issued to you when?
The demand notice, position, but the section 14 they will not issue.
14, after 14,
They will not issue. Section 14 they will not issue.
not section 14. I'm saying after the magistrate's order, You will receive some notice,
No,
possession notice will be given.
no, first is 13.2, followed by possession notice, section 13.4. Then based on the possession notice, the bank will file section 14
After
applications.
that, what will follow?
Then immediately after obtaining the order, certificate copy, where we are not the parties, under
Yes,
section 14,
yes.
they will not give.
After that, what will happen?
I approached the DRT challenging it to set aside the order passed by the magistrate in view of the non-classification of the account is erroneous. Simultaneously,
Professor,
I approached the Honorable High Court of Dharwad, wherein my prayer was the entire measure.
please come to section 14.
Yes, my lord. Chief Metropolitan Magistrate, District Magistrate to assist the securitors. This section 14 clearly says the securitors has to approach the magistrate for to seek the assistance of the jurisdictional police.
15.
Section
15. Section 15.
manner and effect of takeover management. That is takeover management.
What I'm trying to understand is, you are not a party in section 14 proceedings.
Yes.
You will be knowing about section 14 proceedings at what stage?
When they come to the bank, come to the residence property, when they want to seize the
So,
property.
in the facts of the case, when did it happen? In the facts of the case, when did it happen?
I came to know only after 260 days because when they came to the,
Must have stated so. You must have stated in your petition, when that day,
Yes.
you have to be specific on that.
in my application,
Please come to the application.
kindly page number 30, my lord, when I filed my application before DRT,
Page number.
page number 30. This is the application I filed before the DRT.
Let's see, what did you state?
The applicants here must submit that the above case has been filed challenging the order dated so and so passed by first for taking physical possession of the scheduled property. The appeal is not filed within 45 days of
No.
the order.
Then in the facts, we have to know, when did you know about this order?
Section 14 order.
Yes.
That after obtaining the certified copy from the magistrate court, we have approached the DRT by a delay of 260 days. That I have mentioned it, 260 days.
Yes.
The DRT said delay cannot be cut down.
Mr. Counsel, as per you filed your objections in this. As per
I
your
filed my
objections,
synopsis,
after section 14 order, what has happened? What was the communication between the bank and the borrower after section 14?
One intimation letter has been given, my
When
lord.
is that?
Page number 75, I have applied for the certified copy.
Did you say so in your objection?
It is on 24/7/2024, my lord.
24?
7/2024.
When was this, the order under 14 is?
Order under 14, my lord, it is on
Yeah, 1 minute, okay.
3/10/2023, my lord.
3/10/2023.
2023, my lord.
Hmm.
And they have challenged that order before this honorable court in earlier writ petition 1066/2024 of 2024 on 20/01/2025.
20?
01/2025.
21?
20/01/2025, my lord.
21st January?
2025.
Went to the tribunal when?
Kindly see by page number 39, my lord, for a moment,
Yes.
wherein I have filed application under section 5 of the Limitation Act to condone the delay. And in my affidavit has stated at para number 4, page number 40.
Your affidavit.
Page 40. I state that when I received notice from the respondent on 24/7/2024, that is annexure A2, I came to know that the respondent bank has obtained the magistrate order on 3/10/2023 and took symbolic possession of the property. After I collected the copy of the magistrate order and consulted the advocate of filing so that from this date, after obtaining this magistrate court
Your
order.
limitation starts from 24/7.
Yes,
So when did you approach?
yes, my lord.
They have approached this court on 3/8/2024, my lord.
Hmm?
3/8/2024.
3/8/2024.
Ought to have been filed on 17/11/2023, as observed in the impugned order at page 20, my lord.
It is 24/7/2024. You ought to have filed when?
3/8/2024.
24/8 plus another 15 days from there. It will be-
45 days.
45 days.
No, 24/7, then that's 24/8/2024. From there, another 15 days.
Yes.
How,
My lord, they were in knowledge, my lord, because they have filed the earlier writ petition, my lord. Earlier writ petition filed on 7/11/2024.
7?
11/2024.
Much before that, they need to.
Yes,
file it.
my lord.
Hmm.
And it was disposed on 20/01/2025. Earlier to that, there were three earlier, every notice has been challenged.
So by 9/9/2024, that 45 days from the date of his knowledge expires. That you have not chosen to go before the court.
No, no, here,
Forget about the date of 14. Subsequent date of your knowledge, even if we consider that.
yes,
Still 45 days will lapse
yes.
by the time.
But the copy which I have obtained.
No, that is not the concern
Yes.
of the court. That is no, from your date of, from the knowledge. Whenever you appear, you have to apply within 45 days. Now, I can understand you claiming that, that because I'm not a party to the 14 proceedings, I'm not aware of it, so I cannot approach the court.
Yes.
Then there is a logic in it.
Yes.
After knowing it, your ball starts rolling. That limitation, you have to be within 45 days, which you have not chosen to appear. Go before
So-
the court.
No, no, I have applied that the 310, the magistrate court order is 310.
When you
And,
have, when you have
I
knowledge,
received the notice from the respondent bank on 24/7.
I am counting it from 24/7.
And I approached,
And your limitation will conclude on 9/9/2024,
no, I have approached on 3/8/2024.
where,
Application filed before DRT.
when is that?
Page number 39, it is my application filed under limitation 5 of the limitation at
I
3/8/2024.
submit that when I received the notice from the respondent back on 24/7/2024. I came to know about that. Bank has obtained magistrate order and took symbolic portion. After I collected the copy of the, where from one can understand, after I collected the copy, after I come, when
No,
you
no,
have come,
no, kindly see my page number 35, when I have filed my application before DRT.
where is that?
3/8/2024.
Where is that?
That
30?
essay 385/2024, which I have filed before the DRT,
Ah.
3/8/2024, page number 35. And even on limitations, the page number 39, 3/8/2024.
Counsel,
3/8/2024.
yes. Will condone the delay.
Now, much before that, my lord, only one submission I will take, my lord, to assist the court, because I am also hearing so many matters being heard by your lordship. The Surface Act is a special enactment which has to be followed according to the provision of the act. The very classification of the account has to be classified in accordance with the RBI guidelines. The RBI guidelines are statutory in favor. It is mandatory. Before issuing the demand notice under section 32, whether the bank has followed the provision of section 2 of the act, 2C, 2FG, whatever it may be. Then the master circular which my learned brother counsel has submitted to the court, all RBI circulars. What it says is, NPA should be classified if the account is not serviced for more than 90 days, either an installment in case of a term loan or interest in case of overdraft limit or cash credit limit. Earlier it was 180 days, it was brought down to 90 days. But in case of MSME, this special scheme is there, that is separate issue. Here, before issuing the demand notice, whether the bank has followed the provision of the act in classifying my account as NPA or not. 2 says that before classifying, whether the account is not serviced for more than 90 days, it is overdue. Whether it's a doubtful.
As per the act, there is no notice for that.
Which one? So
Before I-
section 2 clearly says,
No, classifying the account as an NPA.
2O
Uh,
is mandatory.
Let's
That
see.
has to be followed.
Let's,
That has to be followed. 2O. Bear it. This is a draconian law.
1 minute. Section 2?
2O.
Yes.
Non-performing assets means an asset or account of a borrower which has been classified by a bank or fund as substandard, doubtful, or loss assets. To more clarify, my learned brother, I'm very thankful to him. He has submitted the guidelines which clearly says the RBI guidelines he has submitted. I may permitted to take your lordship. In their objections, definition of non-performing asset is there. What is non-performing assets?
1 minute.
That is a circulars which comprising of more than, I think, 100 pages. It enlightens what is non-performing assets.
Page number.
The page number here, last, there page ಬರ್ತಿಲ್ಲ, page number has definition in the objections.
No, any of that synopsis, table of contents is there.
Non-performing asset means a non-performing asset is a loan or advance where interest or installment of
You
principal.
have the page numbers there on that. Without, not the running page.
These are
Bottom of the page, bottom
one,
of the page
one.
you see. Which page you are
34,
reading?
my lord, 34 page.
Yeah, page number 1.
Yes, read.
Yeah, 2.1, to definition. An asset including that a non-performing asset is a loan or an advance where interest and or installment of principal remain owed you for a period of more than 90 days in respect of term loan. The account remains out of order as indicated para number 2.2 below in respect of overdraft. That is for bill discount, that is separate issue. Here his question is, when the banks find out he has failed to pay the installments for more than 3 months, that has to be classified as account as NPA in term loan. Whereas the interest is not service in cash credit and OD account, then it has to be classified as O. Suppose if he upgrade the loan account, that 4.2 also RBI states that once the account is regularized, then it can be upgraded. Four point 2.5.
4.1.
4.2.5 is page below 6.
No, 4.1 says about categories of NPAs.
NPA. Here 4.2.5 says upgradation of loan accounts classified as NPA. The moment you pay the arrears of interest or overdues in case of term loan, because overdraft you cannot upgrade because it's yearly. Every financial year ending, it has to be renewed subject to complying some certain formalities. So bank cannot upgrade the in case of loan account of overdraft and cash credit. Then 4.25 means
Yes.
4.25 in case of housing loan. When the period is unexpired, another 10 years, 8 years, 3 years is there, then bank can collect all the overdues, then can upgrade the loan account. Once the loan account is upgraded, then it's no longer be classed as a non-performing asset.
Submissions are made every time that once it is declared as an NPA, we cannot do anything.
No, this is all because I have seen, I have heard, I may permit to elaborate this with my virtue of my banking experience of 20 years. I may permitted, my lord. Here, the 13.2.
Yes, Mr. Vignesh Shetty, is it not the submission generally?
It can be, my lord, I think it can be regularized. Subject to, my lord, there are few criteria. One, my lord, for example, we have given a loan for particular purpose, some unit. The unit is not running. Even though, my lord, they wanted to pay, we can't regularize.
No, it is like this.
Otherwise, it can
Now
be
the bank becomes, now the account becomes a NPA. Then after that, he is ready to pay the amount as per the upgradation of the loan accounts as classified. And in that case, why should you go ahead with the surface?
Lord, there is a scheme for restructure also, my lord. This is a restructured account.
No, not about time, not about
According
this
to
case.
me, according to me, my lord, if the housing loan, it can be my lord, regularized, even subject to my lord overdue.
How it will be regularized?
Regularized, my lord, it is all the time, my lord, in
No,
fact, my
for
lord,
example, now once it is declared as NPA, and after that, that person comes and pays whatever is the outstanding EMI.
Arrears of
Then
installment.
Arrears of
Installments.
monthly installment. Then it will be.
it
Yes,
can
my lord.
be subject to my lord, there is no fraud, there is, the unit is running or whatever the purpose, my lord, I have
No,
sanctioned the loan.
we are thinking about a house property.
House can be done.
So
According
they,
to
they
me,
will pay after 90 days, they'll pay the EMI, whatever
It can
the
be done.
three, now 90 days amount, it has to be, the whole 3 months it has to be paid, or by paying 1-2 months it will be regularized.
according to me, my lord, all the overdue it has to be paid and it has to be regularized. What my lord, which I read, my
That
lord,
is in respect of a residential one.
Residential
It is in a commercial loan.
commercial property, my lord, there are certain hitch also. If, for example, I filed a suit, already filed a OA before the DRT.
No. We are talking about a situation where immediately after you declare it as a NPA, at the stage of 13. Now, when will you issue 13 to notice?
My lord, any, after NPA, my lord, very next day also I can issue.
You can issue. So,
SMA1,
once you issue a 13-2, party comes and says, gives a representation saying that whatever is that overdue, not the entire
Can
amount,
be regularized.
that overdue,
It can be
I will pay, so you have to,
I have to regularize.
that's not the bank doing.
Regularized provided the unit is functioning
In commercial.
Different
in
aspect.
commercial case.
Because to that extent, why should you go? You are only due
I
with the 3 months,
many cases will
90
be
days
regular-
period.
many
When
cases
they're
will-
ready to pay, you don't have to look into
Cases
other
we
things
regularize, It is
also.
permissible. It is permissible.
But I hear from the council
No,
that
it
it
is
is
not so.
not.
I
Then
never-
now coming to the next aspect with regard to the limitation under this section 17. Now, it says about any proceedings after the section 14.
13,
14.
4.
So admittedly, as per the settled law, no notice is required to the borrower under section 14.
14, because it's a
Yes.
only mentioned. my lord,
So if it is not, whatever is the next communication,
Lord,
that's
according to
from
me,
the
the
bank.
notice which I issued, my lord, the 7 days notice or whatever, I'm going to take a physical possession of property. From that day notice.
That will be
or
sufficient.
from the date of 13/4. Yes.
Or from the date of?
13/4. Because that section 14 is, my lord, what act says, my lord, agreed by the measures.
Usually 13-4, when a notice is issued for a 14 order,
That is
sometimes it
some
takes years
ambiguities.
together.
Some ambiguity.
So what I'm thinking is, as far as these kind of cases where immediately after their notice under any of the proceedings after 14, if it is in their knowledge,
This
it should
put
suffice
held in
for,
some- This honorable, my lord, what will happen sometime 13/4 I'll issue today. I'll file a section 14 after 1 year or 1.5 years.
So it
my
can't
lord,
be from
because
13/4.
I need not to issue a notice to them under section 14 because magistrate have
Yes,
only ministerial
yes.
power. Then after 3 months or 4 months, I'll go to the possession of the property. From that day, my lord, delay
it should be 45 days. That should be reasonable.
from that day.
Yes.
One submission, my lord. When you issue 13-2 notice, there is a statutory notice. It is issued under section 32 of the Act. When you issuing notice under section 32 Act, you have to follow whether the account is standard, whether it's a substandard, whether it's a doubtful, whether it's a loss assets. Then whether he has serviced the account or not. Those, that is called yardsticks. Without complying that, immediately 3 months he has not serviced, NPA. 3 months he has not installment paid, NPA. When the property is worth about more than 20 crores, 10 crores, whatever it may be, or double the amount, or 3 times worth, can you consider this as a doubtful asset? Or is it a loss asset? Whether it is a substandard assets? No. Immediately non-performing assets. 3 months he has not deposited, yes. Yes, what my brother says, yes. Unless you establish the fraud, diversification of funds, then you are not entitled for that. Bank can recall the advance. In these cases, whether bank is following this procedure at the time of issuing 13-2, in so far, no bankers, without classifying the account as per RBI guidelines, 3 months he has not deposited, yes, issue notice. What is non-performing assets? The basic concept of non-performing asset has to be analyzed first. Without that, NPA. In my interpretation, as a terminology, in a humor manner, I will say, non-performing assets is not money. He is a non-performing authorized officer. He doesn't know the banking, first of all, to classify my account as NPA in contrary to section 2 of the Act. One of the example I'm permitted to take your lordship in what section 13.2 he has issued a notice.
In your case.
Yes, in my case. How he is a non-performing authorized officer?
Where is
I
that?
want to establish this.
Yeah.
Page number 77. Page number 77. Hope your lordship got it.
Yes.
Directly I will take it to your lordship with your permission. Serial number 5. What it says, on account of the failure to repay the dues as is required, the bank in terms of RBI guidelines, very important, as to the income recognition and prudential accounts norms, classified the above outstanding account as non-performing asset on 27/12/2023. That would have been sufficient. That would have been sufficient. Then I don't have locus standi to urge that bank has not followed. Kindly further sentence. With effect from 27/9/2021. Where is this concept? Where they have invented this? When you say with effect from 27/9/2021,
What is the date? That is the date of taking loan.
with effect from 2021, the account was classified as, it is restructured. Then how you classified my account as NPA from 2021, my operations are being allowed, and the statement of account which I furnished, and this court on the last occasion, in that order sheet has mentioned that I have submitted one loan account and I have not submitted the other loan account. Hence the interim order, if any granted, it will automatically get vacated. No, it is not so. There I have submitted both the loan accounts, page number 95, maybe, page number 95. So this was not noticed. Hence the interim order though says that I have not submitted this statement of account. It is very well available at page number 93. There are two accounts, page number annexure K and annexure L. So both the loan accounts I have submitted. Hence I thought it is not proper again to submit the same statement of account. Hence that interim order clearly says, if I don't submit this statement of account, the interim order gets automatically vacated. No, it is not required because page number 90, the annexure A, it is available.
When was that order passed?
Yes, my lord. That also I submitted at my page number
No.
145.
Date of the order.
145. I have mentioned that I have enclosed. The date of order is
Both the loan
10
accounts
to
are same. my lord.
2025.
10/4?
10 to 2025, page number 145. I have enclosed it. I have submitted
By whom?
by this honorable court.
Page number 140.
145. That order also I have submitted.
Lord, page number 96, 117 and 140 together to be seen, my lord.
And this one,
Similar statement of accounts.
this order, when I approached the Harvard court under section 14, this is the order to deposit 25 lakhs rupees. Partially completed, I have modified this order. I have modified this order. This order is passed in on by this court. 27/3/2025. 27/3/2025, where it states he would seek to lay emphasis upon a fact that the declaration of the account as a non-performing asset itself is erroneous, as the petitioner claimed to have transacted after the declaration of the term loan account as NPA for close to 2 years. So both the loan accounts are submitted here. He would take this court to several account statements, both of which are overdraft accounts and not term loan accounts. This is where the court has done the, whereas I have submitted at page number 90, which is already available. Wherein the court, Harvard court, that is what is got, it get confused. Harvard, I have challenged section 14 to entire measures, because the demand notice, what it says is, with effect from 27/9/20,
Question before the Harvard court.
entire measure, that is a measure, this is an order.
That includes section 14.
Section 14 order I have a challenge. There I said, this court has got the power on question of law, stating that my account is not a NPA. When you say of 27/9/2021,
You are on 2 points about the limitation before the DRT.
That is
And the
limit.
second aspect is with regard to this,
Classification.
declaring your classification of your account as NPA is bad.
yes, when the account is classification of account is bad, the very invocation of 13 to 13 for even 14, the measure which you have taken, that has to be set aside before the The challenge before the Honorable Dharwad courts entertained my application subject to some condition, which I partly complied. Another party could not able to comply. Then there also I have made a mention that I've already challenged the order passed by the magistrate court. It got dismissed. Based on that, that order was passed stating that, no, it's already, it is dismissed. No, it is not so. No doubt, the court has dismissed my application in the Dharwad bench petition. But here, without considering the limitation on question of law, merits of the case, it also got dismissed 260 days delay. My question is, when my account is not NPA, if it would have stopped at 27/12/2023, then I would have been no locus standi. But when I operate is both term and OD,
They are referring it to the date when your account is restructured.
21 backdate, then how you,
Restructuring the account.
how you have allowed?
No, I'm trying to understand the.
Yeah,
facts.
please, my lord.
I'm saying, after you have account is restructured, when you fail to pay the amount, then that is relating back to the date of restructuring.
They cannot go back to restructure. Yes, even if I say, when you are non-performing assessment, the account should not.
From these RBI guidelines.
Yes.
Please point out to the court.
Page 92
how
may be
it
seen,
has
madam.
been dealt with. What are the guidelines with regard to how to deal with a restructured loan NPA?
Even restructure loan also.
Page 9.
Yeah, I mean, only 1 second. Restructure also. Kindly see page number 80. 80.
Of this.
My petition.
Yes.
Page number 80. Serial number 3 on the right side. When you restructure, kindly see LOA. LOA means letter of authority. 29/6/2021. Even in their affidavit, kindly see, my lord. Affidavit. Page number 63.
Of the same paper.
Same. Affidavit filed by the bank before magistrate court. Para number 3. There also. No, there only LOA is there. Here clearly mentioned. Also letter of authority dated 29/6/2021. When such being the case.
So what I'm asking you is, please come to the RBI guidelines.
Yes.
Then with regard to this NPA, with regard to this restructured loan, what are the guidelines? Please point out that.
May I just point out, my lord?
Yes.
Page 92, my lord, of the
your
RBI
this
guidelines.
guidelines.
Yes, my lord.
90?
92.
Yes.
Para 17.2.6, my lord.
1 minute. For para?
17.2.6 from bottom, my lord.
2.6, yes.
If a restructured asset, which is a standard asset on restructuring in terms of para number 20.2, is subject to restructuring on a subsequent occasion, it should be classified as substandard. Now the point, my lord. If the restructured asset is a substandard or doubtful asset and is subjected to restructuring as on a subsequent occasion, its asset classification will be reckoned from the date where it become NPA, my lord.
Then.
No, you please answer to this.
Yes,
17.2.6.
2.6.
2.6 at page number, bottom page 59.
59.
If a restructured asset, which is a standard on restructuring in terms of para number 20.2, is subject to restructuring on a subsequent occasion, it should be classified as substandard. If the restructured asset is a substandard doubtful asset and is subjected to restructuring on a subsequent occasion, its asset classification will be reckoned from the date when it became NPA on the first occasion. So it means to say, when you have classified my account as NPA,
So.
on 27/12/2023.
This is a restructuring date.
Then 27/12/2023. How you can classify my account as a restructuring when LOA was obtained on 29/6/2021? Letter of authority. That's called deposit of title deeds, which in that affidavit has clearly mentioned 63, page number 63. Page number 60 in the affidavit, that is clear. The said mortgage property was continued as collateral security.
You were also submitting about substandard or a doubtful asset. No, as per this 17.2.6, it says the moment after restructuring, if you have not, if you have failed to pay the amount, or there is again in the default, it should be classified as substandard without any consideration about what kind of asset it is. That is the guidelines. Unless and until the guideline, the RBI circular is questioned, we have to follow what it is. So in classifying an asset as a substandard from the banker, there is nothing wrong. That is as per the.
Then when the very classification of account as NPA as on 29/7/9/2021 itself wrong, because letter of authority taken on 29/6.
Please forget about letter of authority. When your account is restructured, give me the date. Simple. When your account is restructured, what is the date of it?
That is restructured, they are not
I
given.
submitted, my lord.
That is,
It
they are
is
not
in my
given.
synopsis, my lord. Yesterday I had.
Date is?
It's for, my lord, original loan was sanctioned in 11/9/2019 for, it's a overdraft limit, 1 crore 50 lakh. And it ought to have become NPA on 29/6/2021, my lord. And before that, 28/6/2021, they have requested for a restructure. Accordingly, it has been restructured. It has been splitted into two accounts. One on 28/6/2021. 50 lakhs for a
That's
1 crore for.
That's why you're relating back to that date.
Yes, my lord. And restructure, the NPA date was on 27/9/2021. That is why we are reckoning back to the NPA date, my lord. And secondly, my lord, there is no unit is not functioning. And there is no transaction. And transaction should be related with GST issues, my lord. They have to submit the GST details and all.
What are the other guidelines? Then whatever you're submitting, they should be basing on some circulars.
Yes, my lord.
Where is the other one?
My
Which
lord.
you're referring now?
My
That, you know,
lord, regarding
like about the
regarding the
functioning
NPA
of-
classification, I produced the master circular, my lord, which is exhaustive regarding the
So,
classification.
Please.
And in
draw
my
the
earlier
attention
writ
of
petition also, they have sought similar grounds, my lord. And on the similar grounds, I had filed my
What we
objections
do
also.
is, let's not go on the issue on a technical aspect. Let us look at what is the
Please, ma'am.
substantial justice. So as far as the first aspect is concerned, it is clear. Now we are on the second aspect.
Yes,
He's
ma'am.
saying that performing it, declaring it as a non-performing asset relating back to
Yes, ma'am.
21 so and so is bad. Now as far as 17.2.6 is clear on that.
Yes, my lord.
Yes.
No, 1 second, man. That I want to clear it. Letter of authority, 29/6/21. Page number 63. 29/6/21. That's called letter of authority sanction documentation lower. How you classify my account as NPA prior to that on 27/9? But I'm very simplifying my argument. That letter of authority is 29/6/2021.
Do you agree that it can be done from the date of restructuring?
No, 29/6 is a letter of authority. There is sanction. Restructuring sanction, everything will begin on 29/6. How you can go back to 27/1 2 days before?
No. As they can go back to the restructuring date.
Then why they have issued 29/6/2021 letter of authority? Then 27, then they cannot classify my account as NPA as 27. It should have been 29 signs afterwards, after restructuring.
Restructuring date is 29/7.
That they have to submit restructuring. When they have submitted, there was two account, 1 crore and 50. They have splitted that.
They have filed it before the.
They have split that. They have split these two account.
Split it, but the date is that. And as per the RBI guidelines, it is correct.
That suppose
2.6.
they cannot go back on 27/21 after documentation is sanctioned 27/6, 29/6.
That's what the circular says.
Letter of authority is a continuation of the mortgage, my lord.
And then
That's it, my lord. It's just
and they have
confusing, my
allowed
lord.
my operations.
Confusing the honorable court.
It has earned interest. More than 2 years I have operated. More than 2 years.
He was very much in knowledge of these proceedings, my lord, earlier also.
Whatever
He has to go before DRAT, my lord, please.
Whatever the submissions you have made, please file the written arguments.
Yes.
And, heard, reserved by. When can you file? By 17th?
Yeah.
I'll also file my.
By 17th, both the parties will
Please,
file
ma'am.
their.
But I'll just clarify in respect of NPA. For example, my lord, more than one loan,
More than one.
one loan. The one account is NPA, or my lord, one account is standard account. Because of my lord, other account is NPA. This is also my lord as per RBI guidelines.
Now, after the restructuring, they have split it into two accounts.
Two accounts.
For example, one account becomes NPA.
NPA, other
then
account
other
cannot
will
be standard.
also be as per
Going to
this
be NPA.
17.2.6.
Though it is standard, it will become.
Though it is standard. My lord, second, my lord, my limb of submission, my lord said it can be, my lord, whether once they paid the overdue. My lord, as per the RBI guidelines, my lord, I'll produce before this honorable court. Even
Please
though
give a
I'll
set of all those
please, my lord.
guidelines.
Even though, my lord, their overdue amount is paid, that for the financial year, that account is heading as, my lord, substandard only. It is not going to become a standard account. As per the RBI guidelines itself. However, my lord, it's a discretion of the bank, or my lord, we can withdraw 13.2, or we can, which it is, my lord, most of the cases banks have did it.
Even after payment, once an NPA, forever an NPA.
Not ever. For the it is for the
Financial
financial year. I'll produce that RBI guidelines before this honorable court with point.
Restructuring is in.
All those, whatever the
I'll
relevant things,
certainly-
give it to the court officer.
I'll-
So please file your-
Restructuring is in case of one loan account, you can restructure. But sanctioning and splitting it to sanction,
All
it
your
becomes a
sub-
new sanction.
All your submissions will be considered and this court will pass an order.
Please, ma'am.
Please give your written submission.
Yes, ma'am. Highly obliged.
No signatures. At 2:30, I will take the 2:30 matters, then I'll continue with this list.
Already reserved ಬರ್ದಿಲ್ಲ. Audition. ಬರೀಬೇಕಲ್ಲ.
Madam, list one will only get continued na after 2:30.
2:30 list ಇದೆ ಮೇಡಮ್.
Okay, madam. Thank you.
ಅದು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ಸ್ ಫೈಲ್ ಮಾಡಿ ಅಂತ ಅದು.
ಅಲ್ಲಲ್ಲ, ಅದು ಓದಲ್ಲ.
ಅದೇನ್ ಬೇಡ್ವಾ?
All done reserved.
ಅಲ್ಲ ಅದು ಡೀಲಿಂಗ್ ಅಂತ ಬರೀತೀರಾ ಏನು ಅಂಡ್ ಅಂತಿದೆ ಏನ್ ಮಾಡೋದು?
ಏನಂತ?
ನಾನ್ ಡೀಲಿಂಗ್ ಅಂತ ಬರಿಬೇಕಾ? ಸಾಕಾ?
ನಾವು ಡೀಲಿಂಗ್ ಅಂತ ಬರ್ತೀವಿ. ಇದು ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಇದು ಗೈಡ್ಲೈನ್ಸ್ RBI ಇದು ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಇಲ್ಲಿಂದ ಇದ್ದು ಇದು ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದೆ ಜೆರಾಕ್ಸ್ ಮಷೀನ್. ನೋಡಿ ಸರ್, ಇಲ್ಲಿ ಫ್ಲಾಪ್ ಹಾಕಿದ್ದೀನಲ್ಲ, ಈ ಫ್ಲಾಪ್ ಹಾಕಿದ ಇಂದ ಫುಲ್ಲು ಎಂಟೈರ್ ಇದಿಷ್ಟು ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಕೊಂಬಂದು ಅಲ್ಲಿ ಮೇಲೆ ಇಡ್ಬೇಕು ಅಂತ ಹೇಳೋರೆ. ಅವು ಅಶ್ವತ್ಥ ಬಂದ ಅದೊಂದು ಜೆರಾಕ್ಸ್ ಹೇಳಿದ್ದೆ. ಹಾ,
ಬೆಂಚ್ ಇದೆಯಲ್ಲ ಸೆಕೆಂಡ್
ಯಾವ್ದು ಸರ್? 10 12 ರಿಸರ್ವ್ಡ್, ಹಾರ್ಡ್ ಅಂಡ್ ರಿಸರ್ವ್ಡ್. ನೀವು ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಿ ಅಷ್ಟೇ.
Pertaining to this property, I'm not. I don't know whether we are going. The 230.
230 list. List number 2 for hearing on interlocutor application 1, Vijay Kumar T.
Appellant, my lord. My
Where
lord,
is that?
number for one dispensation, my lord, judgment, my lord.
Why?
My lord, I have produced the certified copy of the judgment.
No,
in
that's
the-
true. Why you couldn't file the? Not that you have filed it
Produced the-
in some other case.
I have produced the certified copy in.
No,
some-
why you can't file it? That's what I'm asking. There should be a reason for not filing. I can understand you filed in
Okay, on
respect
that
of the.
reason only,
Huh?
only on that reason, my lord, I
Huh?
have not produced this certified copy of the judgment, my lord.
What? I didn't get you.
My lord, I have produced the certified copy
I
in another
understood.
appeal.
If you are not able to produce a certified copy for some reason, what is the reason?
Only on that reason only I am not produced, my lord.
That's what I'm asking.
In MFA number 8102 of
That's what I'm asking. 81?
02 of 2025.
The IA is filed seeking to dispense with the production of the certified copy of the judgment as he has already filed the same in MFA 81?
02 of 2025.
02 of 2025 accordingly. I number 1 of 25 is allowed. Yes.
My lord, R1 notice may be dispensed, my lord.
Memo is filed seeking dispensation of notice to R1.
Also is
dispensed with-
Magma General Insurance Company.
Which one is that?
Magma General Insurance Company.
Who appears for Magma?
My lord, B. Pradeep.
Apart from Pradeep?
I don't.
Where is the list? To all these judgments. Send it to the chamber. Where is that list? Mr. B. Pradeep is directed to take notice on behalf of the insurance company. Any delay?
200,
Huh?
278 days delay in filing.
I number?
I number 2, my lord.
I number?
25.
2 of 25.
I number 2 of 25 to condone the delay of so and so. Condone on condition. Admit final hearing TCR.
Cell number 2, Kailash Shankar.
Notice to respondent.
Filing dispensation.
Notice to?
R1.
Memo is filed seeking dispensation of notice to R1. Dispense with the risk of appellant. R2?
Reliance Insurance.
Huh?
Reliance.
Reliance, who appears? Shivanagoda appears?
Please.
He appears or not?
I think he is no.
Appears? Mr. BC Shivanagoda is directed to take notice on behalf of the insurance company.
There is a
I
delay
number
of-
1 of 25 to condone the delay of 224 days. Condoned on condition. Admit final hearing TCR.
Cell number 3, preliminary hearing.
Yes.
Girish Kumar.
Yes, sir, respondent, my lord. My
Any
lord,
interim order in this?
No interim order, my lord.
No representation on behalf of the petitioner. Liz is matter in the month of January. Next 4.
Cell number 4, Jagdish Chandra.
Here for the petitioner, Mr.
Yes.
Lord. Husband petitioner challenging the interim orders passed under 125.
How much is granted?
30,000 is granted. 10
Only
children.
the wife or the,
Wife and kid, my lord. As far as the kid is concerned, I'm not, child is concerned, my lord, I'm not.
how much is granted to the wife? How much to the?
20,000, my lord.
20,000 to the wife?
Yes, my lord.
10,000 to the child?
Yes, my lord. Child, I'm not interfering, my lord. As far as she's concerned, she has clearly admitted in her affidavit that she's earning basic amount of 18,000 plus perks.
What is your salary?
About 1.8 lakhs, my lord, but I have aged parents where I have already commitment. 1.4 lakhs is already my commitment. But she has suppressed the fact that she was earning that 18,000, my lord. Apart from that, my lord.
Earn 1,08,000, 80,000, still you have commitments.
Yeah.
Wife earns 18,000 and you can't pay maintenance to her.
Well, as on date, my lord, as per the order, 30,000.
Understanding that she's earning 18,000, will it be sufficient for her to
Plus
live?
perks that she has not elicited, my lord. Actually, it is more than that. She's
Let her come,
like,
we will see. This is not a case where we have to stay the order.
no,
Yes.
well, one submission, my lord. As on date, the order passed by this honorable court is from the date of application. It amounts to 8 lakh rupees. I've already paid 10 lakhs. My page number 14, 16 may kindly. I given details, I have remitted entire amount as on date. There are no arrears as on date, my lord.
No, in that case, why do you want stay?
They have filed an execution, but up to date.
No, if you file the execution, you will show that I have paid already more than the amount.
Yeah.
Then there is no execution
No,
then.
no, my lord, what has happened? This petition was filed under criminal petition. Subsequently, it had to go back and then about 5-6 months have taken place. So therefore, that arrears, about 2-3 months arrears are there. They will unnecessarily require, my lord. Up to, there are no arrears, my lord, as on date. It gets accumulated over a period. Until then, as far as the wife is concerned, my lord, to that extent.
Will not stay. Please take out petition permitted to take out hand summons on the council appearing for the respondent.
Yeah,
And
before
shall
the
file
trial
a-
court, ma'am. I will serve on the notice.
Yes, for sure.
That
And,
word may be mentioned.
On such memo, once the memo is filed, is the matter.
Till number 5, MD Raghunath.
Appearing for the petitioner, my lords. With petition 69 of 91 of 2025, my lord. It's listed tomorrow, my lord. I pay this honorable court to tag along with that matter.
Write on a paper, list along with so and so.
Till number 6,
Appear for the petitions council, my lord.
Darini.
Father is before this honorable court.
Yes.
Who is deprived of seeing the child for the past 2.5 years. In spite of there is an order passed by the family court, the father is not able to see the child because the family court has passed an order stating that the child to be produced in the family court premises. My lord will get the order copy at page number 73. At 73, page number 73 may kindly be seen. The operative portion would be,
So it is fixed at the visitation room.
yes, my lord, the unfortunate part is that even this visitation right is not complied with. My lord, at gets to page number 76.
For that, you have to file a.
No, we have filed it. My humble submission is that that may not be an efficacious remedy for the simple reason that we are placed on record the copy of the application which is filed. My lord will appreciate this vital aspect where the table which I am handing over, what is the compliance status in so far as the visitation rights which are already granted in favor of the father on those dates. Kindly see the dates, my lord.
No, what do you expect this court to do?
I am seeking, I'm two reliefs I'm seeking from this honorable court in terms of the modification of the visitation order, which is passed, which is my main prayer before the court. My lord will see the prayer. What I am before this honorable court is at page number 11. What visitation right which is granted at page number 76 by the trial court, even though grossly disobeyed by the respondent, is inadequate for the reason that the trial court confines or limits the visitation right on every first and third Saturday and prescribes a time of 11 a.m. to 2 p.m. And I have been bearing the education expenses of this child, and the 2.5 years, the petition was filed long back, 2.5 years, and as per the table which I have just furnished, last time I saw the child was 21/6/2025. For which I have filed an IA under section 12 of the GNWC Act. In my respectful submission, when GNWC Act, my IA can be confined only in respect of disobedience of the inadequate visitation right already conferred in my favor. If I need to, I have to be very.
Good about it. No, when you're specifically saying about the disobedience, I said, you want a modification of this order that can always be solved.
Yes, my lord,
The petition is permitted to take out hand summons on the council appearing for the respondent before the trial court and shall file a memo to that effect. Once the memo is filed, list the matter.
My lord would consider some interim arrangement since father is deprived of the child.
Not in this,
My lord, kindly appreciate the aspect, 2.5 years in spite of, I'm not bringing in the monetary aspect of it. No, no.
unless and until in these cases, court understands what's happening by hearing the other side. I have never passed not even one ad interim order in these kind of cases, because I have to hear the other side. That you can, if you serve the notice for tomorrow, day after tomorrow you file a memo, I'll take it up the matter.
Would my lord consider fixing a date for this matter?
But I said, the moment you file a memo, the matter shall be listed.
I'm obliged. my lord.
Yes.
Cell number 7, admission matter, Tejasan.
Notice to the respondents.
Cell number 8,
Notice,
cell number 9,
notice. Yes, continue the list. Passwords.
that one matter.
That you call.
Cell number 65, list number 1.
My lord, this is a case where there is an.
Senior counsel is in other court hall. Kindly pass over, my lord.
You argue with.
They're interested, they will come, my lord.
You argue.
Lord, I've just read two contentious.
Have you informed them that it's taking?
Yeah,
Yes.
morning, he himself made a submission that this matter was to come and it was told at 2:30 it will be heard. So they are very much aware. I also informed the counsel and as well as senior
Now,
counsel.
let's see the prayer in the writ petition.
My lord, what he has challenged is section 14. And subsequent to that, he has challenged his position notice and matter of fact, sale notice was issued. Sale notice has been challenged.
So let's have the dates. Let's have the dates and.
Yes, ma'am.
So 14 notice is when?
So 14.
Order is when? 14 order is when?
Magistrate order is 22/7/2025.
22/7?
25.
Yes,
Sale notice is 24/7/2025.
24/7/2025.
SA 253 challenging the sale notice has been filed by them, 253 of 25.
Essay number?
253 of 25.
Hmm.
My lord, in the sale notice, the court ordered them to deposit 2 lakhs.
Date of order?
2 crores.
Date of order?
Date of order, I have produced the date of order, my lord. It's in my counter. The date of order is 14/8.
14/8/25 is the order, conditional order of?
To deposit 2 crores.
Within what time?
28/8.
By 28/8. Whether that order is complied with?
They do not comply. Same day they get a stay here. My lord,
They file a writ petition before this.
before this, before.
This is the writ petition.
This is the writ petition.
Whether the writ petition discloses about filing of the essay?
Not at all.
Hmm.
They suppress that. Same day, and my lord,
8th is the day when they have to pay the amount. That day
Yes.
they will come here.
before that they have filed, they come before this
It was
court.
filed on 1/9/2025.
Yes, my lord. After that, they get a stay. Stay, wherein they suppress the sale notice.
Hmm.
And lordship may kindly see, they get a stay for the entire proceedings. So the sale, I'm not able to.
The stay, what
Yeah,
is the?
Yes, my lord, the interim order.
What is the
The
interim
interim
order,
order.
on what ground it is granted?
136 is there.
This is, my lord,
Dated?
28/8.
Hmm.
Exactly.
How come this is by whom? Writ petition appears to be 1/9. How there is an order on 28?
My lord, here,
Let's read this order.
yes, my
The
lord.
petitioner
Dr.
agreed.
Sri D.R. Ravi Shankar, learned senior counsel for the petitioner is heard. The grant of interim order, the petitioners are agreed by the proceedings under the Securitization and Surface Act, including the order dated 8/7/25, criminal miscellaneous 87 of 25 on the file of the civil judge Kodugu. The learned senior counsel submits that the borrower is indisputably an MSME. The petitioners must have the advantage of the procedures that is contemplated under the notification dated 29/5/2015 issued in exercise of the powers conferred under section 21 and 35 of the relevant act and identification of the petitioners account as an incipient stress as held by the apex court in Bonet's case. So and so, the petitioners have filed the representation for process of identification, and the record should have been the first petitioner account is declared as NPA, paving way for the commencement of the proceedings under the Surface Act. Dr. Sri D.R. Ravi Shankar.
All further proceedings are stayed.
My lord, and my lord, there is a condition here also by this court that the first petitioner will file an affidavit furnishing the details of all the assets, that there would be no dilution of the assets without expressing leave of this court in consideration of the above. This is affidavit, no affidavit till today has been filed. Lord,
What is outstanding?
33 crores 47 lakhs. 22
Enjoying a blanket order.
blanket order, my lord.
33 crores.
33 crores 47 lakhs 22,957. Now, my lord, what has happened is I had relied upon a Supreme Court judgment.
Pass on.
We have. I just take your lordship before I go to the citation. Two notifications, my lord. The first notification is the framework itself, because all the confusion is because of the framework.
With regard to the MSME.
MSME.
Well, how much, there is something like, if it is about 25 lakhs.
Your lordship has said, I have produced that also for your lordship's consideration, because your lordship was telling us last time. My lord, this first framework is of the 29th May 2000.
Amount borrowed is 30 crores.
Amount is not borrowed, but outstanding, as per the notification, the outstanding should be less than.
It is this particular 30 lakhs or 25 lakhs, what I was referring to, that is with regard to the amount outstanding or amount borrowed.
Outstanding, my lord.
Where do you get that?
That is in the.
Revised on-time settlement or where?
That is on the second one, my lord. MSME. If the second notification, revised out, one-time restructure settlement, second page, my lord, MSME. If your lordship goes to second page, MSME, the borrower should be classified as an MSME as on 31 March 2021 in terms of the Gazette notification. The aggregate credit exposure, including second page, eligibility, below eligibility.
Like you have the numbers 1, 2, 3, 4. I'm looking at the framework for the revival and rehabilitation.
This is the first one, my lord. The second one.
Revised one-time restructuring policy.
Next page, second page. Your lordship may change it.
Yes.
Next page. There is eligibility and MSME.
MSME.
MSME. The borrower should be classified as an MSME as on March 31st, 2021 in terms of the Gazette notification. The aggregate credit exposure, including non-fund based facilities of all lending institutions to the borrower, should not exceed 25 crores.
So,
Lending.
as per this, about 25 crores, then the
As on
procedure
31.
is not applicable.
May not be. But
No, there is this is not the one. I have seen the other notification.
But anyhow, my lord, I rely on the first notification which I have produced. Your lordship may look into the first notification which I have given. Your lordship, this is the framework on which all these litigations that are happening. The framework for revival and rehabilitation of micro, small and medium enterprises.
No, without even looking at it, you please tell the court what is the procedure to be followed in MSME.
Para 1, Para 2, Para 3, all have to be followed, my lord. Para 1 is identification of the MSME by the borrower or by the bank.
When you grant a loan under the category of saying that this is an MSME and we are granting the loan.
That was not the case in ours, my lord.
I'm asking you. If that is the case, then there is no question of, because you are aware of it.
No, my lord, that's why I said, my lord, paragraph 2 and 3 become very important. Because you might grant an MSME loan, but we will not know when it is in stress, when it is incipient, when it's going to become, when the company is going to fall. It is the onus on the borrower to come and say, I am in a stress, I am facing problems, this is my accounts, this is the sales, this is the problem. Only on material that is available to us.
Here the issue is declaring an account NPA, which is otherwise and which is a MSME account, there is a distinction. So once you grant the loan, treating it as an MSME unit, and there is a default on the part of the borrower, then what is the procedure? That I'm asking.
This is the procedure, man. If your lordship looks into it, identification by, that's paragraph 1. identification by banks or creditors before the loan of micro, small or medium enterprises turn into non-performing assets. Bank and creditors are required to identify incipient stress in the account by creating 3 subcategories. And so first is the identification. First you identify. Let us presume MSME, we know it is identified. Paragraph 1 is covered. Then what happens is paragraph 2. Identification by the enterprise. Any micro, small or medium enterprise may voluntarily initiate proceedings under the framework if the enterprise reasonably apprehends failure of its business or its inability or likely inability to pay the debts. And before accumulated, once I'll just finish this message. Before the accumulated loss of the enterprise is equal half of more of its entire net worth. Paragraph 3 is very important. The application for the institution of the proceedings under this framework shall be verified by an affidavit of an authorized person. This is mandatory, my lord. Otherwise, if paragraph 1 is only considered, then paragraph 2 and 3 will become redundant. If they need not file an affidavit, then these paragraphs will have no value or no meaning. Then subsequent to that, paragraph 4, when such a request is received by the lender, the account should be processed by SMA. So until we get these 3 processes done, question of we bank proceeding and giving them the benefit will not arise. So what the Supreme Court also held is paragraph 1 cannot be looked into in isolation and hold that any MSME is the duty of the bank. Paragraphs 2 and 3 have to be considered. They'll have to file an affidavit. They'll have to produce material. What sort of is a micro MSME? Is it a macro MSME? Is it a medium? Only after determining these
For
MSME.
example, you will issue a notice under 13.2. Under 13.2, they will come up with saying that I'm a MSME. Then what will you do?
My lord, if they come out with an affidavit has to be supported along with materials. Only after they're giving us the materials.
So what happens is when under 13.2, they issue taking your notice and they give a reply to you under 13.3a. What you will do is, you don't even answer to any of that. Simply say your account has become an NPA, as such nothing to be considered, and you will go ahead with 13.4.
My lord, your lordship is asking in a general category. Your lordship is asking.
General sense.
My lord,
Because all banks are working under these guidelines, so we have to understand it. There
but
should be a holistic
my lord,
approach.
what the courts are saying and what the notification also says is, my lord, paragraphs 1, 2, and 3 have to be followed. That is, they have to give us the material verifiable documents. They have to give us an affidavit because simply they may come and say us simply.
Going to 2, what is your responsibility? I'm asking. Your responsibility is 1. When you have issued the loan, when you say that is an MSME loan, you are aware of it.
We are aware.
You are aware of it. Then, as per the act, what is the procedure? Let's look at the act. Where is the act?
Lord, I have similar matter which will come up at serial number 31. We'll deal with that, my lord, at serial number 31 because the similar matter is there, wherein 13.3a has been raised by them, which is not the case here. Here, what has happened is.
No, here also they are on that point.
No, they have not.
Interim order when it is granted.
No, they have not answered. They have not come under 13.3a, no representation.
Loan is not granted under the MSME.
No, it was not granted. Loan is not granted under MSME. And 13.3a application has not been filed. Matter of fact, 2 writ petitions are filed before this court, and in both the MSME stand was not taken. And even looking into from any angle, even the last opportunity after 13.2 notice has not been taken by them. They have not said I am an MSME, give me the benefit after I issuing 32 notices. All those things are not relevant to these factors, which is there with regard to the next matter at 31. I'll argue on that, my lord. Here, my lord, I'll just take your lordship to the 2 citations. This Pronet's case and which I have already produced. Citation quoted.
Which is the one, just Deepankar Datta's judgment?
No. This is Pronet's and Sri Swami Samarth Constructions.
You have filed it by way of memo?
Yeah, I have filed it by way of memo on 15/10/25. 15/10/25.
What is the date?
15/10/25.
15/10/25. I don't think it is available.
ಇದ್ರಲ್ಲೇನಾ?
15/10/25.
ಈ ಫೈಲ್ ಅಲ್ಲಿ
ಅದೇ ಗ್ರೀನ್ ಇದೆ ನೋಡಿ. ಈ ತರ ಇದೆ.
ಈ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರ ಬೇರೆ ಪಿಟಿಷನ್?
I'm asking documents which they have filed.
Yes, it's here.
15/5.
Pronits versus Board of Directors, Canada.
My lord, the two things my learned friend addressed the argument, saying one is that since we knew MSME, the first thing is your lordship has seen the second notification. It's a one-time settlement of an MSME. In this case, there is a restructuring that has already happened, and the loan account has been restructured, which we have produced as Annexure R2, showing that the loan has been restructured. Now, after restructure, where is the benefit of another restructuring? That cannot happen. Already the benefit of the one-time settlement has been taken by the petitioners. Now, my lord, the other contention my learned friend argued was that since it is an MSME, we knew about it, then we are bound by the Pronit's judgment. And
Which paragraph?
I'll just take your lordships to page 16. That is, I'll take your lordships to the Swami Samath's judgment.
No, first one or the second?
First one is Pronits.
Pronits. Oh. You want me to look at the second one?
No, I'll one second, my lord. Here I see that Pronits is what I have produced as the first one.
2 to 14 is Pronits.
Yeah, I take your lordships to the other next one. That is the Sri Swami Samath Construction
Yes,
and
15 to
Finance.
19.
Now, my lord, paragraph 5. Just take your lordship to paragraph 5.
Now, this is the judgment I'm saying.
Paragraph 5, my lord. The notification detailing the framework, more particularly.
The other day he was distinguishing this judgment. Read from the beginning.
The petitioner enterprise has executed a loan agreement with NKGSB Cooperative Bank, but has failed in its obligation to repay the loan. In due course, the account of the petitioning enterprises was classified as a non-performing asset. The authorized officer of the respondent number 2 issued demand notice dated 13th of 2024 under section 13(2) of the Securitization Act, calling upon the petitioner enterprise to repay the dues of the respondent number 2 within 60 days. It does not appear from the writ petitions filed on July 14, 2025 that the petition enterprise objected to the classification of the accounts as non-performing assets as well as issuance of the demand notice on the ground that this action of the respondent number 2 was in violation of the notification dated May 29, 2015, containing the framework for revival and rehabilitation of micro, small and medium enterprises issued by the Joint Secretary of the Government of India, Ministry of Micro, Small and Medium Enterprises. Respondent and who having moved an application before the relevant magistrate under section 14 of the Securitization and Reconstruction of Financial Assets and Enforcement Act, a court commissioner was appointed as per the order dated April 3rd, 2025. Such order was communicated by the court commissioner to the petitioner enterprise on June 18th, 2025. Mr. Nedumpara, learned counsel appearing for the petitioner enterprise, submits that it was the obligation of the respondent to identify the incipient stress in the loan account of the petition enterprises, but he did not so identify prior to classifying the loan account as non-performing assets, which according to him is wholly illegal. Mr. Nedumpara further submits that the notification is binding on the leading banks by secured creditors under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interests, and therefore any measures taken under the SURFACE Act without complying with the terms of the framework against the micro, small and medium enterprise would amount to an act of an excess jurisdiction. The decision in Pronit's Board of Directors of Canara Bank, forming a part of the writ petition and though not formally cited, was referred to by Mr. Nedumpara in the course of these arguments in support of his submission. Also, Mr. Nedumpara submits that such a notification bar framework does not mandatorily require any micro, small or medium enterprises to rectify the leading bank account or secure creditor from that of micro, small or medium enterprises wishes to have incipient stress in its account identified. Therefore, any defense that the micro, small or medium enterprises did not voluntarily initiate proceedings ought not to have been allowed to be raised. He thus prayed upon admission of the writ petition and grant an interim order of relief against the respondent. The respondents are not required to, paragraph 5, my lord. The notification detailing the framework, more particularly paragraph 1 of its subparagraphs, have to be read together to make its terms effective and meaningful. although it is a sequence of the framework, identification by banks or creditors comes first. It is immediately followed by the identification by the enterprise. In terms of the subparagraph 2, any micro, small or medium enterprise may choose to voluntarily initiate proceedings under the framework if it is reasonably apprehends failure of its business or its inability or likely inability to pay the debts and before the accumulated losses of the enterprise is equal to half or more of the entire net worth. The obligation of the micro, small and medium enterprises does not end there. For the institution of the proceedings under the framework, the application has to be verified by an affidavit of an authorized person, and upon receipt of a request, the lending bank or secure creditor is mandatorily bound to proceed in terms of the framework and to constitute a committee to identify the incipient states. So, my lord, clearly it says that identifying if the or the process has to happen only after paragraph 2 and 3 of the notification, that is the affidavit.
Look at paragraph 6.
Yes, my
from
lord.
bottom-
Paragraph 6 is also.
From bottom, 5-6 lines.
Yeah,
In
ma'am.
our reading, the terms of the framework do not
Not.
prohibit the lending bank secured creditor within brackets, assuming that it has no conscious knowledge that the defaulting borrower is a micro, small and medium enterprises.
Yes, my lord.
Then the others will follow.
The paras 2 and 3, paras 1, this para 2 and 3 are not, is also, your lordship may kindly see, I just take your lordship to the paragraph 6, what it clearly says. The way Mr. Nedumpara argues us to read the notification and the terms of the framework, if accepted, would lead to the conclusion that every leading bank, secure creditor
Having
under
observed that, the code further
No,
says.
just allow me, your lordship, just I'll complete this. If your lordship goes to a little down, if your
I have read the entire paragraph.
here it says, this could not have been the intention behind the introduction of the framework to aid the micro, small or medium enterprises, which for the reason personal to them is unable to clear its debt and requires revival and rehabilitation of the framework envisaged. If indeed it is only the obligation of the leading secured bank to identify incipient stress on the account, subparagraphs 2 and 3 of the paragraph 1 would be rendered redundant. So what the court says is paragraphs 2 and 3 can't be rendered is very much required to be followed. Paragraphs 2 and 3. That's what the Supreme Court clearly says, my lord. Your lordship, I just take your lordships again to that. If the paragraphs 2 and 3 would be rendered redundant.
Having said so, in the next in the last, that 6 to 7 lines from the bottom at 6, the court has made a distinction. In our reading, the terms of the framework do not prohibit the lending bank secured creditor. Then within brackets, assuming that it has no conscious knowledge
that is paragraph 1 is covered, my lord. What the Supreme Court is saying, para 1 is covered. They need not. Lord, what happened in Pronits was, in Pronits, it said Bombay High Court passed the order. It said it is not the owners of the bank, it is the owners of the borrower. Against which Pronits came before the Supreme Court. The Supreme Court said it is not only for the borrower, it is for the bank. Both are liable. It was with regard to paragraph 1, who has to, and here what the court has said is, we clarify the complex notification.
So that's what after 13.2 they have to come up before the court by
13.3
following that circular
13.3a. 13.3a, the benefit is given to them where they have not come. More than that, my lord, here is a case where there is already a restructuring done. And your lordship will look into Pronits case. I just take your lordship to Pronits case now.
No, in this judgment at paragraph number 7, court says when 13.2 you have not taken that, at a later point of time it is not available. When the 13.2 notice is issued, unless the borrower responds to it with regard to its status, then it is not applicable, is what paragraph number 7 is.
They give another opportunity in this case, saying that in case we have missed the bus before the account turned NPA, they clarified and said, after 13.2 notice, you get a remedy, raise your objection.
Yes.
My lord,
So now please come to this first judgment.
Yeah, Pronits case, my lord. I take your lordships to paragraph 20. That is paragraph 20 at page 12. I have numbered it as 12. Paragraph 20. Therefore, if your lordship got it,
Therefore, the stage of identification of incipient stress in the loan account of MSME and categorization of the special mentioned account category before the loan account of MSE turns NPA is a very crucial stage, and therefore it would be incumbent on the part of the MSME concerned also to produce authentication and verifiable documents or materials for substantiating its claim of being MSME before its account is classified as NPA. If that is not done, and once the account is classified as NPA, the bank, that is a secure creditor, would be entitled to take the recourse of Chapter 3 of the SARFAESI Act for the enforcement of security interest. It is also pertinent to note that the sufficient safeguards have been provided under the said chapter for safeguarding the interest of the defaulter borrower for giving them opportunity to discharge their debt. However, if at a stage of classification of the loan account of the borrower as NPA, the borrower does not bring to the notice of the bank or creditor concerned that it is a micro, small, or medium enterprises under the MSME Act, and if such an enterprise allows the entire process of the enforcement of security interest under the SARFAESI Act to be over, or is having challenged such actions of the bank or creditor concerned in the court of law or tribunal having failed, such an enterprise could not be permitted to misuse the process of law by thwarting the actions taken under the SARFAESI Act by raising the plea of being an MSME at a belated stage. Suffice it to say, when it is mandatory or obligatory on the part of the banks to follow the instructions bar directions issued by the central government and the Reserve Bank of India with regard to the framework for revival and rehabilitation of MSME, it would be equally incumbent on the part of the MSME concerned to be vigilant enough to follow the process laid down under the said framework and bring the notice to the banks concerned by producing authenticated and verifiable documents or materials to show its eligibility and to get the benefits of the said framework. But here, clearly the Supreme Court says to trot the way, you can't suddenly come up and say, I'm an MSME, Pronit's case, give me the benefit. Here, there is a restructuring that has happened. But subsequent judgment, which I am relying upon, clearly says it's not just clause 1. Clause 2 and 3 has to be followed. Otherwise, the clause 2 and 3 will be redundant, is what the Supreme Court has said. So it is not just bringing it to the notice of the MSMEs that I'm an MSME, then everything follows the onus of the bank. It is the onus of the borrower. Subsequent to bringing it to the knowledge of the bank, it is a MSME. It has to produce verifiable material. It has to file an affidavit. Otherwise, my lord, every borrower will come and say, I need restructuring. Where is the affidavit?
What is the other procedure that is contemplated under the Act?
Act, my lord, we are what the petitioner has raised. The petitioner has said that he needs the benefit of the 2015 resolution as per Pronit's. What, my lord, I'm clearly stating is 2015 notification, he has to file an affidavit, he has to produce verifiable materials.
Some judgment with regard to constitution of the board, permission of the board, and other procedure is there under the MSME apart from this. What is that I'm asking? Being an officer of the court, you can at least tell the court.
That we'll do, my lord. That's why that is the, I have not produced here because.
What is that procedure?
Lord, which Lord yesterday, Lord, I addressed in a similar circumstances. Wherein, Lord, I took a contention before this honorable court. Wherein, Lord, that only two, Lord, first and foremost, pronate is the first judgment from the honorable FX court. Lord, where, Lord, either I have to, Lord, identify it as a stress asset, or they have to give an affidavit before me, before classifying the account as CNP.
I've seen some rules where the protection that is given to the MSMEs straight away without, before invoking the SARFAESI proceedings, what is that, prior to that, what has to be followed? It's what is discussed in some of the rules.
I think Karnataka Court, one judgment, Justice.
Not the judgment. I've seen the rules.
No, rule, my lord, SARFAESI Act is silent about it. But it is not talks about, my lord, in respect of MSME. Nowhere. In the rules and.
My lord, 2 or 3 things I want to say, my lord. One is, my lord, their MSME account, they registered it in 21-22. The loan account.
You have the rules with you, the MSME rules? Give that.
MSME rules.
Surface rules.
MSME rules. I'll
take it out. Yeah.
It has a micro, small and medium enterprises framework, I think, different classifications, my lord. For each of the, that's the reason, my lord, they need to give us materials to show whether it's a micro. Lord, what I would like to,
I remember somebody was arguing that. Yes, Mr. Senior Counsel. That they need to be a board has to.
This is under, if your lordships were to take Pronit's case, lords. The relevant portions is extracted in Pronit's, if I remember, at page number 8.
Page number?
8 of the compilation of judgments provided by my learned friend.
This is, he has produced this.
Yes.
This notification he has produced.
Yes.
No, apart from that, I had an occasion to see that.
Your lordship is right. Not there is a reference to operating instructions.
Lord, all that.
Para 11. Para 11 of the Pronit's case, it says that there are operating instructions as to how it should be operated. I think that's what your lordship.
MSME has to be.
Yes.
Declared as a NPA. There is a procedure for that.
Yes.
Straight away, because they have not paid the amount or there is outstanding, that's not the procedure. There has to be a committee,
But
something. I have read it somewhere.
But my lord, in our case, my lord, we had restructured the loan. And subsequent to restructure, if they default.
Well, whether it is a MSME or not.
Lords, can I just persuade your lordships? The loan itself is an MSME account. I don't have any other loan.
No, loan is not MSME.
I just
Let's
pass
see
it on.
that. Let us see that.
Can I just pass on this memo, my lord? This is my loan application. Argun, copy.
What is that?
Lords, in this page number 1 is my communication to Canara Bank.
1 minute. Yes.
Lord, there is something called as care ratings pertaining to MSCs, which we had given because this is a condition precedent for applying for a loan. Then page number 3 is my application for loan. Page number 3, in the beginning itself, application form for loans to micro and small enterprises, MSC. This is the loan application. And your lordships may kindly turn to page 9. In that, your lordships will find below the address, account number, product code name, loans to MSME services.
This is which year?
Lords, this is 2016. This is the loan, my lords, which is being serviced. Now, next document also, loans to MSME services, page number 11. Lords, last occasion also we had produced documents to show that they themselves recognize that we are MSME. Lords, for this COVID period, only for the COVID period, the RBI directed that there can be a restructuring by adding all the dues which are payable in the installments as a principal and then restructure it so that we can pay it in the future. They have extended this benefit to me.
At that time, we insisted them to register it under the portal, and that is the when they have registered it as an MSME.
Well, it's 99.
22 is the time they registered it in the portal as an MSME. Until that, it was not a registered MSME at all.
Lords, I can produce documents
which
to show.
They themselves have produced the document.
I will produce the documents. We are MSME since 99.
21, 22.
21?
22, they have produced that document.
Oh, this is page 11. Page 11 is when?
Lords, we have page 11, my lords.
Ujam certificate is 31/3/21.
2016. My lords, my loan application is of the year 2014. 2018.
That is number 1.
This is.
Now, assuming that it is a MSME. Now they have issued a notice under 13 to when?
Lords, 13 to notice even if they have issued, my lord, this is the only factor. If your lordships is convinced on this, I have a case. Otherwise, I don't stand with.
No, but one more thing is a person, a party who has come to the court suppressing all the material facts.
Lords, the facts are stated. I have ascertained. Lords, kindly.
Let us.
Page 16. It is stated. Para 14, page 16.
Para 14.
Yes, page 16, my lords. So there is no suppression of facts.
Then how can you come before this court? having, when you have already invoked the jurisdiction of the DRT, when there is a conditional order,
My
why
lord,
should
so
you
far
come
as,
before the
my
court?
lords, the DRT is concerned, the challenge is to the provisions, to the measures under the SurfAC Act. When a measure is taken under SurfAC Act, my lords, we'll have to approach under section 17. But the question, I just wanted to say this, my lords, why this practical difficulty? Till Pronit's case came, if your lordships may kindly take Pronit's case, why this difficulty has arisen? Till Pronit's case was pronounced by the Supreme Court, the law which was then prevalent was that the Bombay High Court took a view that it is not the obligation of the bank for the purpose of applying these principles as enshrined under the 2015 regulations, and it is not mandatory. So this was the law which was prevalent till Pronit's case was pronounced. For the first time, Pronit's case declared the position of law, saying that if your lordships were to see Pronit's case, my lords, this is essentially what Pronit's case did. At paragraph number 22, till then this was the view. So there is a change in the position of law. Para 22 at page 13.
Yes.
In that view of the matter, we are of the opinion that the findings recorded by the High Court in the impugned order that the banks are not obliged to adopt the restructuring process on its own, or that the framework contained in notification dated 29/5/2015 as revised from time to time could not be said to be mandatory in nature, are highly erroneous and cannot be countenanced. So till then, this was the position of law. So neither the banks did it, nor was the banks recognizing even a request by the MSME saying that we are going to consider this under the 2015 RBI guidelines. Then the question came about, my lords, in Pronit's case as to whether the persons who, the borrowers who are the MSMEs are entitled to be given with this benefit, and whether this is mandatory. Supreme Court answered both the questions saying it is mandatory in nature. Then it said if the bank is fully aware of this MSME, they will have to extend this benefit by themselves. If not, if it is something like I have borrowed a loan, subsequently I am
At the stage of declaring it as an NPA, they have not done it. They have not done it.
They have not done this
They
procedure.
have not done it. So then next stage comes at 13.2.
That's true. My lords, that's the reason.
What did you do?
My lords, then that's the reason why I said, my lords, when they issued 13.2, when they took further steps, the position of law which stood as on, my lords, this is pronounced on 1st of August 2024. So anything done prior to 1st of August 2024 was in a position of law as was prevailing, that
No, next
banks is under no obligation.
Next judgment is when?
Next judgment, my lords, is pronounced in 2025.
Yes.
Date yavattada? Date. I just give the date. Anyway, this is in the year 2025. No, the reason why I am submitting this is
July 28.
there is a change in the position of law, which is to the benefit of a particular class of the borrowers.
No law has been laid down in both the decisions, my lord. There's a clarity.
I will read what is the position of law laid down. Pronit's case, my learned friend wants to say there is no position of law.
In both the cases, there should be an affidavit as per the circular. By the.
That's the reason why I said, my lords, affidavit is required to be filed after this judgment comes about.
No, even at the time of granting an interim order also.
Yes.
There was that was a conditional order. Where was it complied with by the?
My lords, we have complied with that order, my lords. This was a conditional order. We have filed that affidavit. My lords, this affidavit is filed on 1st September
You're saying
2025.
that it is not filed? On you.
First September, he is coming out with something not at the, he has
No,
not
I have
complied,
it.
not complied with the, at the time of the,
Lord,
before
the direction
the
of
date
this honorable court,
28
to file an
was the
affidavit
date.
that I will not liquidate any of the assets and keep it as it is, any of the assets.
He's
I have
saying-
given the details of all the assets which is standing in my name and an affidavit in terms of what your lordships have directed.
Right.
On 1st of September 2025, I filed the affidavit.
1st of September, if he is filing, it should have been deposited. When did he deposit the money?
Lords, the honorable court's order, my
When-
lords,
when has
I
he
think my
deposited the
learned
money?
has not gone through the orders of this honorable court.
It doesn't say so, to deposit any money.
No, it says court order is to deposit pay by 28/8.
Where is that?
I produced it along with my counter, my
In
lord.
the writ petition.
In this writ petition, you cannot seek the order
No,
or
my lord.
implementation of
I
SA
am
order.
permitted to clarify that, my lord. The writ petition number 13365,
Where is
which
that?
I am assisting this honorable court.
Which has not been mentioned in this writ petition, my
Petition.
lord.
My lord, it is
It
not
has not
correct.
been mentioned.
My lord, the
And
honorable-
my lord, in this writ petition which is suppressed,
Kindly
my
come
friend
to
is saying
pay
is not suppressed.
The interim order
13
granted in this.
There he seeks for possession notice again. 2 times. Now, here also he seeks for possession notice. There in 13,336, he seeks for possession. So they suppress that.
I just
My friend
pointed
says
out-
he's not suppressed, he's absolutely
23.
suppressed.
I mean,
What
permitted
was
point.
flown after 2023? This is a petition of 2023. Anyway, I
Please,
get
that in
instructions.
fact, in that writ petition, there's an interim order granted by this honorable court. That interim order is not complied. And apart from that, no point of time, my lord, that, my lord, kindly come to my lord, order dated, my lord, 28/6/2023.
This is on.
WP
what
number
date?
13365 of 2023.
So this is going on from 23
Please.
even till now.
And apart from that, my lord, kindly see the grounds which raised before this honorable court in that writ petition.
You the writ petition.
In fact, I filed my statement of objection also.
It has become a pure abuse of process.
Absolute abuse, my lord. Huge cost, my lord, because
My lord, at
there is
least they have to
suppression.
take-
There's
My
absolute
lord,
suppression.
Right now, I don't have the judgment. In fact, Kerala High Court passed an order. Right point of time, they have to take a contention before the appropriate fora. It is a matter from the day one, my lord, they're contesting on various grounds. My lord, they're seeking, my lord, one-time settlement.
Let's see in this writ petition.
Please, my
that's
lord, kindly
fine
come
in
to the prayer
H1.
sought before this
Prayer,
honorable court.
prayer, my lord. Same prayer. Here also.
One minute, I'll just read the prayer. Paragraph number, my lord, 11. Issue writ of certiorari cost the order dated 17/6/2023, passed by additional senior civil judge at so and so, so and so. Award cost to pass such orders.
Then in the grounds?
Grounds, my lord, I'll just read the entire grounds. The act of violation of the principle of natural justice. The act of respondent bank violation of Article 14. The respondent bank initiated statutory reasonably fairly acted in so and so, so and so. The respondent bank violated statutory provisions. The petition submitted could not pay the amount of the bank since incurred huge loss. The petition that they are ready to.
This is one writ petition.
That one more writ petition, my lord, which I am assisting, my lord, 8224 of 2023.
822?
8224 of 2023. Kindly come to the, my lord, prayer sought in this writ petition at, my lord, page number 10.
Page number?
10, my lord. It starts from 10, 11 it is. Issue writ of mandamus direct the respondent bank to restructure the loan, so and so. Fast position notice.
Where do you get that?
My lord, paragraph number, page number 11, 1, 2.
No. Issue a writ to restructure the loan account dated so and so, to quash the position notice dated so and so.
Is again challenge here, my lord. Same.
Pleaded.
Let us see the grounds.
My lord, kindly, my lord, ground starts from, my lord, page number 9. Violation of principle of natural justice, Article 300.
What is the interim order in this?
My lord, the interim order, according to me, my lord, the second petition only, subject to payment of 9 crore rupees, which is
In
not.
this?
In this, I think, my lord, there is no interim order granted.
Let's see.
No, I don't think so. Interim order is, I mean, subject to, my lord, correctness.
Give the order sheet. Now, please come to the OA petition in the essay or the OA. What was the stand?
Essay.
They say they take pronouns.
Huh?
They say they take pronouns.
I not assist.
Now they have taken it.
Lords, this
Now they
ground
have
is available only after August 2024.
No, my lord, my lord,
Before
that is-
August 24, I can't rely upon pronouns.
My lord, how can this notification?
That notification is.
It's 2015.
It's not about law.
Lords.
It is about the notification is very much there.
Lords, that's the reason. Lords, the reason why I read to your Lords' para 22 is till August 2024, the position of law which prevailed was that this notification is not mandatory. Neither I can avail, nor is it mandatory for the bank to enforce it. This was the position of law.
There is not, my lord, there is no interpretation
Can I just,
of.
can I
it's not
just
a
produce the
position
judgment
law.
of
It is
the
only
Bombay High Court?
Interpretation.
Not the Bombay High Court which set aside, which was set aside in Pronet's case. I'll produce that judgment. That judgment clearly held that these are not mandatory. This is the reason why one of the matters.
So, but anyhow, this kind of right from 23 on one harping here and there, not complying with any of the interim orders that are passed by the court, and filing one petition after the other, 30
But,
crore rupees, 30 crore rupees. 33 crores, just like that I mean, by filing one petition or the other, entire proceedings are stayed. And now I will, under this order of Justice Deepankar Datta, and also this of an, what is this?
Pronouns, man.
That also pronouns
Clearly
also.
says abuse of due process of law. And my lord, suppression, my lord, suppression of essay filed, and then they don't come here and tell.
Yeah, I've already pointed out
They're
there's no
said,
suppression.
but they
If he
don't
doesn't
comply with
even
that
read
order.
the petition to make
They
that
don't
statement.
comply, then they find it convenient to come here, come here and take an order. That too, what sort of order, my lord? Order is, I have sold the property. The property is sold in the auction. And I am not able to execute a sale deed in their favor because the blanket order of stay of the entire proceedings. Now, at least with regard to position, if the order was there, something here, I am not able to confirm the sale.
You have stated on your objections about
Yes, my lord.
confirmation of sale.
Yes, my lord.
I mean, the sale that is
Yes,
conducted.
I have mentioned the property is sold. That's my first paragraph, my lord, in my counter. The petitioners are approaching different courts to the same grounds in suit for their convenience without complying with the interim orders and obtaining stay only to solve the recovery proceedings.
Yes, senior counsel, you want to add anything?
Just four sentences I wanted to add, Milords.
Yes.
Milords, the position of law as it stood prior to 1st of August 2024, as has been observed in Pronit's case, was that 2015 need not be followed. Any petition that has been filed earlier to 1st of August 2024 certainly would not have raised this contention regarding Pronit's because this declaration of law comes about only after 1st of August 2024. Now, number two, after 1st of August 2024, we have given them, Milords, we have produced that letter now saying that we are MSMEs, you have already restructured in 2021 under the COVID scheme, therefore you extend the same policy to us. Now they did not extend this policy, that's the reason why we came. In the interregnum, whatever steps they had taken prior to this Pronit's case, Milords, was subject matter of challenge in the earlier writ petition or in the SA. This is independent of my claim to get the benefit
SA,
under.
when you have gone before the court, why did you not, when an interim order is passed,
Yes,
why did you not
Milords, in
comply?
the SA we have raised this ground regarding Pronit's.
No,
It's not that
interim
we have
order,
not.
interim order.
Pardon, Milords.
Interim order.
Milords,
2 crores
interim-
was directed to be
Milords,
paid.
so far as interim order is concerned, I am under instructions to state, given another 30 days, we'll pay this 2 crore rupees, which was directed by the, we will pay that money.
Yes.
My lord, one thing is, my learned friend has been arguing, but he has not
Two-
said, after
two more
getting the benefit
sentences.
of restructuring, can he seek for MSME?
Milords,
That is not answered at all.
I will answer it. Milords, I'll just answer this, Milords. I really fail to understand from where my learned friend got this statement to be made before the court, that wherever any restructuring is made, is undertaken under the COVID scheme, we are not entitled to the benefit under the 2015.
He has to establish
No,
that.
I will.
Why should I do it? He has
Milords,
to tell, he has come to the court.
I just wanted to say this, the statement made by him, Milords, that if restructuring is given under the 2020, 2021 COVID guidelines, I am not entitled for the benefit under 2015. Milords, is a statement which is casually made because 2015 is independent and 2020 is independent. The moment they extended 2020, saying that I am an MSME, at which point of time I was not even NPA. Subsequently, after the restructuring, if I am to be declared as an NPA, then this 2015 guideline was there. But the only difficulty was, even probably for the bank as also for me, the position of law was that Pronit's case had not yet come. 1st of August 2024, the Pronit's case came into existence. After that, I have started agitating. Whatever is filed before that is only challenging the measures. But after that, whatever has been done is raising the issue relating to the Pronit's case. So far as the facts are concerned, Milords, the statement regarding approaching the SA and having brought it before the court is brought before the court. In SA, all these facts are stated. Whatever is now brought, it is not that it is this facts are, everything is stated in the SA. And the factum of having filed SA is also brought before the court. There is no suppression as such.
So having taken a similar ground in the SA, why should you file a petition?
Milords, now can I
Because
just
you don't
pursue
want
it? I'll just
don't want to pay that.
No,
tax,
I'll just answer that, Milords. Can I just request your Lords to kindly have a look at this judgment, Milords?
What is that?
This is a judgment of the Kerala High Court. Milords, my apologies. I given my copy, Milords. It's a marked copy. My apologies. Our copy.
Yes.
Para 29
Yes.
and 30. As regards the maintainability of the instant writ petition, it's to be noted that the classification of an account as an NPA is distinct and preliminary act having serious consequences, more so when it is breach of judgments referred to earlier, besides the notification concerned. As such, the classification of the accounts of the first and second petitions is clearly illegal and liable to be declared so. Grievance of a borrower regarding the asset classification and consequential invocation of SURFACE Act by issuing 13(2) of the SURFACE Act cannot be redressed under section 17 of the SURFACE Act In the absence of invocation of section 13(4) of the Surface Act and judicial review under 226 is the only remedy. Remedy under section 17 is only against the invocation of 13(4) of the Surface Act after a legal and valid classification of the accounts as NPA. In the present case, although proceedings under 13(4) have since been initiated, foundational challenge is not to the recovery steps themselves, but to the very legality of NPA classification on the ground that the mandatory procedure prescribed under Exhibit 3 and 4 is not followed. This renders the classification NPA is illegal, given the position of law reinforced in the judgments of Pronit and Sri Swami Samarth Construction that an RBI framework is binding and must be complied with before NPA classification is MSME accounts. Since the petitioner's grievance arises at the threshold, the stage would be wrongful classification either itself. It cannot be redressed under section 17 of the Surface Act. Lord, this case also presents itself with the same facts that he had raised proceedings in relation to section 13(4), but subsequently after the judgment came, he went before the High Court and said that I wanted to maintain the petition. While granting the relief, this issue is also answered, saying that they are only required to find out whether I qualify under this scheme or not as an MSME. There are about 700 employees in this. Now kindly have a look at page number 69 along with my writ petition. Just one document I'll point out, because to address that whether we had brought it to their notice I'm an MSME or not during the process of this 13-233 proceedings, page number 68 I had given a complaint. Now this complaint
Dated?
Pardon me, lords?
Dated.
This is dated 15/11/2022.
When was the 13(2) notice?
Lords, 13(2) is issued
20 to 12.
on 12/12/2022, copy of demand notice. So 15/11/2022, we had brought this to their notice that we are an MSME, you will have to extend this benefit. Page 71, my lord, the complaint was given to the Honorable Prime Minister. I will address it. From the Prime Minister's office, it was sent to the my lords, to the bank. There is an endorsement, my lords, details of registration, page number 71. My lords, it says that this complaint having been forwarded to the bank has responded back to the PMO saying that we have addressed this. This is available at page number 71 and then page 72.
Interfere in the banking activity also.
Pardon me, Lord.
Prime Minister will interfere in the banking activity.
My Lord,
Kindly have a look at page 69 and 71.
My friend
Lords.
said, I am not serious. Now it is becoming,
taking a cue from this.
I casually said something, but now
From this, now everybody should address a letter to
the Prime Minister, then it's clarified. Banks will be,
clarified as a.
this is more, this is, if mine is casual and I don't know what to say for this.
Page number?
Page number 69. First petition.
That is 2585.
Yes. 69 is the.
Yes.
Lords, then page 71, your lords, may kindly turn to. Date of receipt 15/11/2022.
No, what did you ask? My humble request to your good office.
Paragraph, Lords, page 69, last two lines.
To support for one more year and not to kill the business.
Lords,
driven by technology. That is
page 69, last two lines.
Restructuring of the loan.
Lords, that's essentially, Lord, that's what is done by the committee. Kindly have a look at page 69, last two lines. Business would have closed during COVID. Thanks for the central government which supported MSME like us and gave the life. Since we stopped working with the government, are trying towards the private infra developers. We need time to establish our business. We have precast construction plant, which is future technology for construction. More than 100 families is dependent, so on and so forth. Lords, now we have brought it to the notice that this is an MSME. This is done. Then page 71.
Yes.
This is the complaint number PMO PGE so and so. This is the complaint number. This is available. Lords, any person can access the net, and this is available. Lords, date of receipt is 15/11/2022. Current status case closed. Date of action is 25/11. Remarks, branch and the RO has informed us that the issue is taken up with the competent authorities and the same is conveyed to the customer.
No, Mr. Senior Counsel, come to page 69.
Yes.
From page 69, where did they say that they are an MSME?
Last two lines.
Where in 69?
Yes. The business would have closed during COVID. Thanks for the central government which support MSMEs like us. We have brought it to the notice. And then what the authorities have said, my lords, the bank has said at page 71. This is the reply which is given to the PMO. Remarks. My lords, I'll just read from the beginning. Name of the complainant, date of receipt 1511.
When you can address a letter to the Prime Minister, can't you write give a representation to them under 13?
Lords, now, if your lords were to see, if this is the letter which was forwarded from the PMO to the bank, lords, the bank has already accepted this and said that we have complied with this. Kindly have a look at that, lords, page
What we are
71.
talking of the restructuring.
I'm kindly just
Talking of the restructuring.
current status case closed, date of action 25/11/22 remarks. Branch and RO, regional office, has informed us that the issue has been taken up with the competent authorities. As an MSME only, competent authority, there is no other competent authority. And the same is conveyed to the customer.
They restructured. the law.
That's the reason why I said they are misleading the court. If they want to make the statement once again, I'll ask them to file an affidavit. Your lordships will have to hold them.
They are still not
No,
filed their
I will.
affidavit.
Lords,
Affidavit
I
to
want to
be
make a
filed here.
statement. Restructuring took place in the year 2021.
Yes.
Restructuring took place in the year 2021, which was a special scheme by the RBI for the COVID affected MSMEs only. This is nothing to do with the guideline or the framework of 2015, which is independent. This 2021 guidelines was wherever this period was declared as a non-functional period, the RBI said that don't ask them to pay anything, add everything into the principal and then restructure it so that they will start giving the money after it is the lockdown is restricted, the lockdown is raised. That is what was contemplated in 2021. Absolutely nothing to do with the declaration of an NPA. But so far as my case is concerned, from day one they are aware. My loan account is an MSME account. My loan application I have produced. The loan account extract I have produced. It's an MSME. They have admitted to the fact in 2021 they recognized I am an MSME. 2022 minutes, when just 1 week before they have issued the notice under 13.2, it is brought to their notice through the Prime Minister's office that this is an account which is treated, this is an account of the MSME. They even say in their remarks that yes, we have taken this before the competent authorities and it is intimated to the customer. Nothing is intimated to me. This is only what is made good to them. I have no further right of access to say anything. Then rating remarks. I have given the rating as good response, so and so, so and so, my lord. This is bank did not do anything. Can I just persuade your lords to kindly see page 71, my lords?
No.
Rating remarks.
So this has all happened much before the 13.
Lords, 13.2 was 1 week after this. 12.1.
What happened? What did you do after that?
Lords, after 13.2, there is no fresh communication from my side saying that I'm an MSME. But this is what I wanted to bring to your lordship's notice. As of 2022, 13.2 notice was issued. Pronits principles were not there. Though 2015 regulations, the guidelines were in place, the view of the Bombay High Court was it is not mandatory. Lords, the mandate was attached to it only because of the judgment of the Supreme Court. No doubt, lords, it may apply from the date on which it is there. But to say this is how you are required to do it was not there. This is something which was not known to anyone. Nobody would have done this. Now, after this comes about, then, my lords, is the requirement to say that yes.
That we cannot accept that till the judgment came into light, we don't know about the procedure, because there is a procedure under 2015.
The procedure.
If your client is not aware of it, that cannot be said that he is ignorant of this, so that we don't have to consider it.
Mala 21, hardship may see two things. They take the benefit of regularization on the notification of 21. They have knowledge about that. For that, they don't need a Supreme Court to give any clarification. But 2015, they say only after they. Well, how can they not know 2015 when 21 they take encash the regularization scheme? And your lordship may kindly see when we regularized this 26/6/21, within 4 months writing to the Prime Minister for giving us benefit. So they don't want to pay. There is no intention to pay.
Yes.
And my lords, we should take serious note of the suppression of fact and the way they are misusing the due process of law.
That all the facts are stated in para 16 and we are referred to essay, and in the essay everything is referred. It is not that we have suppressed anything.
This court has asked the affidavit to be filed. They have not filed, my lord. This court has asked them to file an affidavit.
1st September 2025, we have filed an affidavit. We have served the copy. Really do not know, my lords, why they are making the submissions. It's already a part of the record. Your lordships have seen it.
I have not received any of. Show me if I have served it or not.
Yes.
Please, my lords. Grateful for the hearing.
Dismissed. Order will follow.
Please.
Next.
Serial number, list number 1, serial number 13,
Yes, withdrawal of the petition.
Eugene Prabhu. Yes.
Memo is for seeking to withdraw the petition stating that the petitioner had obtained the necessary orders in essay number 378 of 2025 before the debt recovery tribunal. Accordingly, memo is taken and dismissed as withdrawn. Yes, next 14.
Lord, serial number 14, my lord, on record, advocate is not feeling well, my lord. Kindly let me be taken next week, my lord.
Give the file.
Lord, in this matter, my lord, the petitioner, my lord, challenging the, kindly see, my lord, prayer, page number 10, my lord.
Matter in the month of December. Yes, next.
Serial number 15,
List after sir. Who appears?
My lord, for the petitioner, my lord,
Oh.
or R2, my lord. Service of notice can be
R1 to
dispensed with.
R3, R2 you appear.
Yes, my lord, we are undertaking Bakalat, we are not filed Bakalat.
Lord, in fact, my lord, what is challenged here is, my lord, section 14 order passed by the learned magistrate, where, my lord, I am the secured creditor. Lord, I had approached the learned magistrate, my lord, seeking for an order under section 14 to take physical possession. That has been rejected.
On the ground?
My lord, your lordship may kindly see, my lord, page 35, please, my lord.
30?
35, please. My lord, before that, my lord, in the first round of litigation, my lord, it was rejected. We approached this honorable court, my lord. This honorable court, my lord, set aside that order and remanded the matter.
Where is that order?
My lord, that is at annexure C, my lord, page 27.
20?
Page 27. My lord. Your lordship may kindly see, my lord, page 29 would be relevant, my lord, para 2. It would indicate that the trial court has recorded the finding that no original documents have been produced to indicate that the respondent had received possession certificate to clear the loan. It was further noticed by the trial court observed the postal receipt and the RPAD cover are necessary documents and appear to
Where is the
indicate.
present order?
My lord, the present order, my lord, is at page 35, 35, my lord, para 4 would be relevant. My lord. Para 4 to 6, my lord. May I read, my lord?
Yes.
Page 35, Lord. Under section 13(2), demand notice has to be sent to the respondents is demand for the dues to be paid to the bank. In the present case, there are 3 respondent notices has to be sent to 3 respondents. No proof of notices sent to respondent number 1, 2, 3. Notice which is dated 15/2/2024. There are no RPAD receipts. There are no RPAD acknowledgements produced in the original to know whether section 13(2) surface notice has been complied. If the documents have been produced, then the court can peruse whether the petitioner has sent notices to the respondent, which is fully addressed and sufficiently stamped. In the present case, which is not happened, as the petitioner has not produced RPAD receipts for having sent notices and RPAD acknowledgements to reveal that the said notices are duly served to the respondent number 1, 2, 3. In view of the above, the court cannot calculate 60 days period commencing the period from the notice issued under section 13(2) of the SURFACE Act as from the date of the issuance of the notice. After lapse of 60 days, section 13(4) of the SURFACE Act possession notice has to be issued.
You have not filed the acknowledgement. Is
We
not-
have done it, my lord. Your lordship may kindly see, in fact,
The finding is that. you
the
have not
finding
filed
is that
acknowledgement.
it is the same finding as the earlier order also, my lord, which was set aside. Your lordship may kindly see the original papers are here, and in fact, on the last occasion, the TCR has also been called for.
Is it there? Is there? Let's see.
My lord, small submission, my lord. Respondent number 2 is ready to settle the matter, my lord. If the outstanding
No,
loan.
first of all, under 14, when notice itself is not
Not
necessary
necessary.
to the borrower, the question of hearing now won't arise. It is between the bank and the court. Yes.
Please. My lord, I have, in fact, in the morning, my lord, I have made a certain
The flag.
flags, my lord, so that it will be. Lord, your lordship may kindly see, my lord, the demand notice is available at page 46, my lord. I have marked it, my lord.
Mm.
This demand notice, my lord, lordship may kindly see at the top, SURFACE demand notice by speed post with AD is issued to, my lord, the
Rahul Vinay.
Rahul Vinay, my lord. That is one of the borrower. And the other borrower, my lord, at the bottom, if your lordship could kindly see, Muniratnam Vijay Kumar.
Where are the others?
My lord, at the bottom in the same page, my lord.
Mm.
One is, my lord, Rahul Vinay. The other one, my lord, is Muniratnam Vijay Kumar. And my lord, the next page, if your lordship sees, my lord, V Nikita Raju is, my lord, the third borrower. My lord, this notice, my lord, I will show your lordships the acknowledgements also, my lord. In the meantime, my lord, if your lordships could see the publications also, my lord. I have marked those publications also, my lord. The paper publications, my lord, insofar as the 13-2, and also, my lord, I have marked, my lord, the possession notice and the paper publication for the same.
In all this, only Rahul Vijay Vinay name is there.
My lord, at the end, my lord, the acknowledgements are there.
Raju. And what about, where is the third name?
My lord, the acknowledgements are at the end, my lord.
No. Paper publication. I'm
Please,
looking
ma'am.
at the paper publication.
Paper public.
13-4.
Please, my lord.
Now, according to you, applicants are Rahul Vijay, Muniratnam Vijay Kumar,
Please,
and
my lord.
Nikita Raju.
Please, my lord.
Come to the publication at page 74. Where do you get that other person's name? Muniratnam Raju.
My lord, there are two publications, my lord.
Let's see. One is under 13-4. So that is only one.
My lord, one is under 13-2, 13-4.
So
Both
third-
are published in English and Kannada. my
That's
lord.
what I'm
Please,
looking at 13-4.
Please, my
Where
lord.
is that name
My lord, 13.
of the third applicant?
4, my lord.
74 page.
Please. My lord, first is Lokesh Venkatramanappa. Then, my lord, your lordship may kindly see.
Where are you?
My lord, my lord, point, column 6, my lord. Rahul Vinay. Column 6, please, my lord.
No, you're looking at 13-4 or 13-2. I'm looking at 13-4.
Please.
Rahul
Lord.
Vinay, Nikita Raju, only two.
My lord, in the third column, my lord, Rahul Vinay, borrower, Muniratna Vijay Kumar, co-borrower. In the third column, my lord.
Okay.
My lord, this is dated, my lord, May 20th, 2024, my lord. At the bottom, the date is available.
May 20th,
Please, my lord, in the
2024.
same one, my lord.
That
First is
for
Rahul Vinay, my
serial
lord.
number 1.
Please, my lord.
Rahul Vinay, borrower. V. Nikita Rahul, co-borrower.
Please, my
That's
lord.
one. Number 2, Rahul Vinay, borrower. V. Nikita Raju, co-borrower.
Please, my lord. The third one, my lord. Rahul Vinay, Muniratnam Vijay Kumar, and Nikita Raju, co-borrower. My lord, these are individual account numbers are given, my lord. As per the account numbers, their names have been shown. my lord.
Yes, sir.
Please. My lord, in the similar manner, my lord, if your lordships could see the paper publication insofar as 13-2 has also been published.
Yes, I've seen. Then where is the notification, acknowledgement?
My lord, the acknowledgements, if your lordship kindly see, my lord. At the end, my lord, we have produced, I have marked, I have flagged it, my lord. Please, my lord. In this, my lord, your lordship may kindly see Rahul Vinay at the top, my lord.
That's what the court said.
My
Where
lord,
is,
at the bottom, if your lordship could kindly see, this has been acknowledged by the postmaster. There is a seal and signature. Your lordship may kindly see. I have the originals also. At the bottom, my lord. My lord, these are digitally printed, and my lord, the the postmaster, my lord, has acknowledged. Your lordship may kindly see the original
so
also.
what happened to that RPAD?
Lord, this is, sir, they have received it. Their signature.
No, you must have received the acknowledgement.
Lord, the
This is a postal track.
This is the tracking record with the original of the postmaster seal. The lordship may carry the original seal.
That's what is the specific.
Lord,
ground
we
that
have
is
served
taken,
all
but-
the notices. The paper publication is also taken.
Come to the order now.
Please.
No, instead of doing it, you can file whatever.
Lord, we have filed it. The magistrate has perused it twice. Instead, in fact, my lord, on the first occasion, this
What
honorable
I'm trying
court-
to say is
Sorry.
not the postal this track acknowledgement you will receive when you send it, you will get it back. That you can file before the court. Why to make all these things so complicated by doing all this? You must have received. What would be the difficulty in filing it? That's what precisely the
Please.
magistrate has taken the objection.
Lord, but this has been, my lord, duly stamped by the postmaster also, my lord. And they are not denying it. And in fact, they have never challenged it before any proceedings till date, my lord. 13.2 is not challenged, 13.4
Come
is
to the
not
order.
challenged. Please,
Page number.
page 35, please.
Which
Lord,
are in
may-
the form of printout, which has not been,
Please, my lord.
which has been not complied under section 65B of the Evidence
Lord,
Act.
that is totally unnecessary, my lord. It's a ministerial job, my lord. Your lordship may have, my lord. Time and again, my lord, Supreme Court has also
But
held.
you can
The
file it,
magistrate can't go into
why
all
do you
this, my lord.
complicate all this? Why do you come to the High Court, wasting your time and the court's time? If you can file the acknowledgement what you have received, it would suffice, isn't it?
But these are acknowledgements, my lord, which have been issued by the duly authorized officer, my lord, the postmaster. The magistrate could not have, my lord, rejected it,
No,
my
no,
lord,
it's on the
because it's a
postal
ministerial
track.
job, my lord.
No,
They
no,
have to check if,
acknowledgement is something. You
Please,
will
please.
receive a card. And this is a postal track. And which is, according to you, it is, there is a stamp on that.
Please.
What will happen if you file an acknowledgement? On that, there would be signature, whose signature it is, what it is. If somebody denies that I have not received it.
Lord, the signatures are available in this also, my lord. Your
Oh.
lordship may kindly see at the side. In fact, the mobile number is also available. On the right hand side, my lord, his signature is there, his mobile number is also there.
No, in a postal track, why there will be signatures?
My lord, they take, my lord. While there is a separate sheet, my lord, when we receive the post, we sign it and we have to give our mobile number also. It's a part of the procedure, my lord.
Yes. The bank is before this court, seeking the following prayer. It is submitted that in the earlier round of litigation, when the application that's filed with the bank under section 14 of the Forfeiture Act was not considered by the court, the petitioner bank has come up before this court by filing WP number 20377 of 2025 dated 14 July 2025. And the coordinate bench of this court had set aside the order impugned therein and remanded the matter for fresh consideration. And the petitioner is given one more opportunity to prove the contentions as assessed herein. Thereafter, the present, again, when, after the remand, the court has passed this order dismissing rejecting the application. And what about this rule 1? Postal receipts for having sent the RPAD postal.
These are the postal receipts.
No, 1314.
Please.
The
13
court
to-
has rejected it only on the ground that only the postal track is filed before the court, which are in the form of the printouts and which has not been complied under section 65B of the Evidence Act. Court has observed that there is a doubt as to when postal covers are sent, and there are no postal RPAD receipts, then the court will know which postal tracks they are related to, which notices they sent. Hence, overall, there is non-compliance of section 13.2 and section 13.4 of the Forfeiture Act, and counsel appearing for the bank submits that this court has called for the original record, and that clearly reveals that the seal of the postal department and the signatures, mobile number of the parties is also present. And the court, in a hyper-technical manner, had dismissed the petition. Next, you're appearing for the borrower. When counsel, the notice to, it is submitted that Ms. Nikita Gowda has instructions to appear on behalf of respondent number 2, and notice to 1 and 2 is not sought. However, it is this petition is against an order that's passed by the magistrate in section 14, when the notice itself to the parties is not necessary under section 14. While hearing this petition also, notice to the respondents not necessary, considering the fact that already the postal track where it is endorsed by the endorsed by the postal department is filed. The court, the court ought not have taken such a technical objection. in that view of the matter, the order impugned is set aside, and without insisting on this, the court shall decide the application on the merits of it within 4 weeks from the date of receipt of the copy of this order. Yes,
Please.
next.
Obliged.
Yes, next.
Cell number 16.
Here for the petitioner, my lord.
Yes.
And summons has been served on the respondent bank. The brief facts, my lord. Respondent number 3 to 5 had availed a loan from the respondent number 1.
For the respondent bank, requesting for 1 week time for to observe, file the objection.
Who appears? What is the name of the advocate?
South Indian Bank.
So and so has instructions to, it is submitted that so and so has instructions to file wakalat. Then counsel for the petition to have the copy of the writ petition.
Already served. my lord.
Sir?
Served. I have already produced the.
Council shall get instructions by 17th, list the matter on 17th.
Sir, much.
Cell number
Yes, 17.
17, hearing on IA. Cell number 17.
For the petitioner, as per the earlier order,
Lord, there are 2 writ petitions filed, my lord, before this honorable.
OTS has to be considered by the bank, my lord.
My lord, in fact, my lord, we
But-
sent a letter pursuant to order made by this honorable court to the petitioner to come, my lord, my lord, produce the order.
Take that.
We requested the petitioner come to bank and at least give us your
proposal.
I'll just read, my lord, about subject account. The outstanding liability of the said so and so so and so. In view of the ongoing writ petition and as per the directions made by the Honorable High Court, we request you to submit the OTS offer so that the account may be settled amicably.
When did you go to the bank?
My lord, that, my lord, I have to seek instructions.
You will, you will be seeking instructions from 2022 till when you want.
No, my lord, in the last occasion, it was directed for them to consider OTS.
In fact, we consider.
Order
this,
dated.
My lord, the prayer sought before this Honorable Court, my lord, assailing the sale.
The
24/9.
Then
it was-
counsel appearing to the respondent bank submits that. Bank has addressed a letter on 4/11/2025 asking the petitioner to come up to submit an offer so that the account may be settled amicably. It is submitted that petitioner has not come before the bank with any proposal. List this matter on 24th. By that time, the petitioner shall approach the bank by 17th and shall give his proposal. And whatever is the response of the bank, they shall be submitted to this court by 24th November. List this matter on 24th.
Cell number 18.
Yes.
18.192, my lord. What is the
Must I have
challenge
your
here is-
reading?
What is under challenge is the notification issued by the Union of India designating certain DRTs for matters arising for 100 crores and above. There are 5 DRTs in India, my lord, out of which they have pick and choose only Delhi, Bombay and Chennai. So jurisdictional, the DRTs which falls under the jurisdiction of Chennai DRT, Chennai 1 DRT has been made as a designated
Hear
court.
it on some other day.
No, I'm coming, my lord. This matter, so moto, Supreme Court has taken transfer application, civil 636 and to 645. Matter is pending before Supreme Court, my lord. Transfer applications are there from entire India, they have taken. From division bench of Aurangabad, bench of Mumbai High Court there is a stay. Kerala High Court, there is a stay, all headed by division benches. And thereafter, the transfer petition has been taken. It is pending before Supreme Court. It was to be listed sometime last week, my lord, but it is not listed.
Yes, it is
In between, the 18th, they moved an application. They want to filing a surface application, 100 crores and above in Bangalore. That was rejected, my lord. So it has to go for Group hearing.
It is submitted that the matters are pending before the Honorable Apex Court. This matters in the month of December. Yes, next.
Interim orders may be extended.
Interim order, I'll just look at it if it is there.
Yes, my lord. There are.
Yes, 20.
Cell number 19 adjourned. Cell number 20.
20 minutes challenge in my lord.
This case appearing for respondent bank.
The petitioner.
What is when was the interim order in this case?
Lord, to deposit 1 lakh rupees, my lord.
What is outstanding?
Outstanding as per the section 13, two notice is 7 lakhs, my lord.
No, my lordship.
7 lakhs odd.
As of today, my lordship, there is 9,63,000.
Let them give the statement of accounts
I will produce it.
recent, because as on the date of filing of this
No,
case, my
then
lord,
what
it
should
was,
follow?
my lord,
Once they give the statement of accounts, what should follow?
if he gives my, then we have to consider, my lord.
No, no,
Make-
no. Only thing I can adjourn this matter is let them give the statement of accounts. Please, when are you going to pay the amount? You come up with an affidavit. Because there's nothing to, what is that is questioned before this court? Huh?
My lord, in fact, the mortgage itself, my lord, mortgage is not registered with the Sarsai, my lord. At page 61 of the statement of objections, my lord. Kindly see the property. They have produced, it belongs to a different person, Shazia Banu, at page 61.
You are the borrower.
I am the borrower, my lord.
You have mortgaged the property.
Yes, ma'am.
Which is the property mortgage?
My property mortgage is 64, my site number 64, but they have produced a different document, my lord, at page 61. They have produced a different document. They say that my property is mortgage, but it shows a different name, my lord, at page 61. Kindly,
It's good for you.
My-
Let them take somebody else's property.
my lord, even otherwise, my lord.
No, you may not be agreed with that because you're safe. Your property is not going to be auctioned.
In fact, notice by paper publication is not taken against the other borrowers also. Kindly see, my lord, at page 11, page 49, my lord. Page 49. Notice by paper publication is not taken.
All these grounds you can go before the tribunal.
Yes, my lord. I may be permitted, my lord, to approach the tribunal.
Then what were you doing from 2024 here with 1 lakh payment? Please come. The writ petition is filed. Taking the following prayer. Extract the prayer. He stated that petitions the owners of the property, number 65, Kuskuru Village, Maturu, Shimoga. They have mortgaged this scheduled property and obtained a loan of amount of rupees 7,07,817. It is stated that the petitioners are regular in payment, but the bank had treated the account as an NPA and issued notices under 32 of the Surface Act, which was not served on the petitioner. Petitioner bank has taken the physical portion and handed over the copy of the notice under section 32 of the Surface Act. Then the portion notice under section 13 of the Surface Act and took the symbolic portion of the property without following the procedure as required in the provisions of the Act. Submitted that the bank has also approached the CJM at Shimoga and obtained an order under 14 of the Surface Act on 19/4/2024. Hence, the petition has come up before the court. It is only stated that the procedure is not followed while taking the portion under 13(4), and it is the only property. When the coordinate bench of this court on 4/11/20. On 7/6/2024 has granted the stay subject to depositing of which 1 lakh or not before 18/7/2024. Land Council submits that the amount is paid. When this matter came up on 4/11/2025, this court has passed an order observing that the Land Council, the petitioner submits that he has paid the amount as per the interim order, and according to him, he has paid the total amount of 3,25,000 and the outstanding amount is 7,50,000. According to the Land Council for the bank, the outstanding amount is 9,50,000. This court has directed the bank to furnish the details of the outstanding amount to be paid to the counsel for the petitioner, and by the next date of hearing, the petitioner shall file an undertaking with regard to the time frame and when he is going to pay the outstanding amount. If no such affidavit is filed with the next date of hearing, the matter would be heard on the merits of it. Today, no such affidavit is filed before the court. All the petitioner has not raised any grounds seeking interference of this court with the proceedings initiated under the Surface Act, exercising the jurisdiction under 226 of the Constitution of India. The petitioner, when already Section 14 order is passed, and the petition is aggrieved by the same, he is at liberty to file an appropriate to approach the debt recovery tribunal, and this the presented petition is not maintainable. Accordingly, dismiss, giving liberty to the petitioner to approach the tribunal
21, Girish B. Bandare.
in accordance with
was
law.
challenged.
In accordance with. Yes.
The possession notice was challenged. The interim order was complied by the petitioner. Subsequently, when the interim order is operating against the respondent, they have trespassed my property and trying to take the mahazar and also disposes the petitioner from the premises.
Within, what is it?
Agila. They will make an attempt, my lord. That's why I filed the contempt proceedings.
Yes, yes.
13-4 SL before this honorable court for recovery of around 1 crore 75 lakh that point of time. There are two accounts. And they approached 13-4 SL and this honorable court showed indulgence and granted interim order subject to payment of 35 lakh, which they complied. Now, my lord, in view of the alternative remedy, they can legate it before the DRT. Some time may be given in view of interim order.
How much is paid? What is outstanding?
My lord, there are two accounts, my lord. One
Now
account,
it is, before going to DRT, this is a, in between, it's a resting place for the parties. Okay, we take a break here
1
and
crore
then go.
84 lakhs, my lord. So outstanding balance is 1 crore 84 lakhs.
How much is paid?
Now I have paid 50 lakhs, my lord. First installment 15 lakhs within 10 days. Thereafter within 6 weeks I have paid 35 lakhs.
Generally, how much time it takes if any application is filed before the DRT?
my lord, it is very speed now. Within 6
Generally,
months, 6 months they getting disposed of.
So when is district petition is filed?
This was on 24 minutes. Ayog granted on
12 July 24, my lord.
So that's the time they're getting.
16 July 24, day was granted, my lord. And they also filed OA before the DRT for seeking recovery.
You also go. The presented petition is filed. Seeking the following prayer. It stated that when the loan is availed by mortgaging the agricultural land, the recovery proceedings cannot be initiated under section 31(1) of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. But in the instant case, the proceedings are initiated under the Act. Hence, the entire process initiated by the bank, including the issuance of possession notice, is nothing but abuse of process of law, void ab initio, and the same deserves to be quashed. What do you say about
Copy
this?
is my lord, it is not coming.
When counsel appearing with the respondent bank submits that it is a coffee estate, which is a commercial activity, and at any stretch of imagination, it cannot be termed as an agriculture land. In the light of the settled law, the bank is always at liberty to initiate the proceedings under the Surface Act. On 16/7/2024, a coordinate bench of this court has passed an order. And in the light of the said order, the petitioner has deposited an amount of rupees 50 lakhs.
50 lakhs.
50.
50.
50 lakhs. Next part. As far as the ground that is raised before the court with regard to that the land is an agricultural land, as the same is a coffee estate, that is not available to the petitioner. However, if there are any other grounds and the petitioner is aggrieved by any other action that is initiated by the respondent bank, he is at liberty to approach the DRT. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to approach the DRT within a period of 4 weeks from today, from the date of receipt of the copy of the order till such time the bank shall not take any coercive steps.
Cell number 22, Giri Kumar SV, petitioner.
I beg to appear on behalf. Appear for petitioner.
Yes.
My lord, IO granted on 23/8/2024, subject to my lord, deposit of 20% of the money within 4 weeks. In fact, here also same case, my lord, IO has been complied. My respectful submission is, my lord, let him go before the DRT.
Notice outstanding.
Lord, 35 lakh court. Lord, as on 27/8/2024, 37 lakh 71,924.
How much he paid by way of interim order?
25% of the money. Lord, that is, my lord.
Around 1.5, 2 lakhs. Yes.
My lord, now we are giving 5 lakhs check, 5 lakhs after they give some time for regarding balance amount because due to some losses of our seasonal crops.
Get instructions when he'll pay the remaining amount. Not this 5 lakh business will go. Because the amount is 40 lakhs. And 2024, you are happily enjoying the interim order. Get instructions from your client. It is submitted with the land counsel to the respondent bank that the interim order is complied with. Land counsel the petition submits that the petitioner wants to settle the pay the amount. And he'll get instructions list this matter on 1st of December. By the time the petitioner shall the petitioner shall file an affidavit before this court within what time is going to pay the entire amount.
4 weeks. Huh? At least use some 4 weeks, my lord. Because
4 weeks he is going to pay entire money.
Is it so? List the matter on 9th. For filing an affidavit. Yes.
Till number 23, Sharat Kumar Shetty.
I am the respondent.
I am the borrower. I am the borrower from the first respondent bank. So I have they issued a 13-2 notice. In the meantime, your lordship, the respondent number 2, 3, 4 as claiming the rights over the same property. And
what is that?
It is true that he availed the loan from me and defaulted and I initiated surface procedure, for which on 2nd September 2024, he files a OS number 6282 of 2024.
OS.
That just now I passed. Before copy city civil code. That is your client. And 4th September 2024, the IA filed for restraining the respondent to exercising any of their rights and not to disturb and not to go against any actions against the scheduled property, which is the scheduled property of this petition. The trial court, by observing the facts and circumstances, their prayer is not granted because this matter pertains to surface procedure. Thereafter, notice is ordered. Very next day, files this writ petition without disclosing that fact. The petitioner should have been.
Anyhow, that suit is not maintainable.
And that's
no,
for
here,
injunction.
There is a some. It seems that there is a title dispute. Why? Because same property.
Suit is for what?
Same property is mortgaged.
Suit is for what?
For injunction.
Injunction against all respondents. All respondents are lenders.
Authorized officer,
officer.
officer.
All respondents are lenders. It seems that there is a dispute regarding the title. So therefore, without disclosing that fact, first approach and not got the order, and if at all.
Forget about it. What is the merits of this petition?
Your lordship, kindly go to page 46. Your
What
lordship.
have you questioned?
The 13-2 issued by the first respondent.
Then have you submitted your objection to that?
No.
Sorry, your lordship.
13-2 notice they have issued.
13-2.
What is your response?
Yeah, I have given a reply, your lordship.
Where is that?
So that I have not
Where
put
is-
it. And simple, your lordship, it is here, your lordship, page 46, the scheduled property.
Oh, Mr. Counsel, you question, what have you
That I have
questioned?
not produced before this one. So we have given a
Possession
reply.
notice dated issued by the respondent and so and so.
Demand
it is
notice
back.
issued. Demand notice is 1/8/2024. In the meantime, ICICI Bank also issued a position notice, that is page 46, the same property.
You have taken the loan for the same property.
Your lordship, the first charge is, if at all they have declared as a first charge. So I will pay the amount and I will regularize. Because your lordship, if at all I have paid the amount, then the third respondent or fourth respondent is
Interim
claiming.
order is there in this? Interim order is there.
from 11 September 2024 enjoying the interim order, single fine is not paid, stalling the recovery.
That's my difficulty, Your Lordship. If I repaid the amount up to Your Lordship 8/2024, I have repaid the amount. When the
It is so
Bank
difficult to consider your submission. That's how you are making.
goes, Your Lordship, kindly go through the EC, Your Lordship.
My lord, you
The
have
same,
got-
very same bank has given
Matter on Tuesday.
kindly.
What is that?
Interim order.
Interim order, send it till then.
Kindly.
24,
No, I will call. No, I have a meeting, so I'll call the matters. Wherever there is urgency, please, 24.
24,
Appearing for petitioner, my lord.
Who appears to the respondent? You have filed the vacate petition?
I filed application for vacation.
Yes, list the matter on Tuesday.
yes.
Tuesday
Number-
is 18.
18.
Yes,
Cell
25.
number 25, Initiator Ramash.
25.
I appear for the petition.
What is this IA for extension of time?
Because this court, honorable court has ordered to pay 25% of the outstanding amount.
List the matter on 17th, 26.
26,
I
filed-
Huh? 18th, is 26.
26 on 18 minutes, I filed IA for vacating interim,
Yes,
24 crores loan.
18.
7,
Interim order may be extended. 26.
Wherever interim order, it will be extended. Yes, 27.
27,
Appearing for petitioner, Your Lord. I have deposited the money as per the interim order. I am meant to file the acknowledgement. Party is bringing the original receipt. I'll file it.
List this matter on 24th of November.
Interim order may be extended.
I told you, every interim order will be extended wherever there is.
28,
28.
I appear for the petition in this matter, my lord. There is an urgency. Kindly list the matter any day this week, my lord.
This week it is not possible. List this matter on 17th. Yes.
cell number 29,
Obliged.
I beg to appeal for petitioner in this case. Repeatedly, I am requesting this honorable court. I am ready to deposit the amount. My entire building is under lock because our belongings there inside. Because 14 order has been
This is
implemented.
matter at the top of the list on Monday.
cell
Yes,
number
30th.
30th, my lord, I beg to appear on behalf of respondent.
30.
30th.
Affidavit is ready, I'll file it in
My lord, it's a matter where, my lord, they're running a resort, where, my lord, I'm not able to conduct the
What happened to
valuation.
that?
My lord, within 15 days, my lord, we conduct the valuation.
Hmm.
My lord, they're filing an affidavit saying that, my lord, they need 3 days in advance notice, etc. Within 15 days, we'll carry out the, my lord, valuation, we'll produce
The
before this.
request is it should be on a weekday because they run a resort. Weekend, there'll be a lot of days. Any weekday.
That much you can
But it's-
accommodate.
We'll do it, my lord. Within 15 days, we'll carry out the, my lord, valuation of the report and
Yes,
after 15 days.
in 20, in 30, learn counsel for the respondent bank submits that. Within 15 days, they'll file a valuation report.
I know they have, my lord, it is a undertaken.
That's what the petitioner submits that. He has already filed in, take that.
Just have a copy to
The petitioner has filed an undertaking before this court. That he has no objection for the respondent to conduct valuation of item number 1 to 6 of the secured assets. But the valuer must be a well qualified and recognized by the respondent.
It is a systems. My lord, is own.
That's what he stated so. But he has to be a qualified valuer. It is also stated that the valuation may be conducted on any weekdays as they are running a resort. The same memo is, the affidavit of undertaking is taken on record. The respondent bank on any weekend, on the weekdays shall conduct the valuation and submit a report to this court by which date?
After 15 days, any day, my lord, date may be.
By 20, I'll take it up on 25th.
Grateful.
This is
Days
matter.
advance notice so that we don't take any
Ah.
case. 2 days advance.
25th, and in advance, the copy shall
I'll
be
inform the
served.
council, my lord. I may not. I'll inform the council.
Yes,
31,
it shall be informed to the
Interim order
council.
may be.
Interim order earlier granted is extended. Next,
31,
31. Hmm. 18.
cell number 32,
18th, this on 18th, top of the list, 31. Yes, 32?
Lordship, I appear for the respondent.
Yes.
this is an NPA in which I have asked for the modification of the order.
Because this also 18th on the turn after that.
Lordship
this
said the
also
next
the
date was given as 17th, that is why.
17.
Yeah.
Yes. Yes, 33.
33.
Mm-hmm. Yes, sir.
24.
That's this senior business piece. That is not the problem of the bank, that your senior is not available every time. 17.
Cell number 34.
Huh? 8. And both of you are not there, I will take it up on 19th.
24 sheet are there.
24.
Cell number 34.
Yes,
Today was
34.
the action in this, kindly that. Vignesh
Have it,
Shetty,
Milord.
sir.
Tomorrow, Milord, I'll take an instruction and make submissions.
Any
Today was
urgency in
the-
this?
Today was the action. Milord.
Yes, tomorrow, this matter tomorrow.
Cell number
But don't
35.
ask for tomorrow any other matters because this matter is accommodated. Tomorrow is MFA. Yes, 35.
35.
It is a matter wherein, Milord, after a period of 6 years, issuance of sale certificate.
Then no urgency on 17th, 18th, list on 24. 36.
Same, Milord.
Same. Yes, 37.
37. Kavita D.
This on 24th.
Cell number 30.
Milord, 38, Milord, for the petitioner. It is covered, Milord, 17.
17. 38 on 17. Yes.
39.
39, my lord, by the time my lord granted the interim order, the auction has taken place and it is confirmed. The only reason my lord granted the interim order was they said that we bought the property for 40 lakhs, but the bank is selling it for 20 lakhs. But this is the 5th time we are trying to sell it. And they themselves gave a letter that permitting.
17.
Please,
40. 40.
Order may be
40, 40, my lord.
All the matters it will be extended. Yes, 40.
40, I appear for the petitioner, my lord. They have filed a civil suit. They have filed a civil suit for recovery of the amount. Then earlier they have issued.
I remember this case that you wanted to clarify the legal position.
There is, they have not abandoned the earlier position.
The matter on.
Tomorrow or day after, my lord.
On 25th.
Short, very short question.
25th.
Cell number
41.
41.
For petitioners, my lord, it may be taken up tomorrow. The urgency is there, my lord. They have initiated surfacing proceedings and seized my residential property.
When was it seized?
My lord, on 8/7/2025.
So no urgency.
My lord,
This,
even my school
this
records.
is matter on, this
Day
all,
after tomorrow.
7, no day after tomorrow. I'm not taking up any matter. 17.
Number 42.
My lords, I'm for the petitioner in this case. My lords, there is no caveat, but my lords, I have already filed an essay before DRT, and in that essay, my lords, I have already deposited 75 lakhs. Even after which,
So and so is directed to take notice. List the matter on 17th. Next 43.
my lords, 17th on,
You copy.
yes, 17th on the top of the list, my lords, because it's a restaurant.
So
My
now
lords, they
this
will
is
take,
third top.
my lords, they'll take possession of the
The
property.
third top case.
Yes, my lord.
43.
Grateful, my lord.
Sought for mandamus.
43.
I have not sought for an interim order, it's a case for mandamus.
43.
I will be permitted to take out notice on the standing concern of Canara Bank.
Mr. Shetty is directed to, you also appear for Canara Bank. Yes.
Name
So and so is directed to, what is your name?
Nandish Patil.
So and so is directed to take notice on behalf of the, yes, next.
Cell number 44.
I appear for petitioner in this case. My lord. The urgency in this matter is, my lord, before the DRT, my lord, the sale and its consequential action has been challenged, my lord. The interim protection what we have asked for is, my lord, let them not, they have mentioned that they have issued a sale certificate. Sale certificate should not be registered. That's all, my lord, because I have a very good case on merits, my lord.
No order now. No order now. I'll take it up on 17th and pass.
Lord, Lord, 17th, my lord, I have an international event, my lord. Day after tomorrow, I'll be leaving out of country, my lord. 5 days I'll be out.
Let some counsel be here. Somebody should represent. So
Kindly have this matter tomorrow, my lord.
either we have the matter when you come back from abroad,
My lord.
or we will
Tomorrow,
take
my
up the matter.
Tomorrow, my lord.
Tomorrow, not.
My lord. My lord.
Yes,
My lord, then
I'll list it on Monday. You ask somebody to represent, or else you want some other day, I'll give.
extreme urgency is there, my lord. They are trying, auction purchaser is trying for registration. If registered, my lord, matter becomes infructuous.
By this time, it has become infructuous.
No.
because
Sale certificate
already-
is issued. Registration is not done, my lord. I'm only asking for protection order.
Ask the standing councils whether it is required or not registration. Yes, 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 next.
My lord,
It will
Monday.
come, list the matter on 24th, giving you the
My lord,
leisure you can
if
come.
19th, my lord,
19th, 19th,
please.
next. Not 19th, 18th, 24th or 25th.
18th I'll be, afternoon I'll be reaching, my lord. 19th.
Then we come on 24th. Yes, next 45.
My lord, let it be on 18th only, my lord.
18th.
In the afternoon, after the pending request, 3 o'clock, my lord. My lord, request, 3 o'clock.
In my court, there are no 3 o'clock, 2 o'clock matters. List has to go like that. If you want, pass on, you
18th,
can
my lord,
ask.
18th.
45.
Appearing for the petitioner in this matter, Your
I
Lordship.
appear for the respondent number 2, my lords, in this matter. This matter is actually infructuous, my lords, in light of the agreement entered. So, my lords may
It's only
on the 20.
454. Ask for the, like, just give the court officer the dates, whatever you want.
Seal number 61.
My lordship, I appear in 46, my lords.
GM rests and GM DRT, I will have to look at it. No, no, I'll look at it and do it.
Number ಕರೀತೀರಾ ಮೇಡಮ್?
Madam, 63 on date ಕೊಡಿ madam.
ಎಲ್ಲ ಕರೀತೀರಲ್ಲ?
ಸುಮ್ಮನೆ ಲೇಟ್ ಆಗುತ್ತೆ. ಹಾಕಿದ್ದಾರೆ.
ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ
ಸಾಹೇಬ್ರು ಎದ್ದು ಬಿಟ್ರೆ ಅಷ್ಟೇ ಬಿಡಿ. ಹೋಗಿ ಎರಡೇ
ಹೌದು.
ನಿಮ್ಗೆ ಹಾಕಿರೋದು ಹಾಕಿ ಕೋಟ ಮುಗ್ದೋಗ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲ ಯಾರು ಇಲ್ಲ
ನಮ್ಗೆ ಅಲ್ಲಿ ಕೋಟ ಸಿಗುತ್ತೆ. ಕರೆದು ಡೇಟ್ ಕೊಡ್ತಾ ಇರಿ. ಯಾವ್ದಾರ ಒಂದು ನಾವು ಅಲ್ಲಿ ಬರ್ತೀವಿ.
Petitioner agreement. Short date. Sir, okay. Sir, November ಅಲ್ವಾ?
ಈ ತಿಂಗಳೇ 17th ಅಂತಿದೆ.
18th petitioner long date.
Stay.
Interim order extension. 52 after vacation, madam. Madam, 52 objection file ಮಾಡಬೇಕು.
Madam, 49 date kodi. Hello.
ಮೇಡಮ್ 52 ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು ಮೇಡಮ್.
ಅದು ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಳ್ಳಿ, ನೆಕ್ಸ್ಟ್ ಕರೀರಿ, ಅದು ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಳ್ಳಿ.
ಮೇಡಮ್ 18 ಕೊಡಿ.
ಹಾ, ಬ್ಯಾಂಕ್ 25 ಕ್ರಿಸ್ಮಸ್, 25 ಕ್ರಿಸ್ಮಸ್, ಕ್ರಿಸ್ಮಸ್.
17th ಕೊಡಿ. 2 55 55.1 2 17
56 ರೆಸ್ಪಾಂಡೆಂಟ್.
Hello.
ಹದಿನೆಂಟು ಕೊಡಿ ಮೇಡಮ್.
ಅದು submission she dictated, it's not recorded in the order.
ಸರಿ.
ಹೌದು. 17th 2 ಇದಾವೆ ಅದು.
17 ನೋ ಮೇಡಮ್ 61 17 ಕೊಡಿ ಮೇಡಮ್, 61 17 ಕೊಡಿ ಮೇಡಮ್, 17 ಕೊಡಿ. ಅದರಲ್ಲಿ ಪ್ರಿಲಿಮಿನರಿ ಹಾಕ್ಬೋದಾ? ಅದು ಬಿ ಗ್ರೂಪಿಗೆ ಹೋಗ್ಬಿಟ್ಟಿದೆ, ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಸಿಕ್ಕಿಲ್ಲ ಇನ್ನು ನನಗೆ. ಲಾಸ್ಟ್ ಡೇಟ್ ಬಂದವ್ರಿಗೆ ಟೇಕ್ ನೋಟಿಸ್ ಮಾಡಿದ್ರೆ ಅಷ್ಟೇ.
ಮೇಡಮ್ 17 ದಯವಿಟ್ಟು ಪ್ರಿಲಿಮಿನರಿ ಹಾಕ್ಬೋದಾ ಮೇಡಮ್? ಮೇಡಮ್ ಬರೀ ಟೇಕ್ ನೋಟಿಸ್ ನೆನ್ನೆ ಆಗಿದೆ.
63 ಪಾರ್ಟ್ 2
ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು. 64
66 17th ಆಯ್ತು, ಎನಿ ಡೇ ಆಗ್ಬೋದು.
ಮೇಡಮ್ 51 ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದೀರಾ? 1 ಹಾ ಎಂಟ್ರಿ ಮಾಡಿದೆ ಮೇಡಮ್. 49 ಮೇಡಮ್ ಎಂಟ್ರಿ 49 ಮೇಡಮ್. ಹಾ
1811
ನೆಕ್ಸ್ಟ್ ಇಯರ್ 1811 ಓಕೆ ಮೇಡಮ್.
49 1711
52
1711 ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ನೆಕ್ಸ್ಟ್ ಇನ್ಯಾವ್ದು ಹೇಳಿ? 52 2511
ಮೇಡಮ್ 51 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿರೋದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
ಸರ್ ಎಲ್ಲ ಮಾಡ್ತಾರೆ, ಅವ್ರು ನೋಡ್ತಾರೆ.
ಸಾರಿ ಮೇಡಮ್, ಸಾರಿ. ಸರ್ ನಿನ್ನೆ ನನ್ನ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ My submission is recorded that entire amount will be paid anta. She dictated the order, but ಆ order ಅಲ್ಲಿ reflect ಆಗಿಲ್ಲ. See, WP 33651 serial number 34 ನೆನ್ನೆ ಇತ್ತು ಸರ್. ಸಾರಿ ನೆನ್ನೆ ಇತ್ತು ಮೇಡಮ್. ಇಲ್ಲಿ ಬರೀ ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಇದೆ. ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಇಟ್ಸ್ serial number 34 ಇರಬೇಕು ಸರ್. ಸಾರಿ ಆಗಿದ್ಯಾ? ಆನ್ಲೈನ್ ಆಗಿಲ್ಲ ಮೇಡಮ್ ನೋಡಿ, ದಯವಿಟ್ಟು ಮೇಡಮ್. ಶೋರ ಮೇಡಮ್. ಓಕೆ, ಬಿಕಾಸ್ ಇಲ್ಲೂ ಈ ಕೋರ್ಟ್ಸ್ ಅಲ್ಲೂ ಹಿಂಗಿದೆ ಅಂಡ್ ಆನ್ಲೈನ್ ಆರ್ಡರ್ ಶೀಟ್ ಆನ್ಲೈನ್ ಅಲ್ಲೂ ಹಂಗೆ ಇದೆ. Serial number 62 ಇವತ್ತು. ರೆಕಾರ್ಡ್ ಆಗಿದೆ ಬಿಕಾಸ್ ಆನ್ಲೈನ್ ಈ ಕೋರ್ಸ್ ಅಲ್ಲೂ ಹಂಗೆ ಇದೆ ಅಂಡ್ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ವೆಬ್ಸೈಟ್ ಅಲ್ಲೂ ಹಂಗೆ ಇದೆ. ಮೇಡಮ್
ನೀವು ಅದನ್ನ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರೆ ಕೈ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ, ನಿಮ್ಮಲ್ಲೇ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ. ಸೊ ಈಗ ನಾಳೆ ಇಷ್ಟ ಆದ್ರೆ ನೀವೇ ಬಂದು ಆನ್ಸರ್ ಮಾಡಬೇಕು. ನಾಳೆ ಕರೆಕ್ಟ್ ನಿಮ್ಮನ್ನೇ ಕರೆಯುತ್ತೀನಿ. ಬ್ರಾಂಚ್ ಆಫ್ ದ ಯಾರ್ ಕನ್ಸಲ್ಟ್ ಕೇಸ್ ಅಂತ ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಹೇಳಿ ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಅದು ಒಂದು ಡೇಟ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್ ಇದೆ. ಅದ್ರಲ್ಲಿ ಹೋಗಿ ಹೇಳ್ಬಿಟ್ಟು ಮಾಡ್ಕೊಡ್ತೀನಿ. ಯಾಕೆ ಅಂದ್ರೆ ನಾನು ಹೇಳ್ತೀನಿ ಮೇಡಮ್, ನಮ್ಮ
ಮೇಡಮ್ ಲಾಸ್ಟ್ 7/11ಗೆ ಮೇಡಮ್ ಮುಂದೆ ಬೀಯಿಂಗ್ ಸ್ಪೋಕಿಂಗ್ ಮೆಮೊ ಕೊಟ್ಟಿದ್ವಿ, ಅದು ಏನು ಹೋಗ್ಲೇ ಇಲ್ಲ ಮೇಡಮ್. 26 ಇದೆ ಹಾ ಮೇಡಮ್. 2 ಸಲ ಮಾಡಿದ್ದಾರೆ, 2 ಸಲಿನೂ ಫೈಲಿಗೆ ಹೋಗಿಲ್ಲ ಅದು ಮೆಮೊ. ಮೊನ್ನೆ ಒಂದ್ಸಲ ಮೇಡಮ್ 7/11 ಮೇಡಮ್.
ಅವರು ಏನಾದ್ರು this matter on Monday ಇತ್ತು. ಅದೇ ಅವರು ಇದು ಹೇಳಿದ್ರಲ್ಲ, ಅದೇನೋ ಅವರು ಇದು ಮಾಡೋ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾರಲ್ಲ, ಹೀಗಾಗಿ madam this matter Monday ಇರುತ್ತೆ, ನೀವು ಆಡಿಯೋ ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳ್ಕೊಡಿ. ಏನಾದ್ರು 18 ಅಂತ ಇದ್ರೆ ಮತ್ತೆ change ಮಾಡ್ತೀರಾ ಆಮೇಲೆ ನೋಡು ನೀ ಕೇಳಿಸ್ಕೊ ಆಡಿಯೋ ಕೇಳಿಸ್ಕೊಂಡು ಅದ್ರಲ್ಲಿ 18 ಅಂದ್ರೆ 18 ಮಾಡು. ನೀವು ಸುಮ್ಮನೆ ಬ್ಲಾಂಕ್ ಅಟೆಂಡ್ ಮಾಡಿದ್ರೆ ಕೇಳ್ಕೊಬೇಡಿ, ಅವರು ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ರೆ ಅದೇನೆ. ಅಲ್ಲಲ್ಲ ನೀವು ಫಸ್ಟ್ 18 ಅಂತ ಡೇಟ್ ಎಲ್ಲ ಮಾಡಿಫೈ ಮಾಡಕ್ಕಾಗಲ್ಲ, ನೀವು ಡೇಟೇ ಕೊಟ್ಬೇಡಿ, ಸಿಂಪ್ಲಿ ಅಡ್ಜರ್ನಿಂಗ್ ನಾಳೆ ಡೇಟ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿ. ನಿಮ್ಗೆ ಏನಾದ್ರೆ ಅರ್ಥ ಆಗಲ್ಲ ಸರ್, ಅವರು ನೋಡ್ಕೊಂಡಿರ್ತಾರೆ ಅದರ್ ಸೈಡ್ ಅವರು 18 ಕಿತ್ತು 17 ಕೊಟ್ಟಿದ್ದೀರಾ ಮತ್ತೆ ಮಾಡಿಫೈ ಮಾಡಿದ್ದೀರಾ ಹಂಗೆಲ್ಲ ವರ್ಷನ್ ತಗೊಂಡು ಬರ್ತಾರೆ. ಅದಕ್ಕೆ ನೀವು ಮಾತಾಡೋದು ಅವಾಯ್ಡ್ ಇಟ್ ಡೋಂಟ್ ಗಿವ್ ದ ಡೇಟ್ಸ್ ಟಿಲ್ ಇಟ್ ಇಸ್ ಕನ್ಫರ್ಮ್. ಧಾರವಾಡದಲ್ಲಿ ಹಿಂಗೆ ಇದೆ, ಹಿಂದಿನ ದಿನ ಬಂದು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದು ನಾಳೆಗೆ ರೆಪೋಸ್ ಮಾಡಿ ಕಾಪಿ ಎತ್ಕೊಂಡು ಬಂದ್ಬಿಟ್ಟು ಅಡ್ವೊಕೇಟ್ ನೋಡಿ ಆಮೇಲೆ ಮಾಡಿಫೈ ಆಗಿದೆ ಯಾವುದು ಡೇಟ್ ಕೊಡ್ಬೇಡಿ, ಅರ್ಜೆಂಟ್ ಮಾಡಿ ಡೇಟ್ ಗೊತ್ತಾಗಲ್ಲ, ನಾಳೆ ಡೇಟ್ ಹಾಕಿ.
ಅದೇ ನಾನು ಬೇಸ್ ಸ್ಪೋಕನ್
ನಮಗೆಲ್ಲ ಅಂದ್ರಲ್ಲ
ಅವರು ಹೇಳಿದ್ರೆ
ನೀವು ಮಾಡ್ಬಿಡಿ, ಕೊಡ್ತೀವಿ ಅದನ್ನ ಅದು ಹೋಲ್ಡ್ ಮಾಡಿದ್ದೀವಿ ಕೊಡ್ತೀವಿ. ನೀವು ಮೂವ್ ಮಾಡಿ ಸರ್, ನಾಳೆ
ಸರಿ.
ಬಂದಿದ್ದೀನಿ ನನ್ನ ಕಾಪಿ ನೋಡ 32 ಕಾಪಿ ಎಲ್ಲ ಕೂಡ ಯಾವುದು 32 ನಾ ಆನ್ಲೈನ್ ಆಫರ್ ಇಷ್ಟಾ 32 ನಾ ಅದೇ 11 ಮೇಡಮ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ ಮೆಮೊರನ್ನ ಇರೋದಕ್ಕೆ ಸದ್ಯ ಅದೇನ ಏನ್ ಮಾಡಕ್ಕೆ ನಾಳೆ ಹೋಗ್ತಾರಲ್ಲ ಓಕೆ ಮತ್ತೇನು ಇದೆ ಅವ್ರ ಬ್ರಾಂಚ್ ಹೋಗಿ ಹೇಳಿದ್ದೀನಿ ಕರೆಕ್ಟ್ ಇರೋದನ್ನ ಆನ್ಸರ್ ಮಾಡಿ ಆಯ್ತಾಯ್ತು. ಹೇಳಿ ಸರ್. ಹಾ ಹಾ ಇಲ್ಲ ಇಲ್ಲ ಹಂಗ ಅಷ್ಟು ಲಾಂಗ್ ಡೇಟ್ ಕೊಡೋದು ನಮ್ಮ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ ಸರ್. ನೋ 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 24/5 ಅದೇ 24 or 25 ಅಲ್ಲ ಸರ್ 18 ಅಲ್ಲ ಈಗ ಯಾವ ಡೇಟ್ ಇದೆ ನೋಡಿ 26 ಮೇಡಮ್ ಕೊಟ್ಟಿರೋದು ನಾವು ಅದನ್ನ ಆರ್ಡರ್ ಮಾಡ್ತಿದ್ದಲ್ಲ ಇಟ್ ಈಸ್ ಡಿಕ್ಟೇಟೆಡ್ ಬೈ ಕೋರ್ಟ್. ಅವತ್ತು ಬಂದು ನೀವೇ ಬಂದು ಅಟೆಂಡೆನ್ಸ್ ತಗೊಂಡಿದ್ದೀರಿ ಯಾಕಂದ್ರೆ ಮೇಡಮ್ ಡಿಕ್ಟೇಷನ್ ಆಗಿರೋದ್ನ ವಿ ಕಾಂಟ್ ಆರ್ಡರ್ ಇಟ್ ಬಿಕಾಸ್ ಡಿಕ್ಟೇಷನ್ ಇಲ್ಲ ಅದೇ ಗೊತ್ತಾಯ್ತು. ಇವಾಗ ಈಗ ಏನಿಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವತ್ತು ಬಂದ್ಬಿಟ್ಟು ನೀವು ಬೇಕಾದ್ರೆ ಹೇಳಿಲ್ಲ ಓಕೆ ಅದು ಡಿಕ್ಟೇಟೆಡ್ ಬೈ ಕೋರ್ಟ್ ಸರ್, ನಾಟ್ ಗಿವನ್ ಬೈ ನೋ 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 ನಾಟ್ ಗಿವನ್ ಬೈ ಮೀ ಅದು ಅದಕ್ಕೆ ನೋಡ್ದೆ ನಾನು. ಹಾ ಆಯ್ತು ಓಕೆ ಡಿಕ್ಟೇಟೆಡ್ ಓಕೆ ಸರ್ ಅದು ನಮ್ಮ ಆಪ್ಷನ್ ಇದ್ದಾಗ ಐ ಕ್ಯಾನ್ ಗಿವ್ ಇಟ್ ಬಟ್ ಈ ಆಪ್ಷನ್ ಈಸ್ ನಾಟ್ ಡಿಕ್ಟೇಟೆಡ್. ಓಕೆ ಸರ್ ತಗೊಳ್ಳಿ ಅದು ಇಂಟರ್ನೆಟ್ ಇದೆ ಮೇಡಮ್ ಕ್ಲಿಯರ್ ಮಾಡ್ತಾರೆ ಇದು ಇದೆಲ್ಲ ಬರ್ತದೆ ಇನ್ನೊಂದು ಯಾವ ಡೇಟ್ ಇದೆ ಅಂತಲ್ಲ ಸರ್? ಅದು ಏನಾಗಿದೆ ನೋಡಿ ರಿಪೀಟ್ ಕೊಡೋದಾ ಅಥವಾ ಅಲಾರ್ಮಿಂದ ನೀವು ಹೋಗ್ಬೇಕು. ಯಾವ ಬ್ರಾಂಚ್ ಇದು? ಅದಕ್ಕಾಗಿ ಕೇಳ್ಬಿಟ್ಟು ಫೋನ್ ಮಾಡಪ್ಪ. ನನಗೆ ಮಂಡೇ ಆಯ್ತು ಆಮೇಲೆ ನಾನು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಕೇಳ್ಸ್ಕೊಂಡಿದ್ದೆ. ಹೌದೌದು ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಆಗ್ತದೆ. ಅಮ್ಮ ಇಲ್ಲ ಆಮೇಲೆ